ಪ್ರಶ್ನೆ
ಎರಡು ಸಲ ಮೆನ್ಷನ್ ಮಾಡಿದೆ ಅವತ್ತು ಫ್ರೈಡೆ ಬಂದಿಲ್ಲ, ಇವತ್ತು ಬಂದಿಲ್ಲ. ಅಷ್ಟೇ, ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲ, ನಾಳೆ
ಅದು ಎಲೆಕ್ಷನ್ ಡಿಕ್ಲೇರ್ ಆಗಿದೆ. ನಾಮಿನೇಷನ್ CS ವೆಡ್ನೆಸ್ಡೇ ಬರುತ್ತಲ್ಲ. ಸೊ ಮತ್ತೆ ಮೂವ್ ಮಾಡೋದ್ ಬೇಡ.
ಅಲ್ಲ, ನಾನು ಯಾಕೆ ಹೇಳ್ತಿದ್ದೀನಿ, 2 ಸಲ ಮೂವ್ ಮಾಡಿದ್ದೀನಿ, ನಿಮ್ಗೂ ಗೊತ್ತಿದೆ. ನಾನೇ ಫಾಲೋ ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದೀನಿ. ಅದ್ ಹೆಂಗ ಮತ್ತೆ ಅವ್ರ ಕೆಲ್ಸ ಏನ್ ಮಾಡ್ತಾರೆ ಅವರು? ಅಲ್ಲ, ನೀವು ನೆನಪು ಮಾಡೋದಾದ್ರೆ ಮತ್ತೆ ಅವ್ರ ಕೆಲ್ಸ ಅವ್ರ ಏನ್ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂತ ನೋಡಲ್ಲ. ಒಂದೊಂದ್ ಸಬ್ಜೆಕ್ಟ್ ನಾವು ಅಲ್ಲಿ ಪೆಂಡಿಂಗು ಬ್ರಾಂಚ್
ನಾಳೆ ಮೇಡಮ್, ನಾಳೆ ಆಕ್ಚುಲಿ ಫ್ರೆಶ್ ಮಾಡಿ ಫ್ರೆಶ್ ಮಾಡಿ ಅದು ನಂಬರ್ ಆಗಿದೆ, ಗೊತ್ತಿಲ್ವಾ?
ಮೇಡಮ್, ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಕೇಳ್ತೀನಿ.
ನಂಬರ್ ಆಗಿದೆ.
ನನಗೆ ನಾಳೆ ಸಿಕ್ಕಿದ್ರು ಬಟ್ ಅವರು ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಅವರು ಬೇರೆ ಊರಲ್ಲಿದ್ದಾರೆ. ಬಟ್ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೋಬೇಕು, ಅಲ್ಲಿ ಡೇಟ್ ಡಿಸೆಂಬರ್ ಲಿಸ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ಇದು 4 years ರಿವ್ಯೂ ಪಿಟಿಷನ್. ಶಾಕಿಂಗ್. ಟೆಂಟೇಟಿವ್ ಡೇಟ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ. ನನಗೆ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸಿಂಗ್ ಎಲ್ಲ ಮಾಡ್ಬೋದು. ದೇ ಆರ್ ಸೀಸ್ಡ್ ಆಫ್ ದ ಮ್ಯಾಟರ್.
Serial of call list 2, madam. Serial number 9. Call list. Phase 2 of cause list 2. Cause list 2. Second call. Phase 2 alle barutte. Okay, thank you.
List one.
ಟೆನ್ ತರ್ಟಿಗೆ ಬರ್ತಾವ ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗುತ್ತೆ ಮ್ಯಾಮ್. ಬರ್ತೀನಿ ಮ್ಯಾಮ್ ನಿಮಗೆ. ಗೊತ್ತು ಒಂದ್ಸತಿ ಅಲ್ಲಿ ಹೋಗ್ತಾರೆ, ಒಂದ್ಸತಿ ಇಲ್ಲಿ ಕೂತ್ಕೊಳ್ಳೋ VC ಮಾಡ್ಬೋದಲ್ಲ, ಎಲ್ಲರೂ ಚೀಫ್ ಮಿನಿಸ್ಟರ್ಸ್ ಹೋಗ್ತೀನಿ ನಾನು. ನಾಟ್ ನೆಸರಿ, ಇಲ್ಲಿ ಕೇಳೋಣ ಫಸ್ಟ್ ಅದ್ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತ. ಇಲ್ಲ VC ಅಲ್ಲಿ ಮಾಡ್ಬೋದು, ಏನಿಲ್ಲ. ಅಲ್ಲ ನಮ್ಗೆ ಯಾರ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಅವರು ಇದು ಸೆಕ್ಷನ್ ಆಫೀಸರ್ ಹೇಳಿದ್ದು ಟ್ರೈ ಮಾಡಿ ನೋಡಿ. ಇವ್ರು ಜೂನಿಯರ್ ಜಡ್ಜು, ಅವ್ರು ಸೀನಿಯರ್ ಜಡ್ಜು. ಇವ್ರು ಧಾರವಾಡ ಹೋದಾಗ ಅವ್ರು ಇಲ್ಲಿ ಬರ್ತಾರೆ. ಆಮೇಲೆ ಮುಂದಿನ ವರ್ಷ ಹೋಗುತ್ತೆ, ಇವ್ರು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ತಾರೆ, ಇನ್ನೊಂದು ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಆಗುತ್ತೆ, ಮೂರನೇ ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಇದು.
Adjournment is mentioned page wise.
ನೋಡ್ತಾ ಇದ್ದಾರೆ.
And is to prove. Can you sort out?
Lord, the review petition is pending for 4 years. Review petition is pending for 4 years. The case was last heard earlier this month. However, it's been posted to December 2023. So I request this be heard
Matter.
in a review petition in relation to the special bench, which you are a part.
It's a bench matter. That's a bench matter.
Special bench matter. I realize this is a junior court, but the difficulty I am facing is it's in the 4th year. It's shocking that it's gone to the 4th year. The review petition, when it should ought to have been heard despite a change of benches. Now, if it can be done by weekly,
There are 4 benches which have got changed.
it can be done by
We'll see what is to be done.
kindly, my lord. Because it's also important. My case is important just as much as anybody else's. And
But the bench has to be constituted for that. That's the problem.
it has been constituted. It's just that it's, one person is sitting, one
Now the members of the bench is not sitting in Bangalore.
solution is there.
We have to see. We will see what.
Number 1, date number 7, serial number 45 to 49. Date number 8, serial number 50 to 57.
Your Lordship,
Kindly, my lord.
serial number 50 on behalf of the
Sale
respondent.
number?
50,
Yes.
behalf of the respondent side, please. I've informed the other side.
We inform the petitioner.
Yes, sir.
What do you want time? Who are you appearing for now?
For respondents 2 to 4,
Who is the council appearing?
Mr. S.H. Prashant.
SH Prashant. SH Prashant has entered appearance for respond number 2 to 4. Delete SN Prashant Chandra and Subramanya R. As that are appearing for respond number 2 to 4. At the request of council for respond number 2 to 4, relist on
Your Lordship, pray for 2 weeks.
17th April.
With the lordship's kind leave, my lord, serial number 51, my lords. I appear for
Yes.
petitioners in this matter, my lord. My lord, pray for a week's time, my lord. We need to file a state synopsis and list of authorities and go ahead with the arguments. We need to prepare, need some time to prepare the matter, please.
Have we informed the respondent?
I appear for the respondent.
Not file ಮಾಡಿದೀರಾ?
ನಮ್ದೆಲ್ಲ ಆಗಿದೆ.
ಆಗಿದೆಯಾ?
Long back that we have filed the statement of objection.
51 Bennett
Lord, it was particularly specifically fixed for this day.
submits that he has filed a synopsis of dates and events as also list of authorities. Counsel for the petitioner seeks for and is granted 1 week's time finally to do the
Please,
relist on 5th April. It is made clear that no further time would be granted.
please, my lords. Highly obliged.
Serial number 9, my lord. Raise for 2 weeks.
What is being called out?
Date number 9, serial number 58 to 54. Date 10, serial number 58.
My lord, serial number 47, my lord, list 2.
Date number 11, serial number 69 to 76. Date number 12, serial number 7.
My lordship,
Yes,
serial number 69 you are on.
58,
69,
69.
69 you are. Only 3 days dates I want.
ನೀವು ಯಾರಿಗೆ?
From the other side.
Mr. Tilak, your name is not found in 69.
Yogesh Suguna Bai, Mamta Kulakandi, Mamta Kulakandi.
Mamta Kulkarni. Have you informed the other councils?
No, my lord, I want only 3 days.
Then please wait.
Really, last
If you
date
are-
appearing, they mentioned 30th.
If you are not informed, please wait. Please wait. Don't mention matters without informing.
Okay.
Date number 13, serial number 86, 93.
Number 91 minute.
Yes,
It
madam.
will be not a time locality, it may be moved to 4th minute.
ಅವ್ರು ವಕಾಲತ್ ಹಾಕೋದ್ ಬೇಡ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರಂತೆ. ನಿಮಗ್ ಟೈಮ್ ಬೇಕು ಅಂತ ಹೇಳಿ. Other 91 at the request of the council for the petitioner relist on 5th. 4th Raja, sorry, 6th. 7th Raja ಇದೆ, 4th Raja ಇದೆ. ಅವೆರಡು ದಿನಾನು ಆಗಲ್ಲ.
Page number 14, serial number 94 and 95.
Serial number 94, Andhra card advocate is out of station. Shivaram, next week.
ಸೋಮಯಾಜಿ ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ?
I will inform you. No, it's sir.
ಬೇಡ, ಎಷ್ಟು ಸತಿ ಹೇಳೋದು ನೀವು? ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ, then mention. Before at the request of council for the petition released on 10th.
99, madam.
99.
Okay, 30. I've informed other side, no problem was, madam. ASD appears in that. Yes, got some difficulty today, madam. On 10th.
At your request, this date was fixed.
ಹೌದು, ಅಂದ್ರೆ ಅವರಿಗೆ ಸದರ್ನ್ ರೀಜನ್ ಆಗಿ ಸ್ವಲ್ಪ ಇವತ್ತು ಸ್ವಲ್ಪ ಡಿಶ್ 10th ನಾನು ಸೀರಿಯಸ್ ಮೇಲೆ
ಬೇರೆ ರೆಸ್ಪಾಂಡ್ ಕೌನ್ಸಿಲ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ
ಅವ್ರಿಗೆ ಮಾಡಿದ್ವಿ,
ಎಲ್ಲರಿಗೂ ಮಾಡಿದ್ರು. ಯಾವ ಡೇಟ್?
10th ಮೇಲೆ
99.
ಆ ದಿವಸ ಮಾಡಿದ್ವಿ.
Submit.
Sorry,
The learned additional Solicitor General is otherwise busy. And if the matter is posted on 10th, if you would address arguments, it's made clear that no further adjournment will be granted. We list on 10th.
Yes.
Page 2, serial number 11.
Serial number 11.
Yes.
11 to 13 connected ಮಾಡಿ. Only 1 week time.
ಎಲ್ಲ connected.
Connected.
11, 12, 13 connect.
Serial number 9.
ಏನಾಗಬೇಕು? What do you want?
Regular council not filling.
Who is appearing for respondent now?
Respondent number 2 to 4.
ಯಾರು?
CT Parmeshwarappa.
CT notes your color file. The CT Parmeshwarappa has entered appeals for respondent number 2 to 4. Delete Tikku Venkateshaya and let Devendra file that appearing for respondent number 2 to 4. CT Parmeshwar ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ?
Inform.
ಯಾವತ್ತು ಬೇಕು?
First week.
At the request of the council for the petitioner, we list on 6th.
Thank you.
It is made clear that no further adjournment will be granted if arguments are not advised. The matter will be discussed on our part.
Serial number 9. Filing
Number?
9.
9.
For case Devraj IS there. I'm filing a withdrawal memo, my lords. The petition stands infructuous. I have vacated the premises.
Devendra has entered appearance for respond 2 and 3. Delete name of Shri Kempanna as that for respond number 2 and 3. Counsel for the petitioner has filed a memo dated 27/3/2023 signed by the council seeking for withdrawal of the above matter, accepting the submission of street
Govind Paranam.
also and the memo. The petition is dismissed as withdrawn.
Serial number 6, my lords.
And
today I'm filing wakalat in the registry. Lords may take this matter in next week.
filing wakalat for whom?
For petitioner. The name of the petitioner for reflecting the cause.
Responded.
You are appearing for?
The BBMP.
Shri S.N. Prashant Chandra has entered appearance for R2 and R3. Delete the name of Shri R. Ramchandran as that appearance for R2 and 3. Shri Sarvana submits that you will be filing Wakalatnama during the course of the day. Released on 6th April.
Okay.
Serial number 4, petition has become infructuous. A Gram Panchayat election, subsequent election agogudi.
The Arun BM Learned Council for the petitioner submits that the elections which the subject matter and the election which are subject matter of the petition have been held, rendering the above petition infructuous. Accepting the submission, the petition is dismissed as infructuous.
Please.
Serial number 15, my lord.
Yes.
Serial number 15, list number 2, my lord.
Really?
Is really, I have to file some maps and documents, my lord. They have not filed their objections. I seek for a week's time, my lord.
Then AGA is directed to accept notice for respond number 7. Counsel for the petitioner seeks for a week's time to produce certain maps.
Maps
what do you want to?
Documents, my lord. Regarding
documents. Released on 6th April.
Much obliged.
Page number 3, serial number 14, serial 17. Page number 4, serial number 18 to 24.
My lords, serial number 20, my lords. Appear for the petitioner. My lords, 2 to 4, my lords.
The Pawan Kumar is directed to accept notice for respond number 2 to 4.
And serve.
He is directed to print his name as such. Council to furnish one more set of petition along with annexes. On the said council, delete the name of Srinidhi V as that appearing for respond number 2 and 4. Relist on 13th April.
Great.
19, ma'am.
19.
Yes, ma'am. One week time. Some instructions.
At the request, New Year again.
Please, sir.
At the request of the council for the petition, relist on 10th April, it is made clear that no further adjournment will be granted. Not advance, petition will be liable to be dismissed.
Case number 5, serial number 25.
My lords, serial number 26, I represent the petitioner here. I need an accommodation till 6th April, my lord.
Have we informed the respondent?
I've done that.
26, the request of council for the petitioner, read on 6th.
Obliged.
Arguments are not advanced.
Serial number 28, my lord, I was permitted to withdraw.
28 of list 2, first list.
WP 17515.
Council for the petitioner is filed in 27/3/2023, signed by the council for the petitioner. The petitioner in the said memo seeks permission to withdraw the above petition, accepting the submission of Shri so and so, and the memo, the petition is dismissed at withdrawn.
Serial number 40 and first list. 40.
40.
Withdraw the request. Some instructions.
Preliminary hearing allo.
General body meeting take some other held ಆಗಿತ್ತು.
Council for the petitioner has filed a memo dated 27/3/2023, signed by the council for the petition, seeking permission to withdraw the above matter, accepting the submission of Shrikant NV and the memo, the petition dismissed as withdrawn. Pending IAS time.
Number 1, order serial number 1, CM Yadav.
ಯಾರಿಗೆ ಸರ್ ಮಾಡಿಲ್ಲ?
Yes, Murali, I will serve ಮಾಡಿ.
Yes, Mr. Murali.
Lord, copy is received, my lord. I have received the copy.
You would be appearing.
Yes, my lord. My name may be shown, but I will have the papers are returned back, my lord, after the disposal. I'll have to secure the papers, my lord, from the party.
You are appearing for which respondent? The first respondent only.
First respondent only, my lord.
The others are all dispensed with.
Yes, my lord. In the CRP itself, my lord, it was dispensed with.
DS Murali confirmed receipt of copy of the petition along with annexes. He submits that he would be filing his wakalatnama given a week's time. He seeks for and is granted 2 weeks' time to get ready and address his arguments. Relist on 13th April.
One request, my lord. Lord,
Yes.
the party, my lord, is not in country. He has gone abroad. It may
When
take.
is he getting back?
He says, my lord, after 1 month, my lord. Can I request after vacations, my lord?
Relist on 29th May.
Obliged. Deeply obliged.
Serial number 2, CN Ananthanarayana.
Undertaken to remove the third floor, unauthorized third floor of the building, my lord. They had taken time to remove.
ಏನಾಗಿದೆ ಡೆಮಾಲಿಷ್ ಮಾಡಿದ
Not yet removed. Order passed by the KAT has been questioned.
ಪಾಸು
Please.
ಅವ್ರು ಡೆಮಾಲಿಷ್ ಮಾಡಿ ನೀಟಾಗಿ ಇನ್ನ ನೀವು ಖರ್ಚು ಮಾಡ್ತೀರಾ ಅದು.
Serial number 3, Vivek Kola.
R2
For the petitioner, for a week's time, my lord, to file the application to bring the LRs on record.
already abated,
My lord, on 8th of February, the death of the deceased was
reported.
8th of February, your lordship.
And council petitioner seeks for and is granted
Only a week's time, my lord.
2 weeks' time to file necessary application to bring the legal representative deceased respond number 2 on record. Relist on 13th.
Great.
Serial number 4, SP Srinivas.
Lords, I appear for the petitioner. I received the wakalat on Saturday. It will be filed in the course of the day.
Still, Shri Bharat Muralidhar submit that he has received Wakalatnama and he will be filing it during the course of the day. He seeks for and is granted a week's time to get ready and address his arguments. Relist on 10th.
Serial number 5, B.D. Sukumar.
Time. Where the process fee. Process number 9 and 10.
Courses fee you can't pay.
Vitamin. Most of it.
You pay it now and come pass over.
It's okay.
Serial number 6,
Waiting for petition.
Petition.
Raise time for 1 week, my lord.
What is the objection? Counsel for the petition seeks for and is granted 10 days time to comply with the office objection released on 11th April.
serial number 7, V.R. Sundaresha.
I have to serve the copy of the amended petition to the respondent. I'll comply with that, please.
On amendment. Amendment madila.
House, ಇನ್ನೊಂದು connected matter. First matter ನಾನು
ಸೋಮಶೇಖರಯ್ಯ. First matter ನೀವು ಕಾಪಿ ಕೊಡಬೇಕು.
copy, sir, I'll do that.
ಕೊಡಕ್ ಮುಂಚೆ ಕೌಂಟ್ ರೆಡಿ. That is efficiency. Where is Mr. Shom? He'll pass over. Let us get the amendment carried out. We'll give you time. Somshekar ಅವರು ಬಂದ amendment ಮಾಡ್ತಾರೆ.
Great.
Serial number 8.
Here for the respondent. I was directed to file a report.
We served it. Have you served a copy?
Your Honor, this case has already been examined by the High Court in 3766 writ appeal of 1998, and the report is available already. I don't know what it is.
It's been examined in writ appeal.
Yes. The entire stretch of the road was ordered by the High Court to be examined by an executive engineer and an assistant engineer.
Please
And the
see
report
the
was filed by them and is already in the record.
Lord, please, I'm sorry to interrupt, my lord. Please see the order dated 25/1/2023, my lord.
25?
25/1/2023. Lord, sir, this honorable court, my lords, took note of the fact, my lords, that
Your Honor, even that time I wanted to bring out this information, but they did not hear me.
Where you said that it's already been
It's
examined.
already been examined in the writ
Is a
appeal
copy of the order.
Huh?
We have the copy of the order.
No, I've got the copy here. It was detailed, it was examined in detail, and based on this thing, the writ appeal decision was made by the High Court that the road can be made.
3766 of 1998.
3766, my lord, is a public interest litigation, wherein, my lords, the BBMP was not a party. My lords, this honorable court took note of the fact, my lords, on the last hearing date. My lords directed me to find out, my lords, whether any excess, my lord, the land abutting the road is available for.
There is some office note which has been given.
Yes.
No, no.
The order passed in this. What is the order passed in 376?
Based on this one, it was
766, my lord.
filed in the 3766, the detailed report, the High Court had asked for it. And
the general.
Lords,
This
your
is
lordship.
the order passed by this court.
Please, my lord,
We need to
annexure
see an order of
the judgment has been issued for
Annexure
making.
E.
We need to see that.
Annexure E to
There's a
the,
judgment issued, you know that.
annexure E to the writ petition.
And if you give a command has been issued, it has to be circulated, right? It has to flow down the, so if we see the order, then only we'll know what that order is.
Annexure E to
There's a
the,
judgment passed, but what is the judgment?
annexure E to the writ petition.
Annexure E
3766 writ appeal,
Annexure E.
High Court gave the
Lords, Page
decision.
number 32, my lord.
32.
Lords, that was a review petition. Lords, the,
Where is the order in WP 3766?
Lords, the,
So the review in 3766.
Lord, your lordship could get it at annexure C, my lord, page 22.
Page 26. 26 is WP 10172.
Annexure C, my lord.
3766.
Please. I would respectfully submit, my lord, your lordships may kindly see the array of the parties. My lord, the next page, my lord. The BDA is a party, Respondent number 2 and one Mr. Rajendra Kumar Ranka is the respondent number 1. The BBMP was not a party to this writ appeal.
They were found by the BDA, Mr. Aladi.
Please.
They should have handed it over to you.
Yes.
What happened after this?
Based on that order,
BDA
Your Honor,
It will come to you.
BDA was aggrieved by this order, so there was a direction to the BDA. Lords, BDA filed a review petition before this honorable Lords, which is at annexed email.
that was dismissed.
Page 32. Lords, the operative portion is at page 34, para 4.
Review was filed by the BDA.
Please.
You were directed to pass orders.
I'm for the BBMP.
Yes.
It was not a party.
Corporation was
Please.
to approach the corporation authority who will consider each case and pass necessary orders in accordance with law.
According to law.
What have you done on that?
Oh, my lords, the last occasion, my lords, when this matter came up before this honorable court, my lords, this honorable court took note of the fact that, my lords, there is a 15 feet of road which is already in existence. My lord, there are houses abutting, my lords, on either side of the 15 feet road, my lord. My lord, the petitioner made a submission that there is excess land available on either side of the road, and therefore the road can be widened from the existing 15 feet to 30 feet. My lord. Therefore, I was directed to conduct a spot inspection. My lords, I have conducted a spot inspection. The report is before your lordship.
Your Honor, may I say something on this issue? The corporation BBMP had made 30 feet road. There's a work order, and it was all 95 only they made the road.
Where is that work order? Have you produced it?
No, I have not produced, I have it.
You should have work order.
But now, your lordships could kindly peruse the photographs, my lord, annexed to the report.
The BBMP themselves had made the road, 30 feet road that time, 95. All this matter was considered by the High Court in the review petition, that was in the writ appeal.
Who issued plan sanctions for all these buildings, Mr. Aladi? Who issued plan sanctions? Corporation.
Corporation. I
So
will find
you
out, my lord,
issued plan sanction as a road of 15 feet.
to verify my instructions regarding that.
Your Honor, what has happened is,
See, there is an order passed in writ appeal.
Please.
Review petition was dismissed, directing you to pass necessary orders. Have you passed necessary orders or not?
No, we are not passed any order pursuant to my.
they served
How long
notice,
will you
Your
take to
Honor,
pass orders?
for making
It is
the,
an order which was passed 98 writ appeal,
correct.
and the order was passed on 28 June 1999.
Yes.
Review petition was disposed of on 22nd July 2003.
We were not.
We are in 2023.
That is what the writ appeal and the review petition.
Now you know.
Kindly consider this aspect, my lord.
So when will you pass orders?
Lord, sir, kindly peruse the order on the last occasion, my lord.
We have perused that. You have given your report. That was to see if there is space available. Now, if space is not available, the earlier order has to be implemented.
Because their lordships, on the last occasion, my lord, it was brought to the notice of.
You've done that part of your job, you are done.
No, my lord, I
But the earlier part of the job, you are not done.
wanted to, my lord, bring to your lordship's kind notice, my lord, that, my lord, on the last occasion, matter was heard, my lord, for the other honorable judge, my lord. My lord, his lordship felt, my lord, that since BBMP was not a party, my lord, therefore, my lord, a spot inspection may be conducted regarding the present position, my lord.
I understand, you filed your, now there was a direction also. Of course, it was for the BDA to bring it to your notice. If they have not brought it to your notice, now you are aware of it. There's an order of this court saying that BDA is not competent. Bangalore City Corporation is now empowered to do so. On consideration, we find they do not have to approach the corporation authorities. So now the corporation authorities are aware of this order.
Yes, they have been conveyed by the BDA, Your Honor. Long time back.
Yes, conveyed. What did you do?
Deep inspection. Sorry,
When was it conveyed to you?
1999 only.
You cannot say I was not a party. You are aware of the order direction.
You are aware of the order. No, I only wanted to, my lord, sir.
Yes,
Only for the limited purpose of this.
Yes, sir,
case,
you
my lord,
are statutory authority.
Please,
You have to discharge your duties.
please, my lord, I would, my lord, I would respectfully.
When will you do this?
Kindly grant me 2 weeks time, my lord, because it's a old matter, my lord. Kindly grant me 2 weeks.
That is why we can't give you too much time. 20-year-old matter.
Please appreciate this, my lord. Kindly, because, my lord,
Why does a litigant have to come to ask you to do what you have to do and wait for you to do for 20 years?
kindly grant me 2 weeks time. As a final.
We'll give you 1 week's time, produce all the records. A memo along with a survey report, along with photographs, has been produced. The same is taken on record. The memo, however, does not contain measurement of the road, except for a vague statement that it does not measure 30 feet. It does not indicate what exactly the width of the road is. Admittedly, the corporation has sanctioned plans as regards the building constructed on that road. The contention of the party in person is that necessary directions have been issued by this court in writ appeal 3766 of 1988 to the Bangalore Development Authority to take action on a review petition being filed by the BDA, indicating that the BDA was no longer in charge or in custody of the properties, but had been transferred to the Bangalore City Corporation. The Bangalore City Corporation was directed to take necessary action. Apparently, the Bangalore Development Authority has informed the Bangalore City Corporation about said order long ago, despite which no action has been taken.
Your Honor, we have been knocking the door of BBMP right from that time, every now and then.
In person, submit that despite repeated follow-up by the petitioner, the respondent has turned a deaf ear to the pleas of the petitioners.
Sorry to interrupt. There are certain injunction orders which are operating against the petitioner.
What is it?
Part of the petition also.
Injunction order.
Kindly see, not the annexure H for instance. But they are not the joining the site owners. Sorry. Annexure H, my lord, page 58. 60 is the judgment, trial court judgment.
It is much after the High Court judgment, Your Honor. The BBMP has gone and given false statements in that OS case.
The plaintiffs numbers 1 to 3 have filed this against the defendants, seeking relief of declaration to declare that the defendants, Bangalore Mahanagar Palika, has absolutely no authority in law to decide about formation of a road towards the northern side of the suit scheduled property. Also sought perpetual injunction against the defendants from interfering with the plaintiff's possession and enjoyment of the suit scheduled property, and also restraining them from causing obstruction and construction of the compound wall by the plaintiffs, and also restraining the defendants from widening the road towards the northern side of the suit scheduled property.
Your Honor, despite the High Court judgment,
seeing all these kind of orders, where a suit is filed, corporation doesn't even defend. We asked your law officer to be present, I think, tomorrow. Not even examined your witness. List of witnesses examined by the defendants, nil. List of documents produced by the defendants, nil.
And they're given a
cross-examination, nil.
Kindly see the
So
last.
is this not collusion?
See the last operative.
They did collude.
Yes, but what did you do about this? Or did you file an appeal?
Appeal is not
You neither defended this case, nor filed an appeal despite a division bench's order. And you want to take umbrage under the civil court's judgment?
We brought it to your lordship's kind notice.
Your Honor, even in that case, we tried to impeach.
Just a moment.
They did not let us.
Just a moment. This is not the way that you can conduct your proceedings. It reeks of collusion. Your officers have colluded with these people. They have not filed, they have not contested the matter. And now you want to take advantage of this order.
We brought it to your lordship.
Yes, but we are thankful that you have brought it to our notice.
Your Honor, it was at the insistence of the BBMP commissioner that the BDA revised that it should be made 30 feet road.
You don't give regard to the decision of the division bench. Two orders of the division bench. You don't contest the suit. And you want to make use of the order passed in the suit without even filing an appeal. Think. What is your bona fides?
We brought it to your lordship notice, my lord, that there is an injunction operating against the petition.
At this juncture, Shri Ashwin Naladi, learned counsel for the corporation, going to the notice of this court, the judgment passed by the 17th additional Civil Judge Bangalore in verse number 6578 of 2004.
Your Honor,
Wherein the petitioner wherein the corporation has been restrained from interfering in the peaceful possession and enjoyment of the suitable property by the plaintiffs. The appropriate action is taken to acquire the property to widen the road in accordance with law. A perusal of the said judgment gives rise to a very sad state of affairs. The defendant corporation, though, filed its written statement. Has not led any evidence or produced any documents to establish the right of the defendant in the property. The suit has been filed subsequent to the judgment of the division bench of this court in WA 3766 of 1998 on 28 June 1999 and the order passed in the review petition on 22/7/2003. Those orders were also not brought to the notice of the court. In fact, no appeal has also been filed challenging said judgment, nor has the corporation taken any action to widen the road if necessary by acquiring the land. Who do we have to direct? The commissioner to respond to this?
I will seek instruction. Kindly grant me 2 weeks' time. First week of April, my lord, I am undergoing an operation. That's the reason I made it.
That you should have told us.
Please. I apologize.
There is a lot of explaining to be done by the corporation in the above circumstances. At the request of Shri Ashwin Naladi, we list on 10th.
On the 13th.
13th April, it is made clear that no further adjournment would be granted. The corporation would have to place it on record. The proposed action is the action proposed to be taken by the corporation by that date. We'll have it on. I'll put to the 13th.
Kindly consider this. There are accidents on either side of the road. If any order is to be passed by your lordships,
What we want to see is on what basis have you sanctioned the plan? Does it say 30 feet or does it say 15 feet? And if it says 15 feet, how did you sanction these plans?
Last occasion, my lord, the lordship felt, my lord, that probably in the event, my lord, they'll have.
Concerned with this occasion, Mr. Aladi, you are asked to give the report, you have given the report. So don't please keep on saying last occasion. We don't know what has happened last occasion. We are concerned with the submissions today.
In fact, kindly appreciate this. Yes, this
So what is your stand? You want the buildings to be there only, or are you supporting them?
No, I'm not supporting.
Then?
Not, sir. Only trying to, my lords, this endeavor was to see that, my lords, the joining property owners, my lord, may kindly be included as parties to the.
Your Honor, the
You make an
PK
application.
After the review,
You make an application if you want them to be parties.
There's a direction given to the petitioner, my lord, but it is not in.
You want them to be parties, you make an application. If you don't want, it's your choice. The already directions issued to you, which you haven't done anything. And this is not the first case. They are coming across so many judgments. Civil court, at least in your case, there was a written statement filed. We are seeing judgments where no written statement is filed. In 4 months, the decree is passed, no appeal. Complete collusion on part of the corporation. Suit filed, no written statement, ex parte evidence, no arguments, decree passed. And then you come and show decree.
because they did not revise the kata. Though the BD had given clear instructions for bifurcation with 30 feet, they did not implement it. That is how they went to lower court. And that time they did not let us even implement.
Do this. You have to do your discharge your duties.
Documents are not on record, my lord.
You produce the document. That's why we are giving you time.
Petitioner is making an allegation.
We will make all the documents.
So respondent to produce. You will have to produce the plan sanctions issued, the basis on which the plan sanctions have been issued, the Kata certificates which have been issued as regards the properties in question. You will have it. Produce. 13.
My lord, delivery of the copy. Delivery.
You can take a printout of the upload. It will get uploaded.
My lords, I pay for petitioner. A week time may be, my lords, for amendment of cost. Right?
Carry it out now.
Regular
Ask
council is not enough. Work
Ask
round
him,
of
carry it out. Carry out the amendment.
I am for the response 1, 2, 3, my lord. The report is ready, my lord. I will serve a copy to the other side. I'll file it by tomorrow, my lordship.
Who is R4?
No, R4, is what we collected notice in the last occasion. On account of some miscommunication, I had not taken the necessary, not paid the necessary process. I've done it today. Also ensure hand summons is served. In the meanwhile, my lord, a copy of the status report may be served on me. I'll file my objections as well.
You can't have any objections unless you don't want them.
Within a developer, Kruti developers.
R4, you are permitted to take out hand summons at your request.
Yes. On account of some miscommunication, it was not done. I'm sure it's done as necessary.
Counsel for the petition submit that you will be making payment of necessary process fee as regards the hand summons to be issued to respond.
I have filed a similar writ petition that will be clubbed at the same.
Respond number 4. A registry is directed to do the needful. Shri N.R. Jagdishwara, learned counsel for the corporation permit that
The report is ready. It will file by tomorrow, my lordship.
and will be filed by end of day tomorrow. After serving a copy thereof on the counsel for the petitioner and the other respondent.
I filed a similar
Another similar petition in WP number
5785/2023
has been filed. Connect the said matters. Relist on 17th April.
Oblige, my lordship.
Not sir. This is only a photograph. Lordships may see, even that photograph is so evident. Lords may see, my lord, annexure R1.
What were you directed to do?
Lordships are directed to file the report, inspect the property and file a survey. Encroachment on the public road. Same lord. But in the photographs, the first photograph, lord, at page number 2. Ali a cow shed tara on the hakondu. Lordships may see on the left, on that house, Aradela Kelu lots, that is my lord the cowshed, which is what I have alleged, my lord, specifically in my petition. And also, my lord, lordships may see the adjoining photograph taken from the other side. Illela maragira ಬೆಳೆಸ್ಬಿಟ್ಟು ಇವ್ರ ಮನೆ ಎದುರುಗಡೆ ಮಾಡಿ they want to look as if, my lord, that is their property, like a garden. ಆ ಕೌ ಶೆಡ್ ಅನ್ನ ಹಿಂಗ ಅಡ್ಡ ಹಾಕಿ ಈ ಕಡೆಯಿಂದ ನೋಡಿದ್ರೆ ಐ ಆಮ್ ಗ್ರೇಟ್ಫುಲ್ that BBMP has taken pictures from other side also, and ಇಲ್ಲಿ ಇದೆಲ್ಲ ಹಾಕಿ
You should be, otherwise
ಅಲ್ಲ ಈ ಕಡೆಯಿಂದನೂ ಆ ಕಡೆ ಫುಲ್ ಕ್ಲೋಸ್.
BBMP is beyond repair. This is a road.
ರೋಡ್ ಗೆ ಮರ ಹಾಕ್ಬಿಟ್ಟು
Kindly see page 4, madam.
And you are allowed your road to be encroached by traffic.
One some mistake. Kindly see page 4, madam.
Yes.
This is a main road, the BDA layout. Adjacent is the BDA layout where the road is proper. The petitioners are claiming that this portion is road. It is a revenue pocket, madam. There is no layout plan for this. The persons who are residing there are saying that some litigation is pending and they are saying it is a site.
They are saying that, did you ask them for the document?
Yes, my lordship, that is what I have instructed. Today only they are going to issue notice and we will secure their title documents so that we will come to know about the extent, my lordship. Then we will initiate.
Pawan Kumar, is there plan sanctioned by the BDA?
For BDA layout, there is a sanction.
The BDA plan should be with you after it's been transferred? Once BDA transfers the properties to you, it should be with you.
Yes, sir. For maintenance,
the roads, there must be a layout. The marking of the road, the drains, as built has to be given to you. You have it with you.
But the LH road where they are saying it's the revenue pocket.
What does that plan which has been given to you say?
Yeah, we are calling for the documents of that.
ಇಲ್ಲ ಪ್ಲಾನ್ ನಾನೇ ಹೇಳಿದ್ದೀನಿ.
You have the documents with you. Nimatra Ilva BDA plan sanction has not been given to you.
Sanction plan we can get, it will be there.
So what does that disclose?
This is all the things regarding this revenue pocket. So we go to plan with revenue layout plan.
Page 7.
Layout plan you produced, Mr. Prabhu?
No, my lord. I have page para 2.3. He has inspected and I am placing reliance on his own inspection. Para 2.3, my lord. Further.
2.3 of?
Paragraph, page 7, para 2.3, my lord. Page 7 of my petition. Further, subsequent to representation dated so and so on 17th November 2017, Joint Commissioner East BBMP personally inspected the spot, after which he has clearly established beyond doubt that some miscreants had illegally occupied the public road and they purported to own. Also, it was established that construction of a cattle shed in the middle of First Cross Road, so and so, thereby have wrongly occupied the so and so. He came, he inspected, and further lordships may see the next.
Where's the inspection report?
That, lord, was not given to me. They have a report.
Is there an order passed?
They have not shared it with me, my lord, despite my representation. If they produce that, that will be, my lord, one substantial proof. There is no one more.
It's a note sheet they have filed.
Amele, lordships may see, my lord, next paragraph, encroached includes manhole, water supply and sewage pipelines maintained by BWSSB.
That is why we asked him. We saw the manhole.
Revenue.
Manhole cannot be in a private land.
In BWSSB line
it's a road on it. Our people will issue notice and will take title deeds and we will get to
we don't want to say things.
Some reason
we want to say things, but we are restrained in saying things. Wherever you want, even illegal buildings are demolished. Wherever you don't want, illegal buildings will also continue. Somebody encroaches and puts a compound wall around a manhole, also it becomes private property. How can it be?
Manhole
it defies not only law, it defies basic logic.
Manhole ಕಾಣಿಸ್ತಾ ಇದೆ. Page 4.
What do you propose to do now?
So as per my instruction, we will issue notice to the person who is occupying the space and we will collect the documents and may come to know so that what is the extent they are owning and remaining.
Your Joint Commissioner conducts an inspection. Your directions issued is the pleading. So what is your reply to that?
Secure the record.
So that we will give you a week's time for you to do that?
Allah, that is there, my lord, page 18. I'm sorry, page 18 is the note sheet that I have produced. Page 18, my lord. Ali Kannadadalli ಇದೆ. I'm sorry, my lord, this should have been translated. ನಾನು ಖುದ್ದಾಗಿ ಸ್ಥಳ ಪರಿಶೀಲಿಸಲಾಗಿದ್ದು ಲಾರ್ಡ್ಶಿಪ್ಸ್
ನೀವೇ ಓದ್ಬೇಕು.
ಅಲ್ಲ, ಐ ಆಮ್ ಸಾರಿ. ನಾನು ಖುದ್ದಾಗಿ ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಿದ್ದು ಎಲ್ಲಾ ಮಾಲೀಕರಿಗೆ ನೋಟಿಸ್ ನೀಡಿ ಹಕ್ಕು ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿ ಯಾರೋ ಅವರಿಗೆ ದಾಖಲೆಗಳನ್ನು ಪಡೆದು ಇನ್ಚಾರ್ಜ್ಗೆ ಮಾಡಿ ವಿಚಾರಣೆ ಮಾಡಿ ವರದಿ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಲಾಗಿ ಕ್ಯಾಟಲ್ ಶೆಡ್ ನಡೆಸುತ್ತಿರುವುದು ಕ್ಯಾಟಲ್ ಶೆಡ್ ಜಾಗದಲ್ಲಿ ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಲು ವಿಫಲರಾಗಿರುತ್ತಾರೆ ಮತ್ತು ಕೋರ್ಟಿನಲ್ಲಿ ಕೇಸು ಇರುವ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಯನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ ಎಂದು ಓರಲ್ಲಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಯಾರೋ ಇವರು ವರದಿ ಮಾಡಿರುವುದಂತೆ ಸದರಿ ಜಾಗದಲ್ಲಿ BWSSP ಲೈನ್ ಹೋಗಿದ್ದು ಸ್ಪಷ್ಟವಾಗಿ ರಸ್ತೆ ಇರುವುದು ಪ್ಲೇ ಗ್ರೌಂಡ್ ಇನ್ಸ್ಪೆಕ್ಷನ್ ನಿಂದ ದೃಢಪಡಿಸಿರುತ್ತದೆ. ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಕೂಡಲೇ ನಿಯಮಾನುಸಾರವಾಗಿ ಕೌಶೆಡ್ ಅನ್ನು ತೆರವುಗೊಳಿಸಲು ಕ್ರಮ ಕೈಗೊಳ್ಳುವುದು, ಅಗತ್ಯ ಬಿದ್ದಲ್ಲಿ ಪೊಲೀಸ್ ಸಹಕಾರವನ್ನು ಪಡೆದು ಕಡ್ಡಾಯವಾಗಿ ಏನೇ ಇಂಜಿನಿಯರ್ ಸ್ಟಾಫ್ ಇತರ ಸಹಕಾರ ಪಡೆದು ಕ್ಯಾಟಲ್ ಶೆಡ್ ಅನ್ನು ತೆರವುಗೊಳಿಸಲು ಕ್ರಮ ವಹಿಸಲು ಆದೇಶಿಸಲಾಗಿದೆ. ಆಲ್ರೆಡಿ ಮಿಲಾರ್ಡ್ ಆದೇಶಿಸಲಾಗಿದೆ. Yes, he is respondent number Lord 2. He is respondent number 3.
You don't follow the direction of the court. Now you are not following direction of your own joint commission. Seeks for and is granted a week's time to make a submission action taken subsequent to Annexure B, being the note sheet and instructions, note sheet containing the instructions issued by Joint Commissioner East of the BBMP.
Lord respond.
Released on released on 3rd.
I am for the petitioner, my lord. I have published in the paper regarding the respondent 5. He is avoiding notices and even the hand notice also.
Respondent number 5, Sri Muhammad P. Father's name not known.
Father's name not known to the petitioners. You can't say father's name not known. The account of respondent number 5 not being served. IA 1 of 2023 was filed, seeking permission of this court to take out service by paper publication, which came to be allowed on 24/2/2023. Pursuant thereto, the memo has been filed. Affidavit has been filed. Affidavit of the petitioner has been filed on 15/3/2023, enclosing therewith the paper publication in the newspaper Karnataka dated 2/3/2023. Respondent number 5 was called out and answers for respondent number 5. As such, service of notice on respondent number 5 is held sufficient. Registry is directed to print the name of respondent number 5 with the endorsement served through paper publication. We list on 3rd April.
Serial number 13, Telecast KB.
Court with some objection after submission.
Petitioner is granted 2 weeks time to comply with the office of 10th April.
14, Radha Ramesh.
Is R1 and R2.
Mangalore City Corporation. Mangalore. Harish Bandari.
Shri Harish Bandari accepts notice for respondent number 1, City Corporation 1 and 2. Counsel for the petition, sir, copy of the petition and on the election statement.
Take up notice. Issue the take up.
Shri Harish Bandari or Sarma. There's a panel counsel, you don't need to pay process. Hence, no process is required to be paid. Objections, if any, by 13th, relist on 18th.
Serial number 15, Has done 18th March.
Notice to respond number 4 has been dispatched on 18th March. Awaiting service released on 13th April.
Serial number 16. Case of birth.
On 3/3/2023, my lord, it was directed to the respondent number 2 and 3
Yes.
to file, conduct spot inspection and file report, my lord.
Mr. Vasan,
My lord, for respondent number 4, AK ವಸಂತ್ ಅವರಿಗೆ ಡೈರೆಕ್ಷನ್ ಇದು ಎಫೆಕ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅವರೊಂದು ಇದು ನನಗೆ ಅಪೇರ್ ಆಗ್ತಾ ಇಲ್ಲ ಹೇಳಿದ್ದಾರೆ ಹಾಗೆ ನಾವು ಇದು ಪ್ರೊಸೆಸ್ ಕೊಟ್ಟಿದ್ದೇವೆ ಈಗ.
ಅವ್ರು ಕರ್ಕೊಂಡು ಬನ್ನಿ ಕರೀರಿ ಅವರು ಏಕೆ ವಸಂತ್ ಫೋನ್ ಮಾಡಿ.
ಅಪೇರ್ ಆಗ್ತಾ ಇಲ್ಲ ಹೇಳಿದ್ದಾರೆ.
We'll ask him why he won't have it. Pass it. He is the standing council, ಅಲ್ಲ?
ಇಲ್ಲ ಅವರು ಹೇಳಿ ನಾನು ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ತಾಲೂಕ್ ಪಂಚಾಯತ್ ಇದು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಆಗ್ತಾ ಇಲ್ಲ.
We'll ask him why, what's the problem? So if there's somebody else who is the standing council, we'll ask them to take.
Serial number 17. Rama Narayan.
Big appeal for petition, my lord. The spot inspection was made, but no report has been filed. In the meantime, they say that we are not filed the service to the respondent number 1. I'm doing it today, right now. But spot inspection has been made.
Yes, but you left.
I'll place it on record.
You placed it on record.
I'll place it for 2 days time every night.
It is already placed on record. As if it is there.
3 days time. Latest by Monday.
Granted counsel for the petitioner seeks for and is granted 2 days time to make payment of necessary process fee for issuance of notice to respond number 1. If needful is done, registry is directed to issue notice to respond number 1 returnable by 17th. Counsel for respond number 2 submit that the survey has been carried out. The report will be filed given
In 3 days.
weeks time. Released on 17th.
Serial number 18. K. Venkatachala.
Prakash. Aso.
19.
Lords, this matter.
Yes.
The first matter, my lords, serial number 19. I appear for R6 and R7. Respondent number 6 and 7, I undertake to file wakalat. I've been served the petition copies just now. But my lords, I have a submission.
19 Street. B.U. Muralidhar has entered appearance for respondent 1 to 3. Delete the name of Sri Pawan Kumar is that appearing for R1 to R3. Who are R4, 5, 6, 7?
4, 5 are Bestcom, my lords, and 6 and 7 is I undertake to file wakalat for 6 and 7.
Shirish.
Shirish Krishna.
Krishna undertakes to file wakalatnama for respondent number 6 and 7. PW Westcom Yaro. Who is the standing counsel?
I have one submission. They are not necessary parties because, my lords, it is mandamus to BBMP. And my lords, my submission is that, my lord, they can be allowed, the prayer can be allowed. Let them inspect my property, my lords. I am not conducting any commercial activities. If I am conducting, my lords, let them take action in accordance with law.
Who is the standing counsel for Bestcom?
H.V. Devaraj.
H.V. Devaraj accepts notice for respond number 4. Okay, Monish Kumar accepts notice for respond number 5. The petitioner is before this court seeking for the following relief. The grievance of the petitioner is that the petitioner had submitted representation on 13/12/2021 or 3/2/2020. 13/12/2021 to respond number 5 to close down the commercial activities carried out by respond number 6 and 7 in a residential area, as also to collect tax on commercial rate. Despite the said representation having been submitted, no action has been taken. The counsel for respond number 6 and 7 submits that he is not carrying out any commercial activities in the premises under question, and he has no objection for a inspection to be conducted by respond number
2, my lord.
In view of the said submission made by counsel for respond number 6 and 7, I pass the following order. Petition is allowed. The mandamus is issued directing respond number 2 to carry out inspection of the premises, respond number 6C7, to verify in terms of the representation furnished by the petitioner, submitted by petitioner, and take action thereon within a period of
2 weeks, man.
2 weeks.
Because their representation is, my lords, to close down on my enter. That is not there.
To verify if respond number 6 and 7 are carrying out any commercial action.
It may kindly be fixed for
And this,
inspection.
if so, necessary action to be taken in accordance with law. Since the order is passed in the presence of all the councils, the inspection to be carried out on 10th April, commencing from 10:30 a.m.
3 p.m.
3 p.m. There will be no requirement of issuance of any further notice to either the petitioner or respondent 6 and 7.
Grateful, my lord. My lords,
in the connected matter.
the connected matter, my lord. There, my lord, I have
closed down
I
as if I am running the industry. Then
I have
person was appointed and submitted report to this.
For that, email bantu anta our mele.
It's a counter blast, exactly, counter blast, my lord.
On last occasion, my lord, this court had directed the second respondent to inspect the premises and to submit a report as regarding the nature of business carried on in the premises. I have filed the report on 14th March, my lord. He's running a administrative office in the entire ground floor, my lord.
Is it permitted, not permitted?
It is not permitted because road width is less than 40 feet, my lord. No commercial activity, non-residential activity is permissible as per zone regulation.
My lord, direction was issued to pass an order after filing objection from me, my lord. After filing the objection, they have not heard me. Only at the direction issued by this honorable court, they inspected. Industry was running at Pune. Now, my lord, annexure A was issued on the ground that I am running a industry in the premises in question. Last time you kindly see the report.
Running an office.
Yes, office. Industry is in Pune.
No, we are not directed him to close down on that basis.
This is
Violation of general regulation.
But can you run an office in a residential area? My lord, which is where the road measurement is less than 40 feet.
No,
40 feet is the madboard.
40 feet, my lord.
Ancillary use is
Restriction was imposed after 1915, my lord. So far as sanction plan is granted, my lord, for the office only by the medium.
Sanction plan is for the office.
Yes,
no. I have
portion,
copy of the
ground for portion.
Tell me the way is your sanction plan?
Only a room is permitted to be used by the
That's why my not produced my office. I stated in the petition.
Statement agala plan.
Yes, I produced.
This
By the medium of
Is
1982.
it sanctioned for the office?
Yes, copy of that to the officers, man. Only a portion, only a room in the ground floor is permitted to be used as office.
So,
Entire ground floor is used as administrative office. Plan is for
you are
residential.
only 12 feet by 10 feet.
Yes,
The photos
that's only office, my lord.
photographs indicate otherwise.
The objection is raised on the ground that there is a sound pollution, my lord, and disturbance.
If you are
The
going
report
to,
says not there is no sound pollution or air pollution or anything.
that is not relevant. And sanction is for 12 feet by 10 feet of office.
Since 82, my lord, we are.
That doesn't give you a right. Continue.
This 40 feet and all restriction is imposed after 1915, my lord, in view of the judgment passed by this one court. It is a retrospective effect, my lord. We are running the office since 96, my lord. Sanctions plan is like 82, my lord. Anyway, it is not disturbing any neighbors or no neighbors are fine except this person, my lord.
I have one submission.
If you don't keep your neighbors happy, this is what happens.
He is fighting the everybody, my lord. This is not only with me, my lord.
Sorry, I am a senior citizen and my lords, I have one submission. This inspection report by BBMP, my lords, is on 2nd of March. On 25th of February, my lords, few days before, they have transported all equipments, my lords, like turbines, everything. And prior to that, my lords, the final notification says an industry was considered. There's a lot of noise pollution, my lords, and there are trucks unloading and offloading. They produce those photographs dated 25th of February.
Yes.
huge machines are also transported just before the inspection.
Sorry, my lord, there is no machinery, no machinery, my lord. 2 years back, my lord, pollution control board visited the spot, my lord. They have also submitted report on the objection filed.
And prior, the final notification which is challenged, my lords, clearly says in industry is being conducted below 40.
Last time, kindly see
The
the report.
neighbor has cameras on your house.
No,
your
not
office.
only house, my inside house, and there are a lot of complaint and counter complaint, my lord. Every week, my lord, they used to visit the police station, my lord, for this reason.
Will you vacate or will we ask them to get you vacate?
No, this is only, my lord, office, my lord, we will vacate, my lord, not right now, my lord, it's because administrative office.
How much time do you?
To find out some other, or otherwise, my lord, on the basis of the report, order implement pass, my lord, without hearing anything. Let them, my lord, hear, my lord, by considering my objection and all, my lord, let them pass within 2 weeks or 3 weeks, my lord.
Your plan sanction, why you also you know? Not because it is illegible. The reason why you are not produced, you know.
No, I can restrict to one room, my lord, that there is no problem, my lord.
So now, when will you vacate?
The entire thing will take alternative, my lord, at least, my lord, 1 year is required. Take alternative.
Be reasonable, Mr. Hegde.
No, purchase the
But intelligence is being extended.
No,
Be reasonable.
purchase is only for the purpose of this.
If you don't want indulgence, bad. But we'll have it on Monday. You let us be, but a reasonable time. 1 year ella agala. Correct. Council for 19.1. DV Muralidhar, Council for respond number 1 and 2 submits that the entire ground floor is being used for office purpose, which is not permitted. Prasad Hegde and Council for the petition submit the plan sanction been obtained in the year 1982, as per which the petitioner, as per which the use of the ground floor is permitted for office. A perusal of the plan which has been handed over across the bar, which is also found in the file of the BBMP, indicates that it's only the print room of the ground floor measuring 12 feet by 10 feet, which could be used for office purposes and not the entire ground floor. Faced with the above situation, the Council for the petitioner seeks for a week's time to make a submission, as also make a submission as when the petitioner will vacate the premises and or put the premises to use other than office space. We list on 3rd April.
Tuesday.
Tuesday Raja ಇದೆ. 4th Tuesday Raja ಇದೆ. 6th. Interim order earlier granted is it. Jagdishwara NR, Council has entered absence for R1 Act. Delete Pavan Kumar as that appearing R1 and R2. Yes, compliance, Mr. Jagdishwara.
And let's see, if the Tahsildar has to give a acknowledgement for having served the notice before conducting the survey.
Notice served before survey, Lord. Presence of the petitioner will survey this property. Last time also the matter was passed over, he was not present at the matter.
A date may kindly fix, my lordship, for survey the property in the presence of the petitioner.
Our Barbekala will pass over. Let Mr. Agnihotra come.
Please, my lordship.
Number 21. Is that it?
Directed the BBMP to verify about the condition of the next building.
Who is appearing?
R1 not
And the completing application has come.
Chidananda, you are
please.
still live. Chidananda P has entered appearance for R1 to R3. Lead Pavan Kumar and BL Sanjeev as that appearing for R1 to R3.
I filed my
People
objection.
have filed wakalat.
Some mistake, my lord, which is
And
happening. I
one
filed my
report is
wakalat
also
already.
filed. The applicants for impleading are.
Amel Barana, Mr. But you one small problem with you would sort out one. So who will appear now?
Anyway.
Let Mr. Chidananda appear.
And one
Please.
more learned counsel is the writ appeal.
P.N. Mahesh Chandra for R4 to R8. Yes, Mr. Bhatt.
This is the case, my lords, wherein, my lords, in terms of the directions of this honorable court, I preferred an appeal before the chief commissioner. Chief commissioner, after hearing my appeal, rejected and addressed the question in this writ petition. In between, the applicants herein, who are none other than the busybody and interlopers, also filed a writ petition that BBMP is not taking an action, who are set up by the next bar owner. Now, my lord, against the order passed by the learned single judge, they have preferred a writ appeal, and writ appeal is on office objection stage.
What is the order passed by Leonard Singhal?
Order in my writ petition, my lord, I was directed to prefer a writ petition appeal before the chief commissioner. In that writ petition has been disposed of, word used is that parties are relegated to the chief commissioner. Means, I have already preferred an appeal, I have made a submission to the honorable court also. Now the impleading application says that they also should have been impleaded, which is not necessary. They have set the law into motion, action has been taken.
So you are more concerned about the impleading application than your main petition.
No, the main petition is that, my
What is
lord,
the
I
action
do not
taken?
say that.
To receive the report, please, Madam.
When will you receive it?
There's a week's time, please.
I will file objection copy yesterday served.
Ian served.
Allah, impleading.
Impleading coding.
Yes, they are.
When did the report come?
Next week, please, Madam.
Report of both these bar and restaurant.
Please.
Yes, she Bhatt Leonard Singh Castle seeks for and is granted a week's time to file his objections to IA 2 of 2023. In the meanwhile, office objection to be complied with. Chidananda Leonard Castle to respond number 1236 and is granted a week's time to submit the action taken report.
Interim order may
The list on 6th, the interim order earlier granted is extended.
22. Same size, sir.
In this matter, a mistake has happened. The name of the petitioner is S.V. Prasad. The records what they have is D.V. Prasad. Because of the signature mistake, kindly have it tomorrow, my lordship. Produce the correct report.
Not the first time. In another matter also same thing had happened.
But D.V. Prasad, they have got it. S.V. Prasad, the name initial.
Address, sir? Address?
Address is, they are different.
Address is also different.
Different property. my lordship. Division, subdivision is same. The properties are different. I have shown it to my learned friend also. But it's S.V. Prasad is the D.V. Prasad. Tomorrow.
There are two different people at two different addresses,
Yes,
Mr. Consul.
they have brought in the records of D.V. Prasad.
And your officers want to use the address, a notice served on another person to say notice has been served on the petition.
No, not like that. By mistake, they have brought it. Kindly have it tomorrow. I will produce that.
Can't be by mistake. Can't be by mistake.
Tomorrow, man. Kindly have it.
These are notices being issued for demolition,
No, man. Property tax.
property tax.
Property.
And counsel for respond 1264 is granted 2 days time to produce records. Relist on 30th. Interim order earlier granted is extended. The last two matters was demolition, served on somebody else.
It happens.
Narendra, Nagender,
Yes, sir. Narendra Nag.
address bearer.
Yes, sir.
Yes.
Number 23.
Yes, my lords. I appear for the petitioner, my lords. I have already furnished the RTC as per your lordship's direction, my lords. I don't know why the office has raised objection on.
When have you filed it?
It is filed on 24th March.
24th?
24th March. That was on Friday, my lords. Perhaps due to the latest circular, I think the files have been sent much in advance. Therefore, it's not. It is.
But there are some objections you will have to clear. There are 4 objections. 2 of them are important, so you'll have to clear those objections.
Objections with regard to my lords?
On your memo of his objections.
Very well, my lords. I'll comply with it, but.
Office for The petitioner has filed a memo dated 24/3/2023 and certain of his objection being raised in regard to the memo. Counsel for the petitioner seeks for and is granted a week's time to comply with the same. We list on 3rd April.
Very well.
24, Raja Ramji.
So the petition is case.
Pawan Kumar or something.
They are supposed to file some report or something like that.
File it. Also.
25, yes, Rajshekar.
This objection is that Millets have not furnished your execution petition.
Award and decrease.
Decrease. Because I am not challenging the award, Millets. Only Millets, the auction notice issued by the respondent bank.
How much is the amount?
52 lakhs.
52 lakhs is the award amount or present amount?
Total present amount what they have shown in the auction notice.
How much will you pay? 2/6.
Last time Millets granted me 25% Millets within.
All of you know. 2, 4 and 6.
Yes.
Second week how much? 4th week how much? 6th week how much?
15, 20.
15, 20, 15.
Total 25% last time.
Total 50 ಬರ್ಬೇಕು, at least that amount will. Otherwise, if you pay 15%, it will go to interest. ನಿಮಗೂ ಏನು ಬೆನಿಫಿಟ್ ಇಲ್ಲ. Seen in other matter, 10% ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ, ಎಲ್ಲ ಇಂಟ್ರೆಸ್ಟ್ ಬೇಕು. ನಾವು I paid this money, but it's gone to interest.
That's it. First 15 lakhs within 3 weeks, my lord. So next 25 lakhs within next 4 weeks.
ಆಮೇಲೆ
the full settlement, my lord, within next another 4 weeks.
The PS Rajshekar and counsel for the petitioner. There an AG access notice for responding 1 and 2. PS Rajshekar and counsel for the petitioner. Submit that the total due amount as on today is 52 lakhs.
2 lakh 3,268.
3,268. 260. They submit that the amount equivalent to 15% thereof will be paid within a 2 weeks from today, on or before 10th April.
3 weeks, I see.
3 weeks from today, that is on or before 17th. 25% and another amount equal to 25% will be paid within a
4 weeks thereafter.
Weeks thereafter. That is on or before 15th May, and the balance will
another 4 weeks
within a period of 4 weeks thereafter. That is hereby the entire loan account will be liquidated
by the end of
by
June.
12th June.
By the end of June.
By 19th June. In view thereof, the auction notice dated 17/2/2023 issued by respondent number 3 is stayed till the next date of hearing.
Annexure A to H.
At annexure A to H. Subject to the above payments, if there is any default, if there is a default payment of any of the installments, the interim order will stand automatically recalled. We list on 19th April to ascertain the payment of the first installment. Issue notice to respond number 3 written out by 19th. And copies to be furnished by end of day tomorrow. Dealing with the interim order will stand automatically.
And delivery. 30th is the option.
30th in the upload as a respond to act on a printout of the uploaded form.
Great.
Serial number 26 of Telecast.
Last time it was paid in.
Counsel for the petitioner has filed a memo indicating that the cost has been paid. Ready now?
Respondent number 3 passed away. I will tell you.
Submit that respondent number 3 has expired. The 6th fund is granted. Estina beko?
1 week now.
Week's time. Agata?
Agutte.
2 weeks time to file necessary application to bring legal opinion. Deceased respondent number 3 on record. Relist on 17th.
Office objection.
You comply ಮಾಡಿ.
Comply ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಅವರು ಡಿಸ್ಪ್ಯೂಟ್ ಅವಾರ್ಡ್ ಎಲ್ಲ ಹಾಕಿ ಅಂತಾರೆ.
ಅದನ್ನ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡ್ತೀವಿ.
25 ಅಲ್ಲಿ the production of the award is dispensed with for now, subject to any objection being raised by the council for response.
Hearing on IS serial number 27. MD Chandrasekhar.
What is the unexpected?
Endorsement issued with the Panchayat was challenged before the Deputy Commissioner Energy rate page 34. Produce the Karas copy. Grant
You appear for the panchayat.
Panchayat.
Aneksha H correct?
No, basically.
And the copy of it is correct. IA 1 of 21 is filed for dispensation of production of original of H. The council for respond number 3 confirms that the photocopy of Aneksha H is proper and correct. As such, IA 1 of 2021 is allowed. Production of original of Aneksha H is dispensed with.
15/4/1987. Vacant seat measuring 32 into 20 was allotted in favor of the petitioner.
32 into
20.
20.
Upset price was collected. Data was transferred in the name of the president of the petitioner association. After the change of constitution of the petitioner association, we made an application before the town panchayat for transfer of the data in the name of the reconstituted association.
What was the petitioner earlier?
His petitioner name was Recreation Association, Town Recreation Association. ಅದನ್ನ ಹೆಸರನ್ನು ಚೇಂಜ್ ಮಾಡಿ ಟೌನ್ ಕ್ಲಬ್ ಅಂತ ಮಾಡ್ಕೊಂಡಿದ್ರು ಅಷ್ಟೇ.
That recreation.
Really, ಆಮೇಲೆ ನಿಮ್
Kindly see the order.
Change to town club.
ಹೌದು. ಮೊದ್ಲಿದ್ದು ಟೌನ್ ರೆಕ್ರಿಯೇಷನ್ ಅಸೋಸಿಯೇಷನ್ ಅಂತ ಇತ್ತು. ಟೌನ್ ಕ್ಲಬ್ ಅಂತ ರೀಕನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ವಿ, ಅದಕ್ಕೆ ಚೇಂಜ್ ಮಾಡಿ ಅಂತ ಕೇಳಿದ್ವಿ. Kindly see the allotment made on 50th May 1987. Resolution passed by the Panchayat.
Page number?
Page number 20, Annexure C.
Yes.
Resolution dated 15/4/87. So on page 21.
Yes.
Item number 2. Item number 3, the recreation club site ಕೇಳಿ ಬಂದಿರುವ ಅರ್ಜಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ಸಾರ್ವಜನಿಕ ಹಿತದೃಷ್ಟಿಯಿಂದ ರಿಕ್ರಿಯೇಷನ್ ಕ್ಲಬ್ ಅಗತ್ಯ ಇರುವುದರಿಂದ ಹಾಗೂ ಅವರಿಗೆ ಸ್ವಂತ ಕಟ್ಟಡವಿಲ್ಲದೆ ಇರುವುದರಿಂದ ಸ್ವಂತ ಕಟ್ಟಡ ಅಗತ್ಯ ಇರುವುದರಿಂದ ಅವರಿಗೆ ದಬ್ಬೆಘಟ್ಟ ರೋಡ್ ನಲ್ಲಿರುವ ಪಶ್ಚಿಮದ ಕಡೆ ನೀರಿನ ಟ್ಯಾಂಕ್ ಪಕ್ಕದಲ್ಲಿ ನೀರು ಸರಬರಾಜಿಗೆ ತೊಂದರೆಯಾಗದಂತೆ ಇರುವ ಜಾಗ ಅಸೆಸ್ಮೆಂಟ್ ನಂಬರ್ ಸೋ ಮಂಜೂರಾತಿ ನೀಡಿ ರೋಡಿಗೆ ಲಗತ್ತಾಗಿ ನೀರು ಸರಬರಾಜಿಗೆ ತೊಂದರೆಯಾಗದಂತೆ ವಾಟರ್ ಟ್ಯಾಂಕಿಗೆ ತೊಂದರೆಯಾಗದಂತೆ 32 x 20 ಅಡಿ ಕಿಮ್ಮತ್ತಿನಂತೆ ಚದುರ ಗಜ 2 ರು ಅಂತ ಇರಿಸಿ ತೀರ್ಮಾನಿಸಲಾಯಿತು. This was carried out by passing transferring the khata in the name of
the recreation club. The recreation club.
ಇದು
town recreation association.
ಹೆಸರು ಮಾತ್ರ
ಹೆಸರು
ಮಾತ್ರ ಅದು ಏನಾಯ್ತು, ಪ್ರೆಸಿಡೆಂಟ್ ಹೆಸರಿಗೆ ಖಾತೆ ಮಾಡಿದ್ರು. Kindly see the Annexure D, page 23. ಅವಾಗ ನಂಜಪ್ಪನವರು ಅಧ್ಯಕ್ಷರಿದ್ರು, ಟೌನ್ ರೆಕ್ರಿಯೇಷನ್ ಕ್ಲಬ್ ಅಂತ. ಈಗ ನಾವು ಟೌನ್ ಕ್ಲಬ್ ಅಂತ ಮಾಡಿದೀವಿ ಅಷ್ಟೇ. ಇದು ಫಾರ್ ದಿ ಲಾಸ್ಟ್ 13 years they have collected.
Club is a society. What is it? What is
association? Registered society is the registration. Annexure B is the registration certificate.
Annexure B.
Please.
That is town club. What about town recreation association?
ಎರಡು ಒಂದೇ.
Societies alle itta.
ಎರಡು ಒಂದೇ. Object is one and the same. ಹೆಸರು ಮಾತ್ರ ಚೇಂಜ್ ಆಯ್ತು ಅಷ್ಟೇ.
So name change ಗೆಲ್ಲಿ order ಎಲ್ಲಾಗಿದೆ. Where is the change of name? Because the certificate of registration to change of name ಕೊಡಬೇಕು.
ಹೌದು, ಅದ್ರ ಬಗ್ಗೆ
ಸರ್ಟಿಫಿಕೇಟ್ ಆಫ್ ರಿಜಿಸ್ಟ್ರೇಷನ್
ಮಾಡ್ತಾ ಇಲ್ಲ. ಅವ್ರ ಪ್ರಕಾರ ಏನಂದ್ರೆ ವಾಟರ್ ಟ್ಯಾಂಕಿಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ ಅಂತ. Kindly see the khata transfer.
Constitution is not a issue.
Constitution is not questioned. Kindly see the endorsement issued for the 13 years.
Page?
The Annexure H. Page 34. ನಾವು ಒಂದು ಲೈಸೆನ್ಸ್ ಕೊಡಿ, ಖಾತೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಬಿಟ್ಟು ಹೊಸ ಫಾರ್ಮ್ ಲಾಂಚ್ ಮೇಲೆ. ಕೈಲಿ ಸಿ ದಿ ಆರ್ಡರ್.
Turvekere town so and so, Hakku Vargavane transfer of the Khata. ಶಿವರಾಜ್ ಅಧ್ಯಕ್ಷರು ಟೌನ್ ಕ್ಲಬ್ ತುರುವೇಕೆರೆ ಮನವಿ ದಿನಾಂಕ 5/2/20 ಈ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ತುರುವೇಕೆರೆ ಟೌನ್ ವಾರ್ಡ್ ನಂಬರ್ ಸೋ ಸೊತ್ತಿನ ಆಸ್ತಿ ವರ್ಗಾವಣೆ ಕೋರಿ ಕಚೇರಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದವರಷ್ಟೇ ಈ ಬಗ್ಗೆ ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿದ್ದು ಸದರಿ ಸೊತ್ತಿನಲ್ಲಿ ಕುಡಿಯುವ ನೀರು ಸರಬರಾಜು ಮಾಡುವ ಅಂದಾಜು 4 ಲಕ್ಷ ಲೀಟರ್ ಸಾಮರ್ಥ್ಯದ ನೀರಿನ ಟ್ಯಾಂಕ್ ಮತ್ತು ಇತರೆ ಪೈಪ್ಗಳಿದ್ದು ಸಾರ್ವಜನಿಕರು ಕುಡಿಯುವ ನೀರಿನ ಹಿತದೃಷ್ಟಿಯಿಂದ ಹಾಗೂ ಸದರಿ ಸೊತ್ತು ಮುನ್ಸಿಪಲ್ ಸೊತ್ತಾಗಿದ್ದು ಕರ್ನಾಟಕ ಪುರಸಭೆ ಅಧಿನಿಯಮ 1964 ಕಲಂ ನಂಬರ್ 72(2) ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದಿಂದ ಅನುಮೋದನೆಗೊಳ್ಳದಿರುವುದರಿಂದ ಆಸ್ತಿ ವರ್ಗಾವಣೆ ಮಾಡಲು ಸಾಧ್ಯವಿಲ್ಲವೆಂದು ತಿಳಿಸುತ್ತಾ ತಮ್ಮ ಅರ್ಜಿಯನ್ನು ವಿಲೇಪಡಿಸಲಾಗುತ್ತದೆ. ಎಲ್ಲ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿ 13 years ಆಗೋಗಿದೆ. ಅರ್ಲಿಯರ್ ಖಾತಾ ಟ್ರಾನ್ಸ್ಫರ್ ಯು ಲಾಸ್ಟ್ ಮೈ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಲೆಕ್ಚರ್ D page 23. It was already standing in the name of the club.
Yes.
Annexure D.
Yes.
E, F, G.
So you filed an appeal. Appeal alone.
I filed an appeal. Appeal rejected.
What are the grounds?
Grounds is 17.
72, they have taken a
like
72. Real approval from the government, Lord. If it is exceeding for 5 years or amount 25,000.
ಇಸ್ಕೊಂಡು ನೀವು ಖಾತೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ ಈಗ ಈ ತಕರಾರು ಮಾಡೋ ಸರಿ ಇಲ್ಲ. 13 ವರ್ಷ ಏನ್ ಮಾಡ್ತಿದ್ರಿ ಹಂಗಾರೆ ನೀವು?
ಹೇಳಿ.
Basically, the resolution I brought the copies, called for the record and brought the entire paper from the municipality. There, the resolution itself is a defective. They corrected the resolution for regarding the dimension. Second point is that, my lordship, sir, earlier it was a town recreation.
When did you correct the measurement? When did you correct the measurement?
Somebody has manipulated the resolution itself in the office. And second point is that, my lords, this is the new club was registered before the registering authority. It was not continued registration of the World Recreation Club. The president was died. Later on, not this was
all these conditions not there in your order.
This, my lordship,
These are new conditions coming up.
it was not placed.
Now again name change ಆದರೆ ಅದಿರಬಹುದು ಅಂತ.
But they are not.
What we saw is you don't want it because of problem that may be caused to the water tank.
As per their submission, if previous club was continued and the name was changed by the way of license, then it is a old school, wherein it's a newly constituted club. They are no way concerned with the property.
Just a moment. You issued them a notice.
There we have not taken the context. I do consider.
How you can't take this context?
I do consider, but
you can't make them answer something which you are not.
Regarding the registration, I am submitting, my lordship.
That also you can't.
But
it's not the basis.
But section 72 will come in the municipality act. They have to get.
That is also not something that you have taken in your.
They have not taken there. We are
bring. It may be right, but you can't bring in those things now.
In fact, my lord, that the property which has been going to be expecting from the petitioner, it is surrounded by a water tank, and water tank is supplying the water.
If you want to take action, sir, but take it rightly. Give him reasons. Let him respond.
But sir, regarding section 70
you
only.
Keep something in your head and you do something else.
But regarding 72 only, they have enlightened, my lord.
That is not part of your order.
Deputy Commissioner orders is regarding 72 only.
You take action as per that, they'll reply. If they have a reply, it will have to be considered. And if it is valid, you will have to withdraw your.
Please, my lord.
But you can't give something and pass orders on something else.
The person who claiming the land is no way concerned to the said property.
Give them a notice.
Next, I will cast the notice on that.
Petitioner is before this court seeking for the following relief. The grievance of the petitioner is that land in question measuring 50 by 50 the Petta Road, Ruekere Town, had been allotted to Town Recreation Association, a society registered and the provision of the Society's Registration Act, in terms of resolution passed by the second respondent on 15/4/1987. Subsequent to the name of Town Recreation Association was changed to the Town Club, and as such necessary correction data was requested to be made, which came to be rejected by the second respondent by issuing endorsement on 17/3/2020 as per Annexure H, containing that the said change in Kata could not be made in view of section 72(2) of the Karnataka Town Municipal Corporations. Karnataka
Municipal Act.
Municipalities Act
1964. 1964.
It is in that background that the petitioner is before this court. The M.B. Chandrachуда and counsel for the petitioner submit that no such contention could have been taken under no such rejection could be made under section 72(2) for the reason that the resolution passed for allotment of land was made on 15/4/1987, and the Kata stood in the name of Town Recreation Association until an application for change of Kata was made. Now, after a period of nearly 20 years, competence of the resolution could not be challenged. Shri Manjunath Prasad, Learned Counsel for Respond number 2 submits that the Municipal Council did not have the power to pass such a resolution. Resolution being bad in law, the transfer of Kata has been rejected. The application for transfer of Kata has been rejected. And the appeal subsequently filed before the third respondent has also been rightly rejected. Also, cases. Admittedly, the application which is being made is for change of Kata from the town recreation association to the town club. When such an application is being made, an endorsement could not have been issued that the earlier resolution which had been passed approving the allotment in favor of the petitioner was unauthorized or not competent. If that was the case, the second respondent ought to have taken independent action against, as regards the earlier resolution dated 15/4/1987. No such action being taken. The transfer of Kata cannot, the change in the Kata holder cannot be rejected by issuance of endorsement. As such, I pass the following order. Petition is allowed. The endorsement dated 17/3/2020 passed by the second respondent Annexure H and order dated 2/7/2021 passed by the Deputy Commissioner at Annexure J are hereby quashed. Liberty is however reserved to second respondent to initiate such proceedings that may be available in accordance with law and provide necessary opportunity to the petitioner to reply to the same.
Complaint was given.
R5 where?
R5
Private.
Constructing a building illegally without obtaining sanction.
And you don't want to pay process fee.
Relax.
And you don't pay process fee.
No, I have already paid.
Whenever.
Emergent notice was ordered, Milan. I paid and the the RPAD. ಅಲ್ಲ ಅದರಲ್ಲಿ ನೋಟ್ ಇದು intimation has been delivered ಅಂತ ಇದೆ ಸ್ವಾಮಿ. Intimation has been given by the postal authority.
Insufficient records.
However, we not 21st February.
Carrying out construction in that very address. Are insufficient address and bandide andre artha.
ಅಲ್ಲಲ್ಲ ಅವರ ರೆಸಿಡೆನ್ಷಿಯಲ್ ವಿಳಾಸಕ್ಕೆ ಕಳಿಸಿ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಅಡ್ರೆಸ್ ಕಳಿಸಿ.
Insufficient address. Which is the address where the construction is happening?
Construction is at Bannerghatta Main Road, number 15/1, 5th Main.
So you're not paid process fee for that address?
On that address, the residential address is there, Milord, that is. For that's only we have paid the process.
Have you paid process for both address or only one address?
I will pay both address. Group 1 Padya, that
A
address.
simple thing which you should do.
The construction.
You have shown the cost title both address.
Both address.
Council for the petitioner seeks for.
Respondent authority. Not taken any action, Milord. That is why I have filed IA 1 of 23, showing the photographs. The day to day, the construction is going on fastly, Milord, but illegally. That is blocking my passage, Milord. I have left the passage, but they have not left. The RPI has not left out the passage. The constructing illegally, Milord. Photograph may kindly grant stay, Milord.
Let me see. Next year, K, page 39.
Take instructions, my lord, protect the authority. What action they have given the representation also, my lords. For 2 weeks, my lords, I'll file my objections also.
So what engineer allow this kind of things to happen?
My lords.
What engineer allow these kind of things to happen? Annexure K nodidra you one color photographs ಕೊಡಬೇಕು ನೀವು photocopy ಮಾಡಿದ್ರೆ ಅದರಲ್ಲಿ ಏನು ಗೊತ್ತಾಗಲ್ಲ ಅವ್ರಿಗೆ ನೀವು ಮಾತ್ರ ಕಲರ್ ಇಟ್ಕೊಂಡು ನಮ್ ಕಲರ್ ಕೊಟ್ಟಿಲ್ಲ
ಇಲ್ಲ ತಮಗೆ ಇಲ್ಲ ನಾನು ಕಲರ್ ಇಟ್ಕೊಂಡಿಲ್ಲ ಕ್ಲಿಯರ್ಲಿ
ನಿಮ್ಗೆ ಗೊತ್ತಾಗ್ಬೋದು ಅವ್ರಿಗೆ ಕಾಣಿಸಲ್ಲ ಅಲ್ಲಿ ನೋಡಿ ಅದು
Take instructions, my lords.
Even a cat can also not to enter this passage.
Very bad. I keep concerning. We have been quite till this, till that put up so much construction.
But I am told that they have issued a notice to the respondent number 5, but no action is taken.
If necessary process fee is paid to both the addresses of respondent number 5, registry is directed to issue emergent notice to respondent 5 written out by 17. In the meanwhile, respondent number 4 is directed to inspect the premises in question and submit his report as regards whether the construction is being put up in pursuance of plan sanction and if the sanction plan is adhered to. We list on 17. Emergent. What would the process be? I will.
Little early.
Emergent notice, we can't come back by 10. 17. You paid today only.
We have to affidavit according to mayor and deputy mayor. Only have tomorrow, I file my affidavit. It's ready. Tomorrow.
And council, and AGA seeks for and is granted 2 days time. The file is to comply with the order dated 2/3/2023. Relist on 20 on 30th.
Thirty-one.
Petitioner by me, my lord.
First response.
Construction on the land, my lord, belonging to the petitioner. Lord, the petitioner is before my lordship. Lordship may kindly see, my lord, on page number 144.
Read by the construction, respond number 7.
Lord, BBMP, my lord, respondent number
Who is putting up construction?
5, BBMP.
BBMP is putting up construction. Why do you have respond number 6 and 7?
Lord, they also, my lord, encroach the land, my lord, belonging to the petitioner. I'll invite my lordship's attention to page number 144. My lord, order passed by the DC, my lord, remanding the matter to the Assistant Commissioner for fresh adjudication. On 146, page number 146, and I kindly permitted to read. ಕಡತದಲ್ಲಿ ಲಭ್ಯ ಇರುವ ದಾಖಲಾತಿಗಳಂತೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಎಂಆರ್ ನಂಬರ್ 6, 62, 63, 69, 70 5 ಮ್ಯೂಟೇಷನ್ಗಳನ್ನು ಎಂಆರ್ ನಂಬರ್ 615, 1605, 1689, 1862, 1935 ಮತ್ತು 1973 ರಂತೆ ನಮೂದಿಸಿರುವುದು ಕಂಡುಬರುತ್ತೆ. ಹಾಗೂ ಅರ್ಜಿದಾರರು ದಾಖಲಾತಿಗಳ ಸ್ಪಷ್ಟ ಪ್ರತಿಗಳನ್ನು ಸಲ್ಲಿಸಿರುವುದು ಕಂಡುಬರುತ್ತಿಲ್ಲ. ಒಟ್ಟಾರೆಯಾಗಿ ಬಿಳಿಕನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ದಾಖಲಾತಿಗಳ ಎರಡನೇ ರೀಕ್ಲಾಸಿಫಿಕೇಶನ್ ಪ್ರತಿಯಂದೇ ಸರ್ವೆ ನಂಬರ್ 154ರಲ್ಲಿ ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 29 ಎಕರೆ ಇದ್ದು ಖರಾಬು 20 ಗುಂಟೆ, ಜಾತ ವಿಸ್ತೀರ್ಣ 29 ಎಕರೆ 4 ಗುಂಟೆ ಎಂದು ಕಂಡು ಬಂದಿರುತ್ತೆ. ನಂತರ ಸರ್ವೆ ನಂಬರ್ 154/11 ಎಂದು ದಾಖಲೆ ಇದ್ದು ಒಟ್ಟು 11-13 ಖರಾಬು, 7 ಗುಂಟೆ ಉಳಿಕೆ, 10-36 ಎಂದು ದುರಸ್ತಾಗಿರುವುದು RRT ಪಕ್ಕಾ ಬಲಭಾಗದ ಪ್ರತಿಯಂದೇ ಕಂಡು ಬರುತ್ತೆ. ಮೂಲ ಸರ್ವೆ ನಂಬರ್ 154ರಲ್ಲಿ ಖರಾಬು ಕೇವಲ 20 ಗುಂಟೆ ಇದ್ದು ಸರ್ವೆ ನಂಬರ್ 154/11ರಲ್ಲಿ ಕೇವಲ 7 ಗುಂಟೆ ಖರಾಬಿರುವುದು ಕಂಡು ಬರುತ್ತೆ. ಈಗ ಅಂದರೆ 75-76 RTC ಅಂತೆ ಒಟ್ಟು 11 ಎಕರೆ 3 ಗುಂಟೆ ಖರಾಬು 7 ಗುಂಟೆ 32 ಎಕರೆ, ಜಾತ 311 ಎಕರೆ ಎಂದು ಹೇಗೆ ಬರಲು ಸಾಧ್ಯ? ನಂಬರ್ 527 ದಿನಾಂಕ 13/8/1872ರಂತೆ ಸರ್ವೆ ನಂಬರ್ 141ರಲ್ಲಿ ಉಳ್ಳ ಜಮೀನು ಇತರ ಸರ್ವೆ ನಂಬರ್ಗಳೊಂದಿಗೆ ವಹಿವಾಟಾಗಿರುವುದು ಕ್ರಯಪತ್ರದ ಪ್ರತಿ ಮತ್ತು ಋಣಭಾರ ಪ್ರಮಾಣ ಪತ್ರದಿಂದ ಕಂಡುಬರುತ್ತೆ. ಈ ದಾಖಲೆಗಳ ಮೂಲ ಪ್ರತಿಗಳನ್ನು ಪಡೆದು ಪರಿಶೀಲನೆ ಮಾಡಬೇಕಾಗಿರುತ್ತೆ. ಎಂಆರ್ 154 1991-92ರಂತೆ ಅರ್ಜಿದಾರ ಸೊಸೈಟಿ ಹೆಸರಿಗೆ 5 ಎಕರೆ ಜಮೀನು.
Interim prayer that you are seeking. Interim prayer you are sought.
Interim prayer.
There is no interim prayer, my lord. Lord, may kindly look into prayer, my lord. They'll have to go before.
You are asking for a mandamus to restrain construction.
Still in injunction nature, my lord.
And file this.
Permitted to approach the civil court, my lord. Liberty to
This
approach.
is that property on where Apollo Hospital is sitting.
Please, my lord. Originally, it was granted to Cancer Institute. Thereafter, my lord, they entered into an agreement of sale. Then, my lord, grant was cancelled.
It's not a civil suit filed by the petitioner, which came to be dismissed.
Liberty to approach the civil court, my lord, in respect of.
Already dismissed again.
No, my lord, this 2 acres 30 guntas of land, where, my lord, the construction is taking place. To that extent, my lord, I may be permitted to.
It filed a suit and the suit had already been dismissed. Now you want to file another suit because they are going to give you permission.
That has been disposed of, my lord, even in RFS law. It was not considered since this.
You remember something of this coming before?
My lord, the application was pending before the Assistant Commissioner. My lord,
He won't grant you liberty to file. He'll only say that this is not permissible. If already a suit has come and RFA is done, you can't misuse this order. File another fresh set of litigation.
in respect of this particular piece of land, my lord, because it has to be adjudicated by the Assistant Commissioner.
You produce that RFA and counsel for the petitioner seeks for and is granted a week's time to produce the decree passed by civil court as also the judgment rendered by this court in the regular first appeal. Relist on Six.
Right. Property tax demand, actually A and B, my lord. I'm petitioner number 1 is a society, and petitioner number 2 is an educational institution running under the society, my lord. Section 110 of the KMC Act.
The orders passed. The lagilwa. This is there.
Under the.
Division bench order.
WP 6432 of 2023.
WP 6432
of 2023.
2023. 3. Connect the above matter with
Subject to
Pawan Kumar accept notice.
In fact, my lord, thus far I have paid 1.84 lakhs. Already paid, my lord. Tax. I have also produced the tax.
Accept notice for respondent number 1 and 2. The petitioner is before this court challenging the demand made of property tax amounting to rupees.
2 demand notices. One to 93 lakh.
ಎಷ್ಟು payment ಮಾಡಿದೀರಾ?
1.84 lakhs is paid, my lord. It's a reduction.
20 lakhs is the demand.
Oh, well, no, I'm just bringing to the notice of this honorable court. In a 25% I pay, but 1.84 I paid.
We saw it twice to see if we had missed out, taken one more number into account.
No, my lord. 2 notices were issued, my lord, on the same day.
The demand notices issued at Annexure A and B. In view of the order passed in WP 6432 of 2023, the said demand notices are stayed subject to the petitioner making payment of sum equivalent to
25%.
25% of the demanded amount. Connect with 6432 released on 11/4.
As per the annexure A, my lord, as per the annexure A, that is the advertisement of for allotting the sites for Shumagga, my lord, Suguru village, Shumagga, my lord.
Same.
On that basis,
Same series, sir. Shumagga.
is Suguru village. The site put
Number yavudu? AG accept notice for respondent number 1, 2. Housing board yaru?
Guru Raja Ganchi Mat, my lord.
Also accept notice for respondent number 3, 4.
Sorry, Gurudeva Ganchi Mat.
Gurudev Gachin Mat
Please.
accept notice for housing board.
Gachin Mat.
Gurudev Gachin Mat is in Dharwad, not here.
Our wife is there.
Sumangala Gurudev Gachin Mat accept notice for respondent number 3, 4 yaru?
Ashwin Halani. Ashwin Halani.
Ashwin Aladi accept notice for respondent number 4. In view of the orders passed by this court in WP number so and so, the respondents are restrained from cancelling any of the sites allotted to the petitioners to the next date of hearing. Connect with so and so, release and so. Now to the 6th April.
Annexure.
The urgency to move it with
Not annexure, not actually in the lordship directed to post on 23rd Milan urgency. By mistake, not it was not noted down. Therefore, I moved it again. Supersession order Milan, the resignation Pottidaranta. On 16/3, they submitted resignation.
But your interim order, what you are asking?
Not yes, Milan, I need to correct it. I'm sorry, Milan, I need to correct it. On 16/3, Milan, they submitted the resignation. On the very same day, Milan, the order of appointment of a special officer is passed. Now 29B says not only after the expiry of 15 days, not that can be done. And more so, not the petition number 7 and 8. Not they have now withdrawn it. Not they have submitted the withdrawal letter to the CEO, and along with the affidavit that they under pressure, not they had resigned. Now they have given the withdrawal application also. Not without waiting for 15 days, not this order is passed. 29.
I'll give an ex parte order. Get instructions.
Submission, madam. This is an order for.
Instructions bandidya? You have instructions.
Please, madam.
Okay.
Instructions in the sense, the provision is very clear. This is an order under section 31(1) of Cooperative Societies Act. My first submission is that there is an alternative remedy of appeal under section 106. And a plain reading of this provision, Millards.
31(1).
Please. Appointment of special office, the registrar. Where the registrar is of the opinion that a cooperative society is not functioning in accordance with the provisions of the act, rules or bylaws on account of the number of members of the board, falling short of the required number to form a quorum due to disqualification, resignation, or death or removal of a member, the registrar may, notwithstanding anything contained in this act, rules or bylaws by order, appoint a special officer for such cooperative society for such period not exceeding 6 months. There is a clear line, my lord.
6 months.
Notwithstanding anything contained in this act, rules or bylaws. And your lordship may kindly trust.
Is the appeal provision?
Is it 106 minutes?
Not 6 alle barata ella.
Please.
Fast and
Lord, I am not
section 1 of 31.
Lord, I am not disputing about section 31.
There
is a provision for appointment special officer. Lord, kindly see section 29B for a moment. 29B. And then, my lord, I'll read 29E also. There is a provision for co-option also. 29B. Resignation of members of a board or office bearers of a cooperative society. A member of a board of a cooperative society or an office bearer of the cooperative society may resign his membership of the board or as an office bearer of the society, as the case may be, in writing, under his hand addressed to the chief executive, and it shall become vacant on the expiry of the 15 days from the date of such communication, unless within said period of 15 days, such member of the board or office bearer withdraws such a resignation in writing under his hand and addressed to the chief executive. Now, without, on 6/3, they tendered the resignation. On the very same day, 6/3, appointment of a special officer order is passed without waiting for the statutory period of 15 days. And petitioner number 7 and 8, they now submitted their letter of they're withdrawing their.
When did they withdraw it?
Withdrawal on 6/3.
6/3.
Yellow 6/3.
6/3.
Yeah, Ibru bittu. 5 jana 6/3. The petitioner number 7 and 8, they gave a letter saying we are now taking back that resignation letter on 8/3, which is addressed to the CEO as well as the deputy registrar. Now, your lordship can you recollect, this is the very same society where the other day, they wanted to supersede when there is no share capital. That's why the government took time.
Why do they?
Somehow,
why do they like your society?
I know, my lord, somehow they want to supersede the society.
That order, my lord, I only submitted on instructions that.
Yes, my learned friend submitted.
I am to appointment of administration.
Not speaking of you.
I'm not speaking. I'm pointing out
about you. You are fair and
Please. In view of 31(1), my lord,
see,
notwithstanding anything contained in this act.
that cannot give a go by to 29B, where there is a precondition. You are without jurisdiction.
And with regard to 106, my lord, appeal provision.
You are without jurisdiction. Whirlpool Corporation will apply. You don't get jurisdiction until 15 days.
But what about this, my lord, 31(1), notwithstanding anything contained in the act, bylaws, rules?
We will deal with that. Petitioner is before this court, speaking for the following reasons. The contention of the petitioner, the grievance of the petitioner is that a special officer has been appointed in respect of respondent number 4 society without waiting for the 15-day period prescribed under section 29B of the Karnataka Cooperative Societies Act 1959 bracket KCS Act. Prasad Shettilar and council submits that on 6/3/2023, five directors with their resignation and there being no quorum, respondent of two excised powers under subsection 1 of section 31 and appointed a special officer. He submitted the power to appoint a special officer under subsection 1 of section 31 has to be made only if the requirements under section 29 capital B are fulfilled. Without such fulfillment, no power under subsection 1 of 31 can be exercised. Out of the 5 directors who had submitted their resignation, he submitted that on 6/3/2023 itself. How many?
8/3/2023. Petition number 7 and 8.
On 8/3/2023, petition number 7 and 8 had withdrawn their resignation, thereby the quorum was fulfilled for holding of the next meeting. This fact, having occurred on 8/3, which is a period of 15 days, the third respondent has acted in haste under subsection 1 of section 31. And in that background, he submitted that the relief sought for are required to be granted. And AGA would however submit that in terms of subsection 1 of section 31, a non-obstante clause is present where the registrar has been provided with powers to appoint special officer notwithstanding anything contained in the Act, rules or bylaws for a period not exceeding 6 months. In that background, she submits that the appointment of a special officer cannot be circumscribed by the requirements under section 29 capital B, and as such the appointment is proper and correct. She further submits that an order passed under subsection 1 of section 31 is an appealable order in terms of section 106 bracket 1E1, and as such the petitioner may be relegated to an alternative remedy of an appeal under the said section 106. Third, also presented. The short question that would arise for consideration of this court in the present matter is whether the non-obstante clause in subsection 1 of section 31 can be read, can be excised, can confer power on respondent number 3 to be excised beyond the requirement under section 29 capital B of the KCS Act. Section 29B reads as under. A perusal of the above provision would indicate that any member of the board of a corporate society or office bearer may resign his membership in writing by his hand addressed to the chief executive, but further provides that the said post shall become vacant on the expiry of 15 days from the date of such communication, unless within the said period of 15 days, such member of the board or office bearer withdraws such resignation in writing under his hand, addressed to the chief executive. It is therefore clear that even though a resignation may be submitted, the person who has submitted the resignation is given a period of 15 days to withdraw the resignation. It is further clear that the resignation does not come into effect or become effectual on the submission of the resignation, but will become effectual only after a period of 15 days, unless it is withdrawn. To put it in other words, if the said resignation is withdrawn within the said period of 15 days, then in law and fact, there is no resignation which can be said to be in place as on that date. From and on the date of withdrawal, thereby the post would not become, consequently, the post would not become vacant. Section 31(1) reads as under. A special officer can be appointed if, in the opinion of the registrar of the cooperative society, the cooperative society is not functioning in accordance with the provisions of the Act, rules, or bylaws, on account of the number of members of the board falling short of the required number to form a quorum due to disqualification, resignation, or death, or removal of member. In the present case, what is of relevance is resignation and not disqualification, death, or removal. The resignation, as held above, would come into effect only after a 15-day period. In the present case, the resignation submitted on 6/3/2023 has been withdrawn by petition number 7 and 8 on 8/3/2023. Therefore, the said resignation are ineffectual. When they are ineffectual, the question of exercise of powers under subsection 1 of section 31 would not arise, since the required number to form a quorum continues to exist on account of the withdrawal of the resignation. The contention of learned AGA, by relying upon the non-obstante clause in subsection 1 of section 31, that the registrar may appoint a special officer, notwithstanding anything contained in the Act, rules, or bylaws, for a period not exceeding 6 months, is a power vested with the Registrar of Cooperative Societies to be exercised judiciously by applying his mind, and if circumstances so demand, the said power cannot be exercised arbitrarily at the whims and fancies of the registrar. Be that as it may, any order passed by exercising the powers under the non-obstante clause would necessarily have to be coupled with reasons as to why a special officer is appointed to a cooperative society. But notwithstanding the other provisions of the Act and rules. In the present matter, as can be clearly seen from Annexure C, the special officer has been appointed only on account of there being a resignation being submitted by some of the members, and not for any other reason. Thus, the exercise of powers under subsection 1 of 31 made by respondent number 3 is under the first portion of subsection 1 of 31 and not under the non-obstante clause. Having held that the resignation had not been effectual, the third respondent could not have exercised powers on 6/3/2023 to appoint a special officer, since the third respondent would derive power to exercise, could exercise such power only after the expiry of 15 days of the resignation being submitted in terms of section 29 capital B of the KCS Act. The resignation has been submitted on 6/3/2021. The resignation would have come into effect on 21/3/2023, if not withdrawn before that date. The moment a resignation is withdrawn, the powers under section 29B cannot be exercised. The last contention of learned AGA is that there's alternative efficacy remedy in terms of subsection E1 of clause E1 of subsection 1 of section 106. An alternative efficacy remedy needs to be efficacious in nature, and the order which is challenged should have been passed by an authority having jurisdiction to do so. In view of my above finding that there was no power which could have been exercised under subsection 1 of section 31 by respondent number 3, the said order being without jurisdiction, I have the custody opinion, the said order is required. The ordinative efficacy remedy, the ordinary remedy is not efficacious one. In view of the above, I pass the following order. The certiorari petition is allowed. The certiorari is issued. The order passed by respondent number 3 dated 6/3, hearing number so at Annexure C is hereby quashed.
Authorized action to issue building plan. Development plan already issued by the BDA.
When did you submit? When did you submit?
It was, I have submitted through online on 16/12/2022.
16/12?
Yes.
16/12/2022.
Yes.
ಎಷ್ಟು ದಿನ Mr. Plan sanction?
Done online process there, 30 days I think. I'm not sure, but 30 days.
Sakala, 30 days.
Online endorsements will be issued if there is some lacuna on the part.
Nothing has been issued.
I will just take
You would not have come.
inspection and like what happened to
Pawan Kumar accepts notice for respondent number 1 and 2. That is request released on 30th.
Petitioners are the block owners in Tirumala Maharlika apartment. This is the second round of litigation. Way back in the year 2016, the respondents authorities have issued the notice under section 321 sub plus 1 under the provisions of the KMC Act. That notice, which was at page number 76,
Yes.
Agreed by the said preliminary notice as well as the confirmation order, the first petitioner alone filed the appeal before the Karnataka Appellate Tribunal, Your Lordship. In the said appeal, Your Lordship, the complainant, who is the neighbor owner of the said apartment, that is one, namely Srinivas Kongavi, has filed his application for his implement under Order 110 subclass 2 of the CPC. Your Lordship. His implement was dismissed by the Honorable Karnataka Appellate Tribunal, Your Lordship.
Yes.
Agreed by the said order, Your Lordship, he has prepared the writ petition. The said writ petition also came to be dismissed, Your Lordship, regarding his implement is concerned.
Yes.
That order was challenged before the division bench of this honorable court, Your Lordship. In the said appeal, writ appeal, Your Lordship, the court was remained the matter to the single learned judge, that is, which was pending in respect to the order which was passed by the appellate tribunal. That is, final order was passed by the tribunal, Your Lordship.
Where is the final order?
Final order of the Karnataka Appellate Tribunal at page number 157, Your Lordship. That is a translation copy. That 144, original order, page number 144, Your Lordship.
So 321(3) was
Set aside, Your Lordship. The question is, Your Lordship, kindly, this order, that final order,
what ground was it?
there was no opportunity was given. Non-compliance of order of partner. Then the preliminary order as well as confirmation under section 321 and 321(3) was set aside, Your Lordship.
Thereafter, Your Lordship, the said order was challenged in writ petition number.
Filed by third respondent before the Karnataka High Court, it's shown to by the appellant that is voluntarily removing violated person.
In respect to the locus standi is concerned, Your Lordship,
What has been observed is that you are voluntarily removing the excess construction. Page 164. Recorded the affidavit which has been filed. At 12:13.
That actually, that exercise was done, Your Lordship. The portion of that deviation which was removed, after removal of that, Your Lordship, kindly, the writ petition, in the writ petition, Your Lordship, regarding locus standi of the complainant.
Yes.
At page number.
You're not on local, you are challenging a 248(1) notice. So why are you arguing on locus standi? It's not relevant now.
Your Lordship, kindly, I will come to that portion, Your Lordship.
You want to file it out against respondent number?
Why, Your Lordship, kindly, Your Lordship, and request Your Lordship to take page number 197, Your Lordship. That was the relevant portion.
197.
197, Your Lordship.
Yes.
Accordingly, the writ petition is disposed of, reserving liberty with the respondents BBMP to take appropriate action in accordance with law in the light of the report submitted by the respondent BBMP. The said exercise shall be concluded strictly in accordance with law after notifying the interested parties. All the contentions are kept open, including question of locus standi of the petitioner to maintain subsequent proceedings, if any, in pursuance of any actions to be taken by the respondents BBMP. Your Lordship. Your Lordship, this is there was no locus standi, which was the point of locus standi, which was not at all considered by the
Mr. Counsel, is there a deviation from the sanction plan by you or not?
That is clear contrary by each other. The report submitted by the respondents, Your Lordship. One report says that there was a deviation. Another report says that this is a portion.
Where are those reports? Sure.
Your Lordship, kindly. Kindly at page number 76, Your Lordship.
76. Yes.
Kindly, Your Lordship, differences between measurement of the building as against the sanction plan. This is the first report, that is a preliminary notice which was issued under section 321 sub plus 1.
Yes.
In terms of the said notice, Your Lordship, the differences in construction 6.83.
That is the ground floor.
That is in ground floor, Your Lordship.
First floor is 61.27.
61.27, Your Lordship. Your Lordship, the second, that is second notice at page number 198, Your Lordship. Basement floor, kindly at page number 199, Your Lordship.
Yes.
18.56% in basement floor, Your Lordship. Ground floor 18.56 and first floor 18.56%. As per the first report is concerned, the deviation 61.2%.
You removed some of it.
I am removed some.
Before the KAT, you agreed to.
Yes, I am removed.
But you have not removed everything.
No, Your Lordship, there is no deviation at all. Even Your Lordship kindly appoint any third party experts to verify. Even there is no deviation, only under the influence of that neighbor, that is the complainant. Again and again, these petitioners were suffering, Your Lordship, because these petitioners who are purchased the plots from the respective landowners as well as the developer, Your Lordship. This petitioners, the first proceedings which was taken place from the instance of the only the owner, that is the petitioner number alone, Your Lordship. Now, these notices issued against to all the who are respective owners in the apartment, Your Lordship. My humble submission, Your Lordship, kindly see, there is no deviation at all. Even Your Lordship kindly appoint any expert to analyze the building deviations, Your Lordship.
Email allegation. You can't go and measure. Who will measure? Who can we appoint?
Under the intervention of this honorable court.
Executive engineer, higher officer of BBM, my lords.
The allegation is against the corporation that you are polluting.
I've of course not yet entered appearance, my lords, for respondent number 4 and take notice if your lordships.
Get the measurement done. Who can do it?
Please, my lords, I have the only
So
submission.
you give us a name at its cost.
Lords,
Yes, I'm ready to with my cost.
my lords, if I may make only one submission, the deviation has been taken note of by this honorable court, my lords, and so what, my lord, the order, of course, I don't have a copy of the writ petition, but the writ petition order that my lord, my learned friend read out, in that the previous paragraph, your lordships may please see. This is the order, my lord, dated 10th January 2025.
Page number? Yes, 10 January. 45073.
Please, my lord. Your lordships may please see para 3, my lord. This exercise was done during the pendency of that writ petition. I'll read, my lord, with your lordship's permission. During the pendency of the writ petition, in pursuance of order dated 28/11/2017 passed by this court, respondents BBMP have submitted a report before this court along with a memo setting out the detailed deviation made by the private respondent in violation of building laws and sanction plan. In pursuance of the said report, respondent BBMP claims to have issued notice under section 248 of BBMP Act. In view of the subsequent report filed by respondents,
Vijay Kumar
Shanmugam.
The petitioners were not, all the petitioners were not parties.
Parties.
Please, my lord. But this petitioner was also a party. So,
no, the petitioner.
Please, my lord. That is quite so. So, my lord, my only submission is that this exercise has taken place on multiple occasions. In fact, all that the court said, my lord, in the earlier round was that the deviation is not in dispute. The BBMP can take action in accordance with law.
In their absence, how could there be said that it is not in dispute?
Very well, my lords. In that case, would your lordships?
That was only that can only be restricted to respond number 1.
Please,
not for others.
I quite see that, my lord.
So who can, who is the third party who can measure? And that is cost. We'll pass over, give us the.
Then your lordship. Let us
pass.
Afternoon.
Oh, sorry. Sorry. Sorry.
Sorry. I am sorry.
Is I waiting?
ಯಾರು ನೀವು ಮಾಡಿದ್ರೆ ನಿಮ್ಮ ಪಕ್ಕದವ್ರು ಮಾಡಿದ್ದಾರೆ
ಮಾಡಿದ್ರು ನಾವೇ ಮಾರ್ಬಿಟ್ಟಿದೀವಿ ಅದೇ ಪ್ರಾಬ್ಲಮ್ Annexure C is the sanction plan, my lord. The right hand side, my lord, to the plan. Now kindly see the photograph at my Annexure D.
Annexure C is a sanction plan. This is whose sanction plan?
Is sanction.
Yes.
Fortunately, we already handed it to us.
What is the site measurement?
60-40.
60-40. 1 meter ಅಷ್ಟೇನಾ setback. 1.47 and 2.20. Yes.
Shed is the photograph. Actually, abutting our compound.
1 meter or 1 feet ಆಗಿದೆ.
Annexure is the actual. The funny part is Annexure E, man. Has given us the actual construction plan also. A lift portion, my lord would say.
Meter
Feet difference.
Marking problem ಆಗುತ್ತೆ. The Pawan Kumar access notice to respond number 1, 2, 3. Emergent notice to respond number 4, returnable by 13th April. The further construction being carried out by respond number 4 in property bearing number so and so is restrained till the next date of hearing. Respondent number 3 shall inspect the above property on 6/4/2023 to ascertain if the construction is being put up in accordance with the sanctioned plan or not. And if not, what are the deviations from the sanctioned plan, and submit the report. Pre-list on 13th.
20. Mistake.
Pre-list on 18th.
Earlier, my lords have given the address in the sale date. My lords can also permit me to take out on the site address. Or not. I don't want to come back with address insufficient address.
Counsel for the petitioner to take out notice on respondent number 4, both at the address mentioned in the first title as also on the address, and the address where the construction is being carried out.
Great.
38.
And against the respondents. Earlier, petitioner has paid a writ petition. Interim.
AGA accepts notice for respondent number 1, KHB Arama. Pradeep Kumar accepts notice for 2 and 3, counsel to serve copies. Objections, if any, by 13th, re-list on 20th.
Milord, 39. 39, Milord.
Yes, please.
Writ of mandamus, Milord. I have been running a shop of chicken since 1994, almost 30 years, Milord. Having a valid license which was renewed in 2000. Forcibly, they have shut down my shop on 8th March 2023 at the instance of some miscreants who wants to open a shop in the same lane, Milord. And more than 24 shops.
Where's your earlier license, madam?
My license is at page number 15, Milord. 14 and 15.
This was enforced till when?
This was till 2001, Milord.
One in the year 2023 or go earlier.
They have not renewed my license, Milord, on the instance of some market being opened, and there are several litigations with respect to that market.
Without a license, you have been running for last 22 years.
Milord, there are 24 shops in the same Moodgiri which not even having a license, the first and foremost, and they have not been touched. Page 8, Milord, I have the details of all the shops. Page 8. Not even having a license, Milord.
So they start with you, they'll go to the others. What is the situation? And are you going to vacate all?
Milord, I have requested in February.
This will definitely issue all the.
They have been there for 22 years. Why now?
Time to time they have to renew the license. After there is a license of 2000, year 2000. Renewal they have not done.
Find out the AGA accepts notice for respondent number 1. Moodgiri.
A. Nagaraja.
Nagaraja accepts notice for respondent number 2. The petitioner. There's a serious allegation made by counsel for the petitioner that apart from the petitioner, there are 24 other shops in the premises against whom no action has been taken.
Including petitioner 24, excluding petitioner. Milord, I may be allowed to run the shop, Milord. I have lost already 2-3 and this is the only source of income I have, and
we have directed them not to interfere.
Please.
AGA and Sri A. Nagaraja to make the submission as regards the above serious allegation by next day. We just come 6th.
Grateful, Milord.
being reviewed by the representation dated 3/3/2023, my lord. My lord, I am the owner of the suit schedule property, my lord, which is adjacent to the construction which is carried out by the respondent number 2 and 3, my lord. The respondent number 2 and 3, my lord, from last 15.
On 1 and 2.
Please, my lord. Please, my lord. Sorry, my lord. 1 and 2 are the adjacent land owners, my lord.
Yes.
It is a vacant site, my lord. They are carrying out the construction work, my lord, in the adjacent land.
Yes.
My lord, adjacent to my property towards the southern side, my lord, there is a rock bed, my lord, which was they are trying to drill the rock bed, my lord.
Yes.
Due to that drilling work, my lord, it is creating cracks in the compound wall, my lord, adjacent to my property, and also it is creating vibrations in the southern side of the building, my lord.
So will you remove the rock and give it to them?
My lord, my only grievance is that, my lord, I don't have any grievance against their work. But my only worry is that, my lord, the residents are there inside the building, my lord. If any cracks and if any foundation is getting affected, my
So
lord.
basically, you want them to stop using their property. So would you be willing to remove the rock and give it to them?
My lord, my only
If you are willing to do that,
my lord,
ask them to pay, you do it and give it to them.
my lord, only I want, my lord, let them take safety measures, my lord, and also one more thing is, my lord, they have not left the space, my lord, which they are supposed to give. Leave.
No construction has happened.
Please, man.
There's a rock there, they're removing the rock, there's no construction. which has happened.
They are starting that, they are removing just adjacent to the property, my lord. Because of that one, my lord, the photos I have produced it annexed to C, my lord. Even
Site measurement.
site measurement is 110 square feet, my lord. My residential property is actually having 110 square feet, my lord, which is 42 by 33, my lord.
What is the setback?
My lord, setback is actually, we have left around 3 feet, my lord.
So they can remove it up to 3 feet.
My lord, they have not left the space, my lord. They are starting to dig the entire.
See your own photographs at page 32.
Please, my lord, they are
Much more into the property.
no, my lord, they are started from the compound wall itself, my lord. The annexure E3, my lord,
Notice
that shows
1 and 2. See,
Construction work is stopped. As per my instruction, whatever.
notice for respond number 3. The Pawan Kumar submits that the construction complained of has already been stopped by respond number 3.
No, my lord, today morning also they are doing it, my lord.
Whatever instructions I have, that they have stopped it because they have not taken any plan or something. Just they were doing the leveling work, my lordship.
Not
No, my lord,
they're removing the.
digging is.
You have to take safety precautions.
Yes. Safety they should.
You can remove it, but all the safety precautions have to be taken.
Yes, sir.
The respond 1 and 2 are restrained from carrying out any drilling work and or construction work. Drilling work to remove the stone boulders in the property and or any construction work till the next date of hearing. The respondents on appearance shall file their statement disclosing the safety measures that they propose to implement for drilling of the boulder without affecting the neighboring properties.
Okay.
Released on 13. Yes.
Well, the loan on
ಎಷ್ಟು ಅಮೌಂಟ್ ಎಷ್ಟಿದೆ
1 crore 70 lakhs.
ಎಷ್ಟು ಕೊಡ್ತೀರಾ
Lordship,
246.
only the principal amount they have
What
calculated.
is the actual amount due today?
The actual amount due is 1 crore 86 lakh 4,729.
186.
4,729.
To settle the issue. Because when we get the loan 2020, immediately the lockdown imposed. So kindly
Now an award which has been passed, you are chairing the award before us. We can only give you a slight indulgence on your payment. It's not a matter of right that you can ask.
given chance to settle the issue.
Really?
Fundamentally, we will settle the issue.
Really, ಎಷ್ಟು ಅಮೌಂಟ್ ಕೊಡ್ತೀರಾ 2 weeks ಅಲ್ಲಿ ಎಷ್ಟು ಕೊಡ್ತೀರಾ 4 weeks ಅಲ್ಲಿ ಎಷ್ಟು ಕೊಡ್ತೀರಾ
25%.
25% in 2 weeks. ಆಮೇಲೆ 4 weeks.
It needs some time to settle.
ಹೇಳಿ ಇನ್ನೊಂದು 4 weeks ಆದ್ಮೇಲೆ ಎಷ್ಟು?
25 into
25, 25, 25 and 25 every 4 weeks. You're getting the money. The contention of Krishna is an amount of rupees 1,86.
18604
Zero.
including all. Actual amount, loan amount is 1,70 lakh.
Low interest ಕೊಡಲ್ವಾ? 04
729, your lordship.
729, which is due and paid by the petitioner to respond number 2. Wherein AG accept notice to respond number 1. You are accepting, madam. Please write your name.
Please do.
Notice for respond number 2. Counsel for the petitioner submits that it is due to the COVID pandemic that the petitioner could not make payment of the due amounts. And if reasonable time is granted, the petitioner will discharge the debt due and liable to pay to respond number 2. He submits that the entire amount due will be paid in 4 equal installments on a monthly basis. That is, 25% of the amount will be paid on or before 25th April, the next 25% by 23rd May, third 25% by 20th June, the last installment by 25th July. His submission is placed on record. He is directed to file an affidavit of the petitioner in this regard. In view of the said submission, the operation of the auction notice dated 27th February 2023 at annexure A to D is paid till the next date of hearing. Released on 12th April for the purpose of filing of the affidavit by the petitioner. The respondent shall, second respondent shall inform the second respondent about the interim order passed by this court and inform the direct the concerned not to take any action in pursuit of the auction. Respondent number 2 shall act on a printout of the uploaded copy of this order without insisting on a settlement. Uploaded copy either or inform ಮಾಡ್ತಾರೆ.
Notices have been issued by the BBMP calling upon that it's an enemy property act.
Property.
Enemy.
No.
This matter was already decided, annexure J. And unnecessary notices and at the annexure J, page 71. Page 72, paragraph 5. On the basis of the documentary evidence received from you, as also those furnished to the above mentioned occupants, it is evident that owners of the property were Indian citizens as on the date of Government of India notification dated 10/9/65. Thereafter till 26/9/77 for the purposes of identifying and taking over Enemy Properties Act under the Enemy Property Act 68. As per section 2B of the Enemy Property Act 1968, the term enemy has been defined. This is what the Honorable Supreme Court judgment is referred. Therefore, the entire matter was closed. Now, my lord, after a lapse of
being regarded as in you or your owner?
my owner,
Your predecessor?
my predecessors.
Are regarded to be there?
Yes, yes. That is Mariam Mirza.
When did you purchase it?
Lord, we purchased the property under a document of sale executed by a execution of the court in execution 1500 of 2004.
In the execution proceeding?
It's a execution proceedings where a specific performance suit was filed.
and the suit was decreed. Sale deed came to be executed by the court in our favor.
When was the sale deed executed?
We have constructed the
Lecture
building.
C, my lord, page 20.
Page?
Page 20.
24.
22, 20.
20. Annexure C.
76, 2020.
The type copy is at Annexure C, page 30.
Was executed and
Yes. And now there exists a multi-storied building, a constructed khata. In regard to the property, BBMP gives khata also in pursuance of all these clarifications. Kindly see page 77, Annexure L. There are as many as number of floors for which taxes are being paid. 15 floors are there. I have produced the photograph at Annexure N.
this notice is the name of your vendor.
Yes.
Who has issued this?
This is
No, there
issued
is a circular on 20.
by a certain.
It's only a circular from central government to identify the properties of the enemy. So there was meeting already held. My lord. Earlier occasions not precipitate with any, but the meeting will go on.
Look at this situation now, Mr. Chitandra. We don't know whether the earlier owner there's a letter which says she's an Indian citizen. Even assuming that she was the enemy of the Indian state. Now for last 20 years, an Indian citizen has bought the property. He is in occupation of the property, he has put up construction on the property. So now you want to treat an Indian citizen as the enemy under that act by taking away his property.
Provisions
Who can you enforce it against?
against the owner.
Against the enemy. Why do you want to enforce it against citizen of the country? The burden of proof will be on you so much that there must be collusion to safeguard the property, it being sold to them and all this. Adella baralla. And sugar.
There is no interim orders against. There are several cases pending in this US court. There are directions for not to precipitate, but meeting will go on. Will not cancel.
Why? Why should it go on against citizen of the country?
It is meeting.
Why should he be subjected to this?
The meeting date is already over.
Why should a citizen of the country be called an enemy of the state? It's a very serious allegation being made to call him an enemy of the state. Very serious.
Kindly, I have to tomorrow or day after tomorrow, I'll get instructions.
Please get instructions.
Please, Lord.
Should do this.
Please.
DG, accept notice for respond number. Oh, respond number 6. Shri Pawan Kumar accept notice for respond number 4 and 5. Shri Shanti Bhushan accepts notice for respond number 1. 2 and 3, Garo.
2 and 3, whatever.
2 and 3,
whatever. ASG.
For 1 to 3. DGSI accept notice for 1 to 3. The respondents are restrained from taking any further proceeding in pursuance of Annexure B till next date of hearing.
Yes.
A short question, the short question that arises in this matter is whether by excising powers under the Enemy Property Act 1968, a citizen of the country can be proceeded against merely on account of the vendor of the citizen being an alleged enemy of the state. Latest on 10th April. Accepting the reasons in support of IA 1 of 23, production of certified copy of Annexure A and B is dispensed with, subject to objections, if any, raised by the respondents. IA 1 of 23 is allowed.
Petitioner,
Yes, Mr.
is pertaining to ground rent.
Ground rent.
Similar entry model, page 132, madam.
Pawan Kumar accepts notice for respond number
R1, R2, ground rent.
3 and 4. AG accepts notice for respond number 1 and 2. Page number?
132, madam.
Review of the order so and so. Can I relist on?
5th April.
5th April. ಎಷ್ಟಿದಾವ್ರಿ ಇದು
200. More than that.
Item 45, I beg to give the petitioner minutes are being led by a senior counsel manager who is on his legs in protocol number 4. Matters passed over minutes and called out at 2:30, maybe some difficulty.
Today there is seniors unavailable. This is a matter.
7
I
madam.
understand, my lord. I need it tomorrow or day after tomorrow. Day after tomorrow.
Tomorrow, manager.
Tomorrow night.
Tomorrow, manager.
At the request of both the councils, relist on 30th.
Much okay.
Yes.
It is made clear that no further adjournment will be done.
Yes. Right.
I speak for petition. Madam, next year, Madam, is the order under challenge. The deputy commissioner, without jurisdiction, Madam, the effect of this order is he cancels the bail deed standing in my name. That is the effect of this order. But pursuant to a appeal filed by respond number 3 and 4, regarding measurements, but annexure G is their appeal under section 306, page 59, my lord, is the appeal. Page 59, my lord, before order, my lord, I will.
Records may have to be called for, my lord, in this matter.
Contention is that there is change in measurement.
My lord, I have purchased the properties under 3 sale deeds, pursuant to which, as per the memo which I have filed in the last hearing date, my lord, Khata has been changed in my name. Thereafter, I have obtained sanction plan for the putting up of construction, and there was some disturbance by the commission. Therefore, I have filed original suit before the court, and there was an injunction order against them. My lord, this appeal is under section 306 of Municipalities Act by my tenants. My lord, they are not saying any independent right as such. In page 59, your lordship may kindly see the appeal which they have filed.
59.
59, madam. They are not asserting any independent right in this appeal. What they are saying is that as page 61, 60 LA, they are giving the details of Khata has been changed subsequently. Unauthorizedly, Khata has been made in his name. Therefore,
Who are respondents?
they are my tenants. They have no locus standi to file this appeal before the deputy commissioner, and this provision itself is not an appellate provision under section 306.
Your tenants have filed it again.
My tenants have filed it, and
by virtue of this, this is in the nature of a public interest litigation. They are not asserting any independent right over the property. Only they are saying that there is no basis for recording the measurements, making khata in my name. That is their grievance made before the commissioner. Well, this provision itself is not an appellate provision. And after filing this matter, he sends a commissioner
or respond number D.
So,
Yes, madam. You appears for respond number one. You appear.
but this annexure A, page 12, my lord, order portion. If there is, what he says is, ಮೇಲ್ಮನವಿಯನ್ನು ಪುರಸ್ಕರಿಸಲಾಗಿದೆ ತುಮಕೂರು ನಗರಸಭೆ ಚಾಲ್ತಿ ಖಾತೆ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ಕ್ರಮವಾಗಿ CL ಜಯಕುಮಾರ್, ಲಕ್ಷ್ಮೀ ನರಸಿಂಹ ಶೆಟ್ಟಿ ಮತ್ತು ಪುಷ್ಪವಲೆ ರವರಿಗೆ ನಿಯಮಬಾಹಿರವಾಗಿ ದಾಖಲೆಗಳನ್ನು ರದ್ದುಗೊಳಿಸಿದೆ. ಈ ಸ್ವತ್ತಿನ ಸ್ಥಳ ನಕಾಶೆಯಲ್ಲಿ ಸ್ಥಳದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಸೋ ಅಂಡ್ ಸೋ ಅಡಿಗಳ ವಿಸ್ತೀರ್ಣವನ್ನು ಮೂಲ ಖಾತೆಯಲ್ಲಿ ದಾಖಲಿಸುವಂತೆ ಆದೇಶಿಸಿದೆ. By virtue of this order, he sets aside or puts into in effect the sale deeds. By virtue of it, I have purchased the property. Property, he registers it in the name of my vendor.
Now, what is the measurement found to be 44 by 33?
Well, that is not the case at all. That this measurement, what he has recorded, is totally incorrect. The vendor had 103 into 140 total measurement which he had. My vendor. Under 3 sale deeds, we have purchased the entire property. But it was 90 old properties. Such extent 103 into 140 is not available. 80 into 130 is available there. Entire property is recorded in my name. These tenants have no independent right over the property. What they say is earlier measurements were less. Therefore, record it according to the earlier measurement only. That's what their submission is. But I have filed the memos as per which 3 khata has been made in my name. Totally. But the sale deeds are at annexure B onwards. There are 3 sale deeds. But at first, the sale deed is 4/11/1991. Annexure B, my lord, it starts. Schedule is at looking at the schedule, my lord. Lots may kindly see the numbers don't tally, my lord. What my lord is saying, my lord, in terms of number.
He'll come to you, Mr. Abhinav. Who are you? You are a tenant.
No, my lord, I'm not a tenant. I'll find. But under first sale deed, dated 4/11/1991.
Yes.
Sixteen, your lordship. East to west 36 at the southern end, 43 at the northern end, up to south 56.
This is khata number 2422
Please me.
and 2421.
That was in 2421 or
2422.
Yes, my lord. This is 2422.
2230. And 2421, 222229. The Nalak Katali Seri, east to west 43.
ಇದು
43 plus 56 by 2 and 48.
56 into 48 by 2.
East to west 36.
36.
Southern end 43, northern end 56.
36 into 43 by 2 plus 56 into 48 by 2. That is one property.
36 into 43 by 2.
Please, madam. That is what 36 into 43 by 2.
48 into 56 by 2.
56 into
48
48 by 2.
by 2.
That is one
First portion.
first part. The second is also annexure C. The date is the same for 1st April 1991. Second sale date. This is Krishna Swami Rao has sold it to Lakshmi Narasimha Shetty. Schedule is 15 into 22 by 2 into 66 into 68 by 2. Page 25. 2027 bar 2153 bar 2225 situated in Ward Mandipet, measuring east to west 15 feet at the southern end.
15 into
22.
and 66 into 68.
Please.
It's a 15 feet common passage.
Common passage.
Bounded by. When the schedule is saying BCHI, look,
It was not produced along with the schedule.
there has to be a schedule because it's been demarcated like that.
And what the next sale deed is page 26. Typed copy hakidi. Typed copy 34 start agutte. 36 last mechanic schedule.
This is 2027 2153 2235.
This is 46 into 44 into 66 into 68 by 2.
Into 56. 56 into 56 by 2.
Yes, that Tata has not been done to the actual extent which is shown in the sale deed. It is lesser than what is shown in the. I have filed 3 Tata certificates as by memo. In that memo, measurement is
When did you file the memo?
I have filed sorry.
2153 235 50 into 60 under that. Say 2153 2235 30 by 66.
Yes, ma'am. That's the.
And again 2153. 40 into 31.
At the move. All the 3 put together, my lord, I have filed a suit against the corporation. In that, I have combinedly given the schedule. That is at page 52 of the.
If you don't produce the sketches, we can't make out.
But sketch, yes, under that it was not filed along with this line.
If the boundary is marking better.
Really, I have the document of that is recorded in cards.
What happened to that suit?
Injunction is granted against the.
Injunction suit.
Yes, injunction suit. My vendor had a property which measures 103 into 140. Entire property under 3 sale deeds he has sold to me.
Each of the schedules mentions alphabets that could necessarily mean that there is a sketch next to that. It should have been registered. So basic thing that you'll have to do is to produce that sketch.
That's what.
So drawing inferences like.
But that part aside, I will produce that certainly. Now, by virtue of annexure A, what the commissioner has done is, he has negated my sale deeds.
We don't know what your sale deeds are for because is to time spent money, we are not able to make head or tail out of it as to which side, what is the area. Because they have described it by a sketch.
In the sale deed,
We can make out. Otherwise, you have a property which is 15 into 22 by 2, 66 into 68 by 2, 46 into 44 by 2, 66 into 56 by 2. How will it match to 80 by 130 that you are playing?
all the three put together, that is the
Jigsaw puzzle in the jigsaw puzzle. So you'll have to place these sale deeds together and show us. That must be there in the sketch. What's your claim, Mr. Abhinav?
But property originally belonged to one T. Shamarao, my lord. My lord, he gave permanent leases, my lord. And we were permitted to put up construction. My lord, dehors that, my lord, some sale deeds are now being claimed. Why, my lord, I interjected, my apologies, my lord. Each of the sale deeds, my lord, show a different municipal number. So therefore, my lord, without taking into account, my lord, permanent leases which have been given and buildings which have come up, my lord, now they are claiming some sale deeds. To justify that, my lord, they create one partition deed in the year 1991. So what the municipal authorities have done is, they have said that originally this khata never stood to this extent. And whatever the khata, my lord, was originally standing in the name of their vendor, my lord, they have transferred it.
Who could respond? The deputy commissioner decide all this.
And our book original measurement measurement because my lord, by over
change on the basis of that he is decided.
No, he did not change. He only restored it to what was there earlier. Now, what is the order that is passed is only restoring it to the extent that existed in his books. So, if my learned friend claims that there is
none of you have filed objections. All oral arguments. 3 sets of respondents. 2014 matter. When will you file and place all these?
This 10 days time.
You also produce the sketches. We can't. Nobody can understand this.
My
at the beginning of the year 2014, objections are not filed by the respondents. 2 weeks time, in the interest of justice, 2 weeks time is finally granted. Objections, if any, to be filed on or before 10th April 2023. If same is not filed by then, the objection will be taken as not filed. Relist on 13th April. It is made clear that no adjournment will be granted. Counsel for the petitioner to also produce the sketches of the property annexed to the sale deeds relied upon by the petitioner.
Point number 6. Riga informed that not the station. Riga, out of station.
You're asking a general question. 2014 matter.
Date next week.
On behalf of the counsel for the petitioner, short accommodation is sought for relist on 5th April.
From petitioners, may I request a password?
Password. Ready?
Yes.
Ready for petitioner.
Soumyaji?
Yes.
Yes.
Or responding to contestant response.
You are 1, 2, 3. N. Nagaraja?
Nagaraj irbeku. Our contestant response.
Contesting respond.
You are ready?
I am ready.
Password.
Kindly have time tomorrow. Kindly have time tomorrow.
49 at the request of counsel for the petition relist on 30th.
Please.
We'll come back in the afternoon.
Number 62, madam. Serial number 62, madam.
62.
Yes, madam. For the respond number 3, madam. I inform the other side also, madam.
Inform.
Please.
62 are the request of council for the. Yenik Becknam time.
Objection, madam.
Fund is granted 2 weeks time finally to file a statement of objection. Objection if any by 13th, relist on 20th.
List number 2, serial number 5. Petition may be disposed of. During the pendency of this petition, the Panchayat authorities has granted the license as well as the plan has been approved. Now the house has been fully completed and house ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾ ಇಲ್ಲ ಪಂಚಾಯತಿ ಅವರು. Those served.
ಯಾರಪ್ಪ ಮೂಡಿಗೆರೆಗೆ?
ಮಧುಗಿರಿ ಪಂಚಾಯತಿ.
ಮಧುಗಿರಿ.
ಮಧುಗಿರಿ.
ತುಮಕೂರು.
ಹೌದು.
Nagarajappa accept notice on number 2. Counsel for the petitioner is filed.
A license along with approved plan.
ಏನ್ ಮಾಡ್ಬೇಕು ಇದ್ರಲ್ಲಿ?
Dispose ಮಾಡಬಹುದು ಅದು.
ಏನಂತ dispose?
It spends on its own millards because
withdrawing. You're withdrawing and ತಗೊಳೋದಾ?
in view of this petition is.
Still have to hear. How can we do that? If you're withdrawing, we can dispose. Indirectly you want it to be allowed.
Infructuous ಆಗುತ್ತೆ in view of.
ಹೇಳಿ ಅದು infructuous and dispose ಮಾಡಿ.
Now I can. ಅದನ್ನ memo in terms of the memo petition.
In terms of the memo it cannot be done. You have lot of.
No. ಅದು ಲೈಸೆನ್ಸ್ ಗೆ 6 ತಿಂಗಳು.
Infructuous ಇದಾ ಹೇಳಿ.
Infructuous.
Counsel for the petitioner submit that the above petition has been rendered in practice. The submission is placed on record. Petition is dismissed from instruction.
Serial number 58, Mala.
Yes.
80, my lord.
Just a moment. We'll come from this side. 58.
This memo kindly be taken on record, my lord.
Memo is not taken on it. 58.
I've carried out the amendment. I need to file the amended petition.
58.
Yes, Mala. I'll keep the other side informed.
The counsel for the petitioner seeks to and is granted 2 weeks.
Just a week's time.
Weeks time to file amended petition.
Yes.
Relist on 6th April.
Serial number 80 was listed today to file objections of respondent number 3. I still have to get the approved draft from the lines, my lord. I will inform the petitioner.
My lords, I'm for the petition, my lords. On the previous date, it's already last chance was given to file a statement.
Are you opposing or are you conceding?
I'm not opposing, my lord. Only the date can be fixed to file an objection.
That is always fixed.
2 weeks.
On the third, my lords. May I request for?
I don't want to seek further adjournment, my lord. 2 weeks.
Counsel for respondent number 3 seeks for and is granted 10 days time to file his objections finally. If objections are not filed by 6th, to be taken as not filed, relist on 10th.
Let interim order may be extended, my lord.
Order earlier granted.
Serial number 39.
Oblige, my lord.
Hand delivery of the order which is passed.
It will be uploaded, madam. Yes.
Serial number 78, madam.
70?
78.
You are for?
For objection. I am appealing for a fourth respondent.
Have you informed the petitioner? And don't mention.
Serial number 36.
36.
Some questions from DDA or PWD engineers may be asked in the survey.
We'll come back. DDA construction ing mad.
PWD. He's asking saying some retired BBMP officials. He's agreeing to it.
Yes, my lord, would your lordships have it after 2 days, my lords? We'll seek instructions on who can be appointed, my lord.
So, for that purpose, give us the name, we'll appoint today.
The difficulty is in contacting the client. I tried in the meantime.
Smartphone, mobile phone.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವರೇ 68 ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡಿಲ್ಲಲ್ಲ?
ಹೇಳಿ ಮೇಡಮ್, ಹೇಳಿ ಸರ್.
68 ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡಿಲ್ಲಲ್ಲ?
ಯಾವ್ದು ಸರ್ ಸೀರಿಯಲ್ ನಂಬರು?
68
ಯಾವ್ದು ಹೇಳಿ?
68
ಸರ್. ಲೈನ್ ಅಲ್ಲೇ ಇರಿ ಸರ್. ಇಲ್ಲ ಸರ್, ಇದೆ
ಇದೆಯಲ್ಲ?
ಇದೆ ಸರ್, ಇದೆ ರೀಚ್ ಆಗುತ್ತೆ ಮಧ್ಯಾಹ್ನ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು.
ತೊಂಬತ್ತಾಗಿದೆಯಾ? ಕ್ರಿಮಿನಲ್
ಎಷ್ಟು ಜನ ಇದ್ರಿ?
ಜಾಸ್ತಿ
ನಮ್ದೇ ಕಂಟಿನ್ಯೂ
ಮೇಡಮ್.
ಚೆಕ್ ಮಾಡಿ. ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ನಾಲ್ಕಿಂದ ನಂದು ಬೇಡ ಎಂಡದಲ್ಲಿ ಇಷ್ಟ
Hearing on IA matter, serial number 97, 97, ಅದೇ ಸ್ಪೆಷಲ್ ಆಗಿ CS ಮ್ಯಾಟರ್ ಅದು ಯಾವಾಗ ತಗೊಂಡ್ರ? ಹೌದಾ?
ಮೆಮೊ ಯಾವ
ಮೆಮೊ ಬಹಳ ಇದೆ ಕೊಟ್ಟಿದ್ದು. ಹೌದು ಅದೇನ್ ಗೊತ್ತಾ ಅದೇನಾಗಿದೆ 33 ರಿಪೋರ್ಟ್ ಹಾಕ್ಬೇಕು, ಅದು ಅಪ್ಲೋಡ್ ಆಗ್ಲಿಲ್ಲ. 17ನೇ ತಾರೀಕು ಸರ್ವೆ ಮಾಡ್ಬೇಕಾಯ್ತು, ಅದು ಅಷ್ಟೊತ್ತಿಗೆ 4967 ಈಗ ಆಗ್ಬಿಟ್ಟಿದೆ. ಈಗ ಆಗಿದೆ ಅಂತಂದ್ರೆ 17ನೇ ತಾರೀಕು ಆದ್ಮೇಲೆ ಆಗಿದೆ. ಅದು ಅಷ್ಟೊಳಗಡೆ ಆಗಿದ್ರೆ ನನ್ಗೆ ADLR ಕಮ್ ಡೇಟ್ಸ್
ಚೆಕ್ ಮಾಡಿ ಹೇಳಿ 30ನೇ ತಾರೀಕು ಆಗ್ತದೆ.
ನಾನು ಶುಕ್ರವಾರ ಹಾಕಿದ್ದೆ ಸರ್ ಶುಕ್ರವಾರ. Serial number 53, next matter. That's all file. Next matter. Top of file. 22277. 231. Continue. Namde. ಇಲ್ಲ 22277.
ಏನು ಇಷ್ಟೊಂದು ವಯರ್ಗಳು
ಇದು ಆಯ್ತು, ಇನ್ನು ಆಗ್ಬೇಕಾಯ್ತು.
ಒಂದು ಎಷ್ಟು ಜನ ಕೆಲಸ ಇದ್ದಾರೆ ಪಾಪ ಮೇಡಮ್ ಮಾಡ್ಬೇಕು, ಇನ್ನು ಜನ ಮಾಡಬೇಡಿ ಅದಕ್ಕೆ.
ಮಧ್ಯಾಹ್ನ ಕೊಡ್ತೀನಿ ಪೆನ್ಸಿಲ್ ತಗೊಂಡಿದ್ದೀರಾ?
ಹೌದು ಮೇಡಮ್.
ಯಾವ್ದು ಸೀರಿಯಲ್?
53.
ಅದು ಆಮೇಲಿಂದ ಇತ್ತು.
Yes.
What officer? Court officer, Bangalore bench.
4053 ನಾಳೆ ಐತೆ ಇದೆಯೇನೋ ಸ್ವಲ್ಪ ಪಾರ್ಟ್ 23 WP $4053
What officer? Kalaburagi bench in the audio clear is
4053 23 WP WP
ಭಾರತಿ ಮೇಡಮ್
ಫೋನ್ ಮಾಡ್ತಾನೆ
ಹೌದಾ ಸರಿ ಅದಕ್ಕೆ ನಾಳೆ ಬರ್ಬೇಕು
ಸೀರಿಯಲ್ ನಂಬರ್
ಹಲೋ
ಭಾರತಿ ಮೇಡಮ್
ಲಾಗಿನ್ ಆಗಿದ್ದೀರಾ?
ಆಗಿದೀವಿ. ಆಡಿಯೋ ಕ್ಲಿಯರ್ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ.
ಸರಿ ಮೇಡಮ್.
ಸರಿ ಸರಿ ಆಯ್ತು. ಸಾಹೇಬ್ರು ಬಂದ್ರಾ?
ಇನ್ನೂ ಇಲ್ಲ. ಅದೇ ಫೋನ್ ವೇಟ್ ಮಾಡ್ತಾ ಇದೀನಿ. ಚೇಂಬರ್ ಇಂದ ಕಾಲ್ ಮಾಡಿ.
ಸರಿ ಸರಿ ಓಕೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್
ಸರಿ ಸರ್.
ಓಕೆ
ಓಕೆ ಓಕೆ ಓಕೆ.
ಟ್ರಾನ್ಸ್ಫರ್ ಆಯ್ತು. ಅಮೌಂಟ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದಮ್ಮ ಈಗ ಫಸ್ಟ್ ಸ್ಟಾರ್ಟಿಂಗ್ ಕರೀತಾರೆ ಇಲ್ಲ 230 ಒಂದು ರೆಗ್ಯುಲರ್ ಎಷ್ಟು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಡೇಟ್ ಏನು ಗೊತ್ತಿಲ್ಲ ನಾನು ಕ್ಯಾರೆಟ್ ಮಾಡಿದ 7.1
ಮೇಡಮ್ ಭಾರತಿ ಮೇಡಮ್
ಹೇಳಿ.
ಮೇಡಮ್ ಕಲಬುರ್ಗಿ ಬೆಂಚಿಂದ ಸಾಹೇಬ್ರು ಬರ್ತಿದಾರಂತೆ.
ಹಾ ಸರಿ ಸರಿ, ಇಲ್ಲಿ ಇನ್ನೂ ಬಂದಿಲ್ಲ.
ಬಂದು ಇಲ್ಲಿ ಸಾಹೇಬ್ರು.
ಓಕೆ ಓಕೆ, ಇನ್ನು ಬಂದಿಲ್ಲ ಇಲ್ಲಿ.
ಸಾಹೇಬ್ರು ಬಂದಿಲ್ಲ.
ಇಲ್ಲ ಮೇಡಮ್, ನಿಮ್ ಹುಡುಕೊಂಡ್ ಬಂದಿಲ್ಲ ಸಾಹೇಬ್.
ಅದಲ್ಲ, ಇವ್ರ ರಿಪೋರ್ಟ್ ಬಣ್ಕಾರ್ ಅವರು
ಎಸ್ ಮೈ ಲಾರ್ಡ್ಸ್.
ರಿಪೋರ್ಟ್ ಬಂದಿದ್ಯಾ?
ಹಾ ಕಳಿಸಿದೆ ಸರ್, ನಾನು 6/3 ಹಾಕಿದೆ ಆನ್ 6/3 ಮೈ ಲಾರ್ಡ್.
ಸರಿ ಸರಿ ಸರಿ.
6/3.
ಡಿವಿಷನ್ ಬೆಂಚ್.
ಮೇಡಮ್
ಸಾಹೇಬ್ರದ್ದು ಇದು ಅಲ್ಲಿ ಅಲ್ವಾ?
ಖಾಲಿ ಇದೆ ಅಲ್ಲಿ ಇಲ್ಲಿ ಬರ್ತಾರೆ.
HCK proceedings. ಸರಿ. MFA 200254 ಏನಾಗ್ತದೆ? ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಅಪೀಲ್ ಮಾಡಿದಿರಾ? ಅಮೆಂಡ್ಮೆಂಟ್ ಕ್ಯಾರಿಡ್ ಔಟ್ ಆಯ್ತೇನ್ರಿ? ಮಾಡಿದ್ರಾ? ಮಾಡಿ ಈಗ. ಆಮೇಲೆ ಇನ್ನೇನು ನಾನ್ ಫೈಲಿಂಗ್ ಹೋಗುದು.
Mr. Bankar?
My lordship, my lord, I submitted the report, my lord, on 6/3/2023, my lord. Memo dated. Along with this memo, my lord, conduct and behavioral report, my lord, dated 24/1/23, and also, my lord, and
6-3 of sent it.
Yes, my lord.
Memo
6-3. The memo, along with memo, my lord, I have produced 2 documents, my lord. 6-3.
Professor Sahib, ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ 6-3?
Just me, my lord.
6-3 ಇದೆಯಾ ನೋಡಿ.
ನಮ್ಮಲ್ಲಿ ಇಲ್ಲ ಇಲ್ಲಿ ಫೈಲ್ ಅಲ್ಲಿ.
ಕೊಡ್ರಿ 6-3 ಇದೆಯಾ? ಇಲ್ಲ ಮೇಲೆ ನಮ್ಮಲ್ಲಿ ಇಲ್ಲ.
Both the files don't have that report.
I submitted in the my lord registry on 6-3 itself, my lord.
ನಮಗೆ ಕಳಿಸಿರಲಿಲ್ಲ ಅದು.
4 weeks, 3 weeks ago.
And also, my lord, the probationary officer's report, my lord, sent by the my lord assistant additional registrar, my lord, High Court, Dharwad, directly to my lordship Bangalore.
We'll ask them to verify. You filed it in Dharwad or you filed it in Bangalore?
Dharwad, ma'am.
We'll ask them to verify.
Please.
The additional SPP submit that the probationer's report, Amele, probationer officer's report.
No, my lord, I submitted, my lord, report of the my lord Central Jail Authority, my lord Belagaum.
What is the Central Jail Authority, Belagaum?
And also, my lord, circular issued by the my lord Director of Prosecution, my lord.
Circular issued by Director.
Yeah.
My lord, PO report is my lord directly, my lord, submitted to the.
PO report is.
Yes, my lord, directly submitted to the court.
By the PO, is it? And that the probation officer has submitted his report directly to this court. Although the file does not indicate the presence of those documents, registry is directed to verify and put up the same.
Please.
Relist on 6th April at 2:30.
Please.
ನೋಡಿ ನೀವು ಚೆಕ್ ಮಾಡಿ ಅಲ್ಲಿ ಫಾಲೋ ಅಪ್ ಮಾಡಿ.
Yes, ma'am. Yes, my lord.
List number 2, serial number 26, Lord, 27, I'm sorry, 27. I request for day after tomorrow.
I
am informed.
27 at the request of the council for the petitioner. ಏನಕ್ಕೆ?
Lord, I have one more matter which may clash ಆಗುತ್ತೆ ಅಂತ ಅಷ್ಟೇ ಇದೆ. But I am ready, fully ready.
Reach ಆಗಲ್ಲ.
The report is also filed for this court, my lord, regarding deviation is concerned.
Report file ಮಾಡಿದೀರಾ?
I am sorry, ಇದಲ್ಲ ಸಮ್ ಇದಲ್ಲ ಇನ್ನೊಂದು.
Deviation ಅಲ್ಲ ಇದು.
It's elimination wordings. I am sorry.
ಇದು ಹೋಲ್ಡಿಂಗ್ ಮ್ಯಾಟರ್ ಆಯ್ತು.
Wording
matter ಏನಾಗಿದೆ?
Advertisement tax.
Advertisement tax.
ನಮ್ಮ ಹೋಟೆಲ್ ಹೋಲ್ಡಿಂಗ್ ನಾನು ಹಾಕೊಂಡಿದ್ದೀನಿ ನನ್ನ ಹೋಟೆಲ್ ಮುಂದೆ. For that they are demanding.
Tax matters ಯಾವತ್ತಿದೆ? ನಾಳೆ ಇದೆ. The request council for the registries that connect the above matter with WP so and so and relist tomorrow.
One more, my friend is asking, one more, 21, my colleague, my friend is not well, my lord, advocate for petitioner. He is not well today. He is requesting for 1 week's accommodation or promote.
Somyaji, accept note, Somyaji? Mandi avre alla?
Mandi avre, Mandi adila.
DJ Somyaji has entered affairs with respond number 1, accepts notice for respond number 2 and 3 also. Registry is direct print his name as such. At the request of council for the petitioner, released on not well,
Not well.
10th of April.
Much.
One matter, a fresh matter, I had moved it for the wrong court, not GM and classification activity. Award is challenged, not they are going to take.
CS award.
Yes, Lord.
ಎಷ್ಟು amount?
Lord, one is 3 crores and one is Lord 17.
Before it comes, you make your this one on 2 weeks guest ಕೊಡ್ತೀರಾ, 4 weeks rest ಕೊಡ್ತೀರಾ, 6 weeks rest.
Now already whatever is the outstanding overdue amount, check ಕೊಟ್ಬಿಟ್ಟಿದೆ sir.
Decide.
Please, please.
Check the amount.
I'll take
End
it.
of the list.
List number 2, serial number 14, my lord.
List number?
List number 2, serial number 14, my lord. For respondent number 5.
Yes.
Next time, my lord. Other side inform ಮಾಡಿದ್ರು.
ಮಾಡಿದ್ದೀರಾ? The request of
R5.
respond number 5. Relist on 10.
My lord, serial number 1, serial number 16, my lord. Petitioner, I am for.
Serial number 1.
List 1, serial number 60, my lord.
List 1, serial number 60, yes. Really.
I appear for petitioner, my lord. Please pray for time, my lord.
ಏನಾಗ್ಬೇಕು ನಿಮ್ಗೆ?
Petitioner, my lord.
Yes.
ರಾಜೇಶ್ ಅವರು ಸಿಲೆ ಕೌನ್ಸಿಲ್ ನಾಟ್ ವೆಲ್, my lord. Please ಅದಕ್ಕೋಸ್ಕರ ಒಂದು ಟೈಮ್.
Respondent council ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
Then please wait.
Please.
30 matter. Number 1, serial number 86.
Lord, in this case, my lord, your lordship had given direction. The director of prosecution had filed an memo. Take 24/2.
Kekoka.
Its copy may be dispensed because it is between the court and the.
ಬೇಕಾಗಿಲ್ಲ. You don't need to.
ಅದೇ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿದ್ದಾರೆ.
ಏನಂತ?
Copy is not served.
Office objection raised as regards service of memo on the counsel for respondent stands overruled since the memo has been filed in pursuit of the direction issued by this court.
So, as director of prosecution, my lord, that they have already made an circular, and it was distributed to all the prosecution APPs and other departments. And so far as in the judgment, my lord, in para 16.4, we have wrote letter to all the departments yet to receive the compliance report. 16.4.
ಯಾವಾಗ ಬರ್ಬೋದು?
Towards this end, the police IT, government of Karnataka, director.
When will you file that complaint?
Hello?
When will you file that complaint?
And it is directed that director of prosecution and the registrar of this court are directed to work with each other. There is little confusion.
Police IT has to work with because they are not speaking to each other.
Please, we wrote to the DG office. Already we wrote to just what the action they have taken. I'll make it.
Memo dated 27/2/2023 is being filed enclosing the circular dated 16/2/2023 issued by Director of Prosecution. The said memo reads as under. Memo is accepted. The compliance on behalf of the Director of Prosecution is accepted.
Yes.
Wherein DGA seeks for and is granted 2 weeks' time to comply with the other directions.
And have it after vacation.
16.4.
Because they have to coordinate and they have to.
Elections is antana. Relist on 25th May.
Serial number 85.
Achha.
Lordship may recall this that matter. This is already a 1972 association and now registering a cooperative society. Lordship had requested to permit to direct me to file.
You took some time to produce some documents.
Yes, please.
Produce it. You filed it in the section, then it should be here.
Extra copy.
You filed it today. You're filing it now.
Please.
Why don't you file it with the registry? It will be put up in the file.
Your Lordship, the only difficulty was since they are all senior citizens, for me to collate the sale deeds. The matter was last session on Thursday. Took some time, Your Lordship.
Now it will get adjourned unnecessarily to that.
Please. Well, that was the only difficulty. Took some time to collect the documents. I've served it on the other side as well.
Counsel for respondents submit that they have filed certain documents. Registries that put up filed certain documents today. Registries that put up the same. Relist on third.
Interim order kindly be extended.
Interim order earlier granted. You are not filing any documents.
No, Your Lordship. They have-
Counsel for the petitioner submit that she does not wish to file any documents.
Thank you. The rest are connected by.
Shekhar? Which matter is this matter?
The claim pertains to leave encashment benefits.
Hmm.
The leave rules will not have enclosed. But before that, my learned friend pointed out, Your Lordship, Rule 35, at page 7, for which it was adjourned, page 7, page 7, Rule 35.
Yes.
An employee who is dismissed or removed from service, but is reinstated on appeal or revision, is entitled to count his former service for leave.
Yes.
My lord, the former service is prior to the dismissal. Here, my lord, Your Lordship is deciding the dismissal period, my lord. That is from the date of dismissal till the date of reinstatement. The former service, my lord, is prior to the.
Anyway, that interpretation you are giving, you have acted against the interpretation by giving him the leave. You are only not giving him the encashment.
My lord, that also, my lord. Your Lordship may kindly come to the definition, my lord, of leave, my lord. That is at page 2, my lord.
Yes.
Page 2, my lord. 8, my lord. Section 8. Leave means leave includes earned leave. Page 2. Leave includes earned leave, half-pay leave, commuted leave, leave not due, extraordinary leave, casual leave. Now, Your Lordship may kindly come to 6, my lord. Relevant portion. Earned leave. Earned leave means leave earned in respect of period spent on duty and shall include privileged leave earned during the oath. It means may not earn in respect of period spent on duty. Now I will take Your Lordship to the judgments. The judgment which I am placing reliance that page 9. Page 9.
Yes.
The division bench was pleased to place take into consideration at paragraph number 5, 6, and 7 the judgment, and at paragraph number 10, 8, 9, and 10, and I'll read 9, at page 12. The proposition of law has been laid down by the Honorable Supreme Court by referring to the above cases can be summed up that an employee, if reinstated with consequential benefits, would be entitled to all such benefits that he would have got if he had worked in the normal course. But he is not entitled to those allowances which would accrue only if he worked in the conditions entitling him to draw the allowances. Both the cases of the apex court held above do not pertain to earned leave. The full bench of the High Court of Andhra Pradesh in the case of so-and-so has specifically held that earned leave is not a consequential benefit and workman has to render active service and thereby earn privileged leave to his credit. It has observed that after going through various settlements of memorandum between the workman and the employer, we are in no doubt conclude that the privilege is intended for rest and recuperation, and workman has to render active service and then earn privileged leave to his credit. A workman out of service for any reason whatsoever is not entitled to privileged leave. Similarly, this court in WP number so-and-so has held that earned leave is not a salary and the petitioner is not entitled to the same when he was not working. It is observed earned leave cannot have been earned as a matter of right, but by actual working. In appeal, writ appeal. Then, my lord, we kindly come to para 14, my lord. I was required to, my lord, clarify on this aspect, my lord. Para 14. Earned leave is a privilege a workman would be entitled to only by actual working, and it cannot be earned as a matter of right, even if he did not work. Even if he were to be in employment, he becomes entitled to it only if he works and earns it, otherwise not. It is similar to night shift or traveling allowance, which accrue only if the person decides to work. If he does not work, in that event, he is not entitled to it. Hence, earned leave, unless the relevant regulations expressly specifies otherwise, cannot be considered as part of the consequential benefits. My lord, my learned friend, my lord, read this portion, my lord, and placed reliance on Rule 35, my lord, and stated that there is a rule, my lord, in the corporation entitled, my lord,
The rule in this matter of Vijaya Bank.
my lord, that is, my lord, if your lordship comes with
No such rule.
the order, my lord,
Extract.
my lord, kindly see, my lord, para 13, the reliance placed on the judgment, my lord. In that, there are rules, my lord. Para 13, my lord. We are persuaded by the reasoning of the full bench of the Andhra Pradesh High Court in the case of Andhra Bank and another P. Balkrishna by Zellas, and this court in WP number 735 of 89, while considering the earned leave, has laid down by the apex court so and so. My lord, I have produced, my lord, 735 of 1989, my lord, the order at page 15, my lord, in page 15. The rules, my lord, are similar to the rules of the corporation, my lord.
Page 15 is
my lord,
National Textile Corp.
yes, madam. That is para 13 ali, the honorable
Para 13 is Andhra Bank.
Andhra Bank and this court in WP. You know this. WP 735 of 1989.
Adil.
Yes, madam. So in 735 of 89, madam, the rules are similar, madam. The facts of the case, madam, is para 4, madam.
Where is the rule?
My lord, rule is discussed in page 22, my lord, in page 22.
Yes.
But before that, my lord, I'm sorry, my lord, I did not bring to your lordship's notice, my lord. There's one more, the leave, my lord, is, that is, my lord, sorry, my lord, kindly come to the rules of the corporation, similar to the one in Taggi's case, my lord. That is page 4, my lord, in page 4.
Page 4 of?
The today's compilation, my lord. The leave rules, my lord, and just point out to your lordship at 4, my lord.
Yes.
At page number 4, my lord. It is the calculation, the last one, my lord. In calculating earned leave, the actual number of days of duty performed should first be counted and then multiplied by 1/11, the product expressed in days and limited to the maximum earned leave admissible. This is read with earned leave, my lord, at 11, my lord. 11.
Yes.
The earned leave admissible to a permanent employee is 1/11th of the period spent on duty. For every 11 days, my lord, he'll get one. My lord, similar rules, my lord, in page 22. In page 22, my lord.
32.
22.
Yes.
In the relevant portion, my lord, in the middle, my lord, it's about 12 lines, my lord. It is the contention of the learned counsel, your lordship.
Is the contention of the?
Like the rules are are titled as National Textile Limited Leave Rules, my lord. It starts with that 1970.
Yes.
Middle. In the said rules, the expression earned leave is defined to mean leave earned in respect of periods of service with the corporation and granted on full pay. This leave can be earned in respect of the periods of actual service in the corporation. Even though the petitioner was not in the services of the responding corporation during the disputed period, he cannot be deemed to be in service either by creating a legal fiction or by a notional presumption. The details and the procedure for earning leave is prescribed under clause 6 and 7 of the leave rules. The said clauses of the leave rules gives a clear indication that the leave has to be earned and it cannot be granted by default or when the employee is not on duty. It is like earning interest on the money deposited in a financial institution. For every 12 days of working, 1 day of earned leave will be credited to the employee's leave account and 2.5 days for each completed month of service. If an employee does not work, he would not be entitled to any earned leave, since it is only earned leave is encashable and not any other leave such as commuted leave, half-pay leave, casual leave. Earned leave account is maintained in two parts, encashable and non-encashable. Any part or whole encashable can be availed as a leave and is not necessary that it should be in cash. The quantum of earned leave is limited to a maximum of 75% of the earned leave admissible during a calendar year, subject to a maximum of 23 days, and the balance is credited to non-encashable earned leave account. The amount payable towards encashment of leave will not be reckoned as salary for the purposes of overtime, bonus, gratuity, etc. A conjoint reading of clause 6 and 7 of the leave rules leaves no manner of doubt that this leave has to be earned while in service, not while out of service. If the employee did not perform any work during the period of termination, it is open for it to demand leave with wages or compensation in lieu of thereof. In my view, this claim cannot be treated as either legal or valid, since the earned leave cannot be earned as a matter of right and not only by but only by actual working. And
Full back wages.
well, in the present in this case also, my lord, similar facts, my lord. If your lordship sees the facts, it was the order of dismissal, my lord, was set aside. Kindly see, my lord, para 4, my lord. The facts are similar, my lord, in the present case and in the case of Tyagi at para 4. Petitioner in this petition, that is page 18, my lord, asserts that since he was prevented from performing his duties in the respondent corporation by an order of termination dated November 10, 1983, till his reinstatement in the services of the respondent by their order dated July 31st, 1987, is deemed to have continued in the services of the company and deemed to have discharged his duties in the company. Therefore, he would be entitled to all the benefits from the respondent company to which a regular employee is entitled. It is further asserted that the stand of the respondent company, because his services were terminated, he is not entitled to those benefits. Is not in, because once the order of termination is set aside, the petitioner is deemed to have been in service, discharging his during the said period, since the management was responsible for preventing the petitioner from discharging his duties, and the petitioner cannot be blamed for not working during the said period. And further, since the order of termination has been set aside by this court, he is entitled to all the consequential benefits, including earned leave salary, LTC, medical reimbursement, etc.
It is the operative portion in life.
Well, it is.
Is the following and
My lord, in view of the matter, just above para 13, my lord, in that view of the matter, it cannot be said that
after 13 ends the following and
just about 13, my lord, 3 lines above. In my view, that is para 12 only. In my view, the earned leave salary, leave travel.
That we have read. After 13, according to petition is liable to dismiss, hence the following. What is the condition that were imposed?
Well,
hence the following and therebitu, other there's nothing below that.
well, the petition was dismissed.
Was it a conditional dismissal? Or
Page 9, well, it's no. It's dismissed, my lord, in the meaning. Again, page 9 of 9, judgment.
Problem with some of these publications is we can't.
Well, shall I try, my lord, in the order, my lord, order of the High Court, because this is followed.
Look at para 10, the court says that you not be entitled for but full wages.
If your lordship says para 12, my lord, para 12, there is, in my view, the earned leave salary, leave travel concession, and medical reimbursement are not part of the wages, but which are more or less in the nature of night shift allowance and running allowance, which were considered by Apex Court in the case of Bharat Electronics and in Dilbag Roy Jerry's case. In that view of the matter, it cannot be said that earned leave salary, LTC, medical reimbursement were due to the petitioner as a part of the wages for the entire period when he was prevented from performing his duties in the respondent company. Following this, my lord, the division bench at Parak.
Judgment is not complete, is what we are saying. The last portion is not there.
Well, if the lordship passes over, my lord, I'll take the, because this is the.
We'll complete the rest of it only for that purpose.
Okay, yes, sorry, my lord. Para 13, my lord, because I had to rely on this, because para 13, the division bench has placed reliance, my lord. The next judgment, my lord, is page 24, that is
Andhra Bank.
Andhra Bank, my lord. That is page 26, my lord. In page 26, para 5 months. The core question that arises with determination is whether an employee is entitled to the leave and encashment for the period for which he was kept out of employment, consequent on initiation of disciplinary proceedings, which ultimately ended in favor of the employee when he came to the reinstated service. Well, it has been held, my lord, that after discussing, my lord, at page 30, in page 30, my lord. Para 15, my lord. After going through the various settlements and memorandum between the workman and employer, we are in no doubt to conclude that the privileged leave is intended for rest and recuperation, and the workman has to render active service and thereby earn privileged leave to his credit. A workman out of service for any reason whatsoever is not entitled. In fact, the only provision, my lord, my learned friend brought your lord's notice, 35 minutes, rule 35. I took time, my lord, to find out how they apply this rule 35, my lord.
Full bench.
Yes.
Yes. Malad. Division bench of Istanbul Court judgment, Malad. Date 13, Malad.
Yes.
Para 14, Malad. Last two lines, Malad. Last three lines. Hence, earned leave, unless the relevant regulation expressly specify, otherwise cannot be considered as part of consequential benefits. Malad, in all the judgments, Malad, what will understand referred, Malad, there is no regulation or specific rules, Malad, regarding computation of leave during the period of out of service, Malad. Malad, in KSRTC and in APSRTC regulation, APSRTC regulation not, Malad, there is a provision for counting the period, Malad, clear to reinstatement, Malad, taken into account for the purpose of leave benefits.
ಅದೆಲ್ಲಿದೆ?
ಅದು ಇದರಲ್ಲಿ ನಮ್ಮ 35 Malad.
35, the interpretation now sought to be given to 35 is former service.
Former service means, Malad, up to the date of reinstatement, Malad. Because, Malad, former service automatic, Malad, they worked, Malad, entitled. So what remains is, Malad, dismissal period. So when he was reinstated, Malad, subsequent previous service is a former service. So he understood, Malad, my understanding, Malad. He understood is that, Malad, up to the date of reinstatement, Malad, the service rendered by the workman is treated as for purpose of calculation of increment leave, Malad. Otherwise, ಇದು ಬರೆಯ ಕ್ವಶನ್ ಇರಲಿಲ್ಲ. ಅಥವಾ ಅದನ್ನು ಹೇಳ್ಬೇಕಾಗಿತ್ತು, ಇಲ್ಲ ಅಂತ ಹೇಳಿ.
This interpretation now sought to be made.
Malad, ಎಷ್ಟೊಂದು ಕೇಸಲ್ಲಿ
We have to award back wages in everything.
Malad, it's not so, Malad. The appellate authority specifies, Malad, whether he is entitled to the prior period or not. In many of the cases, even my learned friend has got it clarified that the previous service should be, Malad, protected. Because when there is an order of reinstatement without any other, my lord, clause, my lord, by the appellate authority or the revision authority, my lord, it has been held that the prior service, my lord, because the dismissal period, my lord, even neither the appellate authority nor the disciplinary authority could travel before the order of dismissal, my lord, because the order of punishment, the punishment starts from the order of dismissal till reinstatement. In cases, my lord, in the service.
See, that could be the case if the punishment was confirmed by this court.
No,
The
that's why it says, my lord.
Set aside.
My lord, it says, that's why it says, my lord, appellate authority or revision authority. Because in the cases, my lord, in what happens whenever I'm informed that the appellate authority or the revision authority, sometimes, my lord, they say that he's reinstated into service. As far as the other benefits, my lord, prior benefits would be silent, my lord. In such cases, my lord, this clause is and the protection, my lord, is.
If you look at it this way, insofar as prior service prior to his dismissal, obviously has to be protected. Nobody can say anything about it.
My lord, it will be treated.
Then you say, I have dismissed you now, earlier ones, I am not going to take into consideration.
That is the reason, my lord, only for the order of the appellate authority and revision authority. They showed me some certain orders, my lord, when they clarified, my lord. They showed me orders where the order of the revision authority is silent, my lord. It only says reinstatement of the workman.
Those are.
So only in those cases, my lord, and this is very, very limited, my lord. It's not pressed into service, my lord. I am told that in 1 or 2 cases.
Shaker is pressing it. But normally, even back wages he gives up. In this case, he is insisting on this.
But because, my lord, in none of the cases, my lord, consequential benefits, wherever there is consequential benefits, leave encashment is not provided, my lord.
By concession, we can pass some judgment. When it is being argued, we'll have to look at what the legal position is and do that. Now, we've heard both of you, insofar as the judgment of the single judge of this court. The last para is not there. Page 9.
Yes, my lord. That I will provide. I'll provide. And the leave rules is, my lord, similar, my lord. National textile rules is similar to the.
We'll consider that. We'll consider that.
My lord, in full bench decision, my lord, last year kindly.
Full bench. Andhra Pradesh.
Yes.
Yes. Last till page 24.
Para 7, my lord.
Para 7, page 26.
Para 7. Per contra learned counsel. Per contra learned counsel appearing for the respondent submits that rejection of approval, the order of dismissal by the industrial tribunal under section 33 2B of the Industrial Disputes Act 90% dates back to the date of order of dismissal and restore the position of the employee to the date of the order of dismissal, entitling him all the consequential benefits such as continuity of service and other consequential attendant benefits, including the privilege leave. To buttress his submission, reliance has been placed on the division bench decision of this court in the appeal number so and so. So APSRTC chairman, vice chairman T. Govinda Reddy and cited decisions of Supreme Court in vice chairman Govinda Reddy's case. It has been held that there is absolutely no justification whatsoever on the part of the corporation not to treat the period of absence as qualified service for the purpose of payment of gratuity and encashment of earned leave. When the corporation itself for the purpose treated the period from November 5, 71, August 22, 23, 2003, as if the employee was in active service, the dispute in vice chairman so and so case was between APSRTC and its employee. APSRTC in the cited case did not plead of any rule in the service condition under which workman has to render actual service to earn privilege leave. Therefore, the cited decision has no applicable to the facts of the case. In fact, my lord, this judgment has been affirmed by the Supreme Court. So, though, my lord, the full bench cited this judgment, my lord, so one aspect, my lord. In another aspect, my lord, in
You're saying APSRTC versus Govinda Reddy.
Yes.
Was upheld by the apex.
Apex.
Where is that judgment?
ಅದು ಡಿಸ್ಮಿಸ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಅದು ಅದು ಆ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲೇ ಬಂದಿದೆ ಅಪೀಲ್ಡ್ ಬೈ ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ. In that paragraph itself,
This case, my lord, has no application to the present case. That's rejected, my lord. The contention of.
ಸರಿ ಆಯ್ತು ಬಟ್ ಲಾ ಏನಿದೆ ಅಂತ ಅಷ್ಟೇ. APSRTC regulation has been considered in Govinda Reddy's case, my lord. In all other banks cases, my lord, there is no such regulations or rules. Considering this judgment, my lord, full bench judgment on Govinda Reddy's case, my lord, the honorable Judge Single Judge of Andhra Pradesh, my lord, elaborately considered these two judgments, my lord.
This is now latest 2016.
Yes,
Yes.
again, my lord,
The judgment is not given to me.
ಕೊಟ್ಬಿಡ್ತೀನಿ
Taken by surprise by this.
ನೋಡ್ತೀನಿ ಒಂದು ಸೀದಾ ಕೊಡ್ತೀನಿ.
ಅದಕ್ಕೆ ಕೇಳಿದೆ 2 ಮಾಡ್ಕೊಂಡಾಗ 3 ಮಾಡ್ಕೊಳಕ್ ಆಗಲ್ಲ.
ಅದಕ್ಕೆ ಎಲ್ಲರಿಗೂ ಹೇಳೋದು ಪ್ಲೀಸ್ ಗಿವ್ ಕಾಪೀಸ್ ಅಂತ.
ಗೋವಿಂದ ರೆಡ್ಡಿ ಇದೆಯಾ?
Anyway, and reply this, madam, later, because I have to get the other judgment also.
5.1, my lord, 5.1. You would submit that the entire period of out of employment as a consequence to the award passed by the labor court had to be counted as period spent on duty, and therefore the said period also should be computed for the purpose of accumulation of earned leave. In support of the said contention, London Council placed reliance on the decision of the division bench in this court in management of APSRTC, so on, so on, Govinda Reddy's case. Further, my lord, full bench decision also referred, my lord. You would further submit that the regulation 34A of APSRTC employs real regulation 96 part regulation, which is laid upon by to deny the benefit to the petitioner, was considered by the division bench and held that denial is illegal. The special leave to appeal civil and so also was dismissed by the Supreme Court, what order dated 12/12/2003. He would therefore submit that in view of the principle laid down by the division bench of this court, in the Govinda Reddy petitioner is entitled for computation of the entire service of out of employment for the purpose of grant of accumulation of earned leave. Further, my lord, para 10, my lord. In Govinda Reddy, petitioner was placed under the suspension on so and so and later removed from service. Labor court passed award setting aside the removal and directed reinstatement with continuity of service and back wages. He was reinstated on so and so. The period from 1971 to 83 was not computed for the purpose of grant of gratuity and earned leave. By construing provision in regulation 34 of the regulation 96, the fact that the management treated the period from 5/11/71 to 22/83 as in service and fixed stay and reinstatement by duly giving notional increments for the above period. Division bench held that there is absolutely no justification whatsoever on the part of appellate corporation not to treat the period as so and so. In the case before the full bench, my lord, what my learned friend relied, my lord, with petitioner was cashier in Andhra Bank, he was dismissed from service, so and so. Andhra Bank filed application for approval under section 33(2) BF General Disputes Act before the Industrial Tribunal Hyderabad in ID number so and so. pending before the tribunal did not approve the action of the Andhra Bank. Consequently, petitioner was reinstated to service and so on. Petitioner made a representation for encashment of leave account to his credit during the period from 82 to 86. The said request was rejected by the bank. Petitioner challenged the rejection in the writ petition filed before this court, contending that as the order of dismissal was not approved by the industrial tribunal, the relationship between the employee and the employee subsists continuously and therefore is entitled to all the consequential benefits, including the benefit of privilege leave. 11.1. The full bench was called upon to determine whether an employee is entitled to the benefit of leave encashment for the period for which he was kept out of employment when such action was held illegal in support of the claim of computation of the period of out of employment for the purpose of earned leave. Reliance was placed on the decision of the division bench of this court in Govind Reddy. Regarding para 7 of the judgment, as reported in the journal, would show that the decision of the division bench in Govind Reddy was considered undistinguished. The full bench has held under that dispute in Vice Chairman versus Govind Reddy's case was between APSRTC and its employees. APSRTC in the cited case did not plead any rule in the service conditions under which workman has to render actual service to earn privilege. Therefore, this cited decision has no applicable to the facts of the case. 11.3. The reference to full bench was considered having regard to the Shastri Award and bipartite settlement, which governs the employee of nationalized banks. Reading of paragraph 15 of the judgment, as reported in the journal, makes aspect clear. At this stage, it is appropriate to extract relevant observations. There is, after going through the various settlements between the workman and the employee, clear of the doubt.
Read the entire thing.
The
Operative portion, para 16.
yes, ma'am. The honorable single judge, ma'am.
Judgment para numbers are flying all around the place. 13.2 in the matte 9 baratte, then.
Allah, judgment extract ಮಾಡಿದೆ sir. 13.2 in full bench judgment. In full bench judgment.
ಇದು ಲೇಬರ್ ಲಾ ಜರ್ನಲ್ ಎಲ್ಲ ರಿಪೋರ್ಟ್ ಆಗಿಲ್ವಾ?
ನೋಡಿ ಸಮಸ್ಯೆ ಇಲ್ಲ ಆಗಿರುತ್ತೆ ಅನ್ಸುತ್ತೆ. Considering the Deepali Gundu service judgment, my lord, the word reinstatement and reinstall the original position, my lord. Dismal court, my lord, though my lord, full bench held that, my lord, and considering the earlier judgment of Govind's case, my lord, opened that, my lord, was entitled for earned leave, my lord, during the dismissal period. My understanding of the regulation is, my lord, previous farmer service is, my lord, up to the rate of reinstatement. If there is a farmer service up to the date of dismissal, my lord, no need for clarification, my lord. Since he is worked, my lord, he is already worked. That period cannot be regularized again, my lord. What period is regularized is from the date of dismissal till reinstatement. That has been correctly clarified in the regulation, my lord. Reinstatement, my lord, farmer service, my lord, up to the date of reinstatement. Is counting for leave, my lord. In fact, my lord, up to the date of dismissal, my lord, already taken into account the leave and leave in his leave account. That cannot be taken back at any point of time, my lord. Hence, my lord.
We'll look into it. Produce that judgment.
Yes. And about this judgment, my lord, I'm not in.
Want to make submission?
ಅಲ್ಲ ಗೊತ್ತಿಲ್ಲ ಏನ್ ಗೊತ್ತಿಲ್ಲ ನನಗೆ. The facts again because ನೋಡ್ಕೊಂಡು.
ನೀವು ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ ರಿಸರ್ವ್ ಮಾಡ್ತಾ ಇದೀವಿ, ವಿಲ್ ಪಾಸ್.
Yes, ma'am. Yes.
Heard this juridical and counsel for the appeal. What about you, Mr. Karthikeyan?
Yes, I
Adopt. Shri L. Sheikh, counsel. Reserve.
Number 90, number 100.
Rainy case, my lord, in respect of one advertisement, my lord, one of 2008, my lord, with great difficulty, my lord, the list has been prepared because it was very difficult because about, my lord, 8 or 9 divisions, it will be spread over, my lord. So they have, my lord, within the time, my lord, 1,210 employees, my lord, have been brought on probation within 2 years.
1,210.
Yes.
How many were hired?
In one advertisement.
In one advertisement, my lord.
How many were?
1,600 were there.
How many were? 1,600 were hired.
And 1,200 are brought on provision.
The 2008, my lord, was published 1,200 post, my lord. After 2008, my lord, 8 to 10 advertisement was published in my lord.
My lord,
ಇದರಲ್ಲಿ
what I was trying to-
ಇರೋರು ಒಬ್ಬನೇ.
ನಾವು ಇನ್ನೂರು ಜನ
person.
defaulters ಗೋಸ್ಕರ. They want the regulations, my lord, which is enforced to be.
ಏನೇನ್ ಡಿಫಾಲ್ಟ್ ಇದೆ ಅಂತ ಎಲ್ಲ ಟ್ಯಾಬ್ಲೆಟ್
ಅದನ್ನ ಕೇಳಿದ್ ನಾನು ಸರ್. ಅದನ್ನ ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ರೆ ಇವ್ರು ಇದನ್ನ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
ಇಲ್ಲ ನಾನು ಇದನ್ನೇ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದೆ.
Whatever, ಅಲ್ಲ.
ನಾನು ಇದನ್ನ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದೆ. ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲದೆ ಇರ್ಬೋದು. ನೀವು
ಇಲ್ಲ. ಚೆನ್ನಾಗಿ
ಅದು ಹೊರಗಡೆ ಇಲ್ಲಲ್ಲ.
ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಅಂದ್ರೆ ನೀವು ಇಲ್ಲದೆ ಇದ್ದಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೀವಿ.
ಅಲ್ಲ
Every time
ಇರ್ಬೋದು, ಬಟ್ ಕೋರ್ಟ್ ಹೇಳಿದ್ದು ಅವರು ಡಿಫಾಲ್ಟ್ ಏನು ಯಾವಾಗ ಸೇರಿದ್ರು
ಕೂತ್ಕೊಂಡಿದ್ರು ನಾಯಕ್ ಕೇಸಲ್ಲಿ. ನಾಯಕ್ ಅವ್ರದ್ದು ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡು ನಾಯಕ್ ಇಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿದ್ರು. ಅವತ್ ನಾನು ಮಾಡಿದ್ದೆ ಸಬ್ಮಿಷನ್. He doesn't know without even clarifying.
Give us the details of the advertisement.
Yes, ma'am.
Number of people you hired, number of people that you confirmed, number of people you did not confirm, and the reason for that. Those were the things that you had to give. ಅದಕ್ಕೆ 2 ಸತಿ ಅಜ್ಜನ್ ಆಗಿದೆ.
ಇದು within 2 days my lord ಆಗಿಲ್ಲ. ಎರಡೇ ಮಾಡ್ಕೊಬಹುದು. ನಾನು ಕೊಟ್ಬಿಡ್ತೀನಿ.
ಕೊಟ್ಮೇಲೆ ಅವ್ರೇನಾದ್ರು ಹೇಳ್ಬೇಕು ಅಂತ ಇದ್ರೆ
ಬ್ಲಡ್ ಅಡ್ವರ್ಟೈಸ್
ಲಾಸ್ಟ್ ವಾರ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲ, ಇದು ಕಂಪ್ಲೀಟ್ಲಿ ಡಿಫರೆಂಟ್.
advertisement and
it is already recorded in the order. Advertisement, number of people hired, number of people confirmed, number of people not confirmed, reason for not confirmation.
Yes, I'll give you. I'll
put it. Twice it's been adjourned for that.
Yes, my lord. I
one advertisement it is not helpful, my lord.
Into all this ನೀವೇ ತಗೊಂಡ್ಬಂದ್ಬಿಡಿ ಎಲ್ಲ.
ನನ್ನ ಕಡೆ ಇದ್ರೆ ನಾನು ಇವತ್ತೇ ತಂದ್ಬಿಟ್ಟಿದ್ದೆ ಸರ್.
The questions my lord which are before the court. ಇವಾಗ ಒಂದ್ ಕೇಸ್ ನಲ್ಲಿ
So when will you get this matter? ಯಾವ ಕೊಡ್ತೀರಾ?
ಶೇಖರ್ ಹತ್ರ ಎಲ್ಲ ಇರುತ್ತೆ.
6th of April, my lord.
Before?
5th of April, 5/4.
Renuka Learned Counsel for the RTC seeks for one more accommodation to produce the details earlier undertaken. Relist on before 5th or 5th?
5th, my lord.
5th.
Pursuant to the interim order, my lord, the workmen are working since from 2013-14, my lord. By getting meager salary, my lord, they are waiting this judgment, my lord. Now continue ಮಾಡದ ಹೋಗದ ಅನ್ನೋ ಮಟ್ಟ.
Waiting from 2013 will.
Yes, my lord.
Another 10 days is nothing, Mr. Sheikh.
ಅದು ಪಾಸಿಟಿವ್ ಆಗಿ ಅದು very difficult for their families, my lord. 2013.
The entire judgment I'll furnish with the court of it.
Please leave that.
Yeah, date I represent petitioner, my lord. Petitioner has not compared the order on account of my lord stating the premises. And moreover, under the new BBMP Act, there is a provision to apply for modifying the plan. So under these circumstances, the client is filing memo for not pressing the petition, and now he ಏನಾಗಿದೆ ಪರಿಸ್ಥಿತಿ ಆ ಪರಿಸ್ಥಿತಿ ಬಂದಿದೆ ಈಗ. There is a provision under the new BBMP Act. If the construction is by deviation, can apply for the plan and by
Counsel for petitioner has filed a memo dated 27/26 signed by the petitioner and the advocate for petitioner accepting the submission of Sri D.G. Chinnappa Gowda and the memo. The petition dismissed as not placed.
Number 5.
Shivkumar. None appears. Copies in respect of service to respondent number 9 and 10 have not been furnished. The writ petition in respect of respondent number 9 and 10 stands dismissed. Relist on 11th April.
Number 7. Yes, in the ratio collected by.
Petitioner in Moksha's matter. ಮಾಡಿದಿರಾ?
ಆಮೇಲೆ ಕೆಲವತ್ತು ಮಾಡಿ
I am trying to.
ಯಾವಾಗ ಯಾವಾಗ ಕೊಡ್ತೀರಾ? 7.17 ಅಲ್ಲಿ already dictation ಆಗಿದೆ. 7.1. Counsel for the petitioner has carried out necessary amendment. He seeks for a week's time to file the amended cost item released on 13th April.
Serial number 9.
Amendment carried out.
Carried out.
Pays for 2 weeks of time.
Counsel for the petitioner has carried out necessary amendment. He seeks for a week's time to file amended cost action released on 13th. Mr. Vasant. So.
Apologies, my lords, I wasn't present in the morning of the case was called. My apologies, my lords, I wasn't called, I wasn't there. Lords had directed me to find out what is the action we have taken subsequent to Annex D, which is impugned, my lords. My instructions are, the fourth respondent, my lords, has preferred an appeal before the commissioner in appeal number 16 of respondent number 5, my lords. In appeal number 16 of 2003, which was listed on 4th of March 2023, and an order of status quo has been granted. The next hearing date is 15/4/23.
15/4.
15/4. You could add after that. Oh, any status quo, you cannot pass status quo.
Commission has the power to pass it.
So my instructions, there is no any order. Or the WhatsApp of the order.
It is making the submission. The Honorable Judge VG, the transfer for respondent number 1 to 4 submitted an appeal filed before the commissioner challenging the notice under section 248(2). The commissioner BBMP has ordered a status quo to be maintained. And next date of the matter is on 15. Hence, released on 19th.
I am for response 1 and 2 minutes.
Jagdishwara.
Government advocate to for having served the notice before inspection survey. Or ಬೆಳಗ್ಗೆ submission ಮಾಡ್ತಿದ್ರು.
It was to be fixed anta idralla.
ಹೌದು.
Notice was not served and therefore date is to be fixed anta.
The government advocate was mentioning to me that the notice was not served, so maybe this was not
notice. What we'll do is we'll fix the date for survey. And since you are there, that is notice.
So whether this matter will be pending?
Once the survey comes, then we'll see that. Pending.
So that
The internal and AGA submit that the survey could not be carried out to on survey due to notice on this petitioner not being served. In view thereof, the chance's opinion that a date could be fixed by this court, which could be deemed to be service of notice on the petitioner and the respondents. The carry out survey
ADLR.
Jurisdiction ADLR shall carry out survey of the concerned property commencing at 10:30 AM on 6th April 2023. Report to be submitted on or before 13th April, released on 19th April, 18th April.
Sir, morning, because they better the council also, myself also to be present. ಬೆಳಿಗ್ಗೆ ಸ್ವಲ್ಪ
ನೀವು ಅಲ್ಲಿ ಹೋದ್ರೆ ಇಲ್ಲಿ ಕೆಲಸ ಹೋಗುತ್ತೆ, ಅಲ್ಲಿ ಹೋದ್ರೆ ಇಲ್ಲಿ ಬರಕ್ಕಾಗಲ್ಲ. Has to be done during the daytime and office hours. Send your colleague or the petitioner will be.
Or any Saturday, better.
On 8th April, commencing at 10. 7th Raja ida. 7th April at commencing at 10:30 AM. Since the order is passed in the presence of both the councils, in all the councils, there is no requirement of any further notice. If any of the parties choose not to be present during the survey, they should not be entitled for any equitable consideration.
Last time also, what happened was
The matter was disposed of with the direction. I think I have produced the annexure also.
I think he said the better.
Yeah.
I am told that they have not received. Instead of it, they have sent by WhatsApp message. The Tahsildar office clerk came there. She told me that the message has been sent through the WhatsApp. But of course,
Let's not get into all that thing,
yes,
Mr. Jagdishwar.
yes, my lord.
It was mad, yeah.
Yes, my lord.
Seven.
For the petition, morning, my lord, they took some
Mr. Pawan Kumar.
pass over in the morning. Citizens are supposed to produce documents regarding the
Notice and opportunity.
Notices have been issued.
Notice issue ಆಗಬೇಕು, serve ಆಗಬೇಕು, or reply ಇದ್ರೆ consider ಆಗಬೇಕು.
So 2 more notices next week.
Who is this served on?
Second notice is served by RPD post there, they have posted. First notice is received by the petitioner.
Where is the acknowledgement for this?
The RPD
Receipt is the acknowledgement. RPD receipt is not service. Either you have to produce the postal track or RPD.
is not there in their file, but they said they have posted it, and the first notice they have received, they have given it.
First notice, yes. This is also important.
Second notice they have posted.
Third notice, ಏನು ಇಲ್ಲ.
Third, they say they have posted it only, but the receipt is not there in the original. The last notice only purpose.
Moonne Sati, you are getting stuck on similar thing before us.
Placing the records, whatever is there.
Serve notices and give them opportunity. If you don't do it, then you can't exercise any power.
Opportunity for hearing may be given.
Now what happens, you are not handed it over, Allah?
No, it's already working. In the meantime, the responding number 4.
That we will set aside.
They were carrying.
We'll set aside the work. Petitioner is before the court, seeking for the following reasons. The grievance of the petitioner is that without
So one more,
opportunity,
there is an arbitration clause also.
then why did that? Then you go for arbitration. We'll quash this.
Facility may be given to them. And
without giving an opportunity to the petitioner contract with the respondent for maintaining a pay-for-use toilet has been cancelled and a new work order which has been issued in favor of respondent number 4. On the last date of hearing, counsel for respondent number 1 and 2 sought for short accommodation to produce the original file, indicate service of notice on the petitioner. The said original file having been produced before this court, it is seen that though the first notice has been served on the petitioner, the second notice, there is only the RP receipt and there is no acknowledgement as such available on the file indicating service of notice on the petitioner. The third notice neither bears the RP receipt nor acknowledgement. In that view of the matter, it is clear that the petitioner was not issued a note, petitioner was not served with a notice to enable the petitioner to reply to the same and place his say on the matter before the respondents. This being a violation of the principle of natural justice, I am of the considered opinion that the contract with the petitioner should neither be terminated nor a fresh work order be issued to respond number 4. Hence, I pass the following order. Writ petition is allowed, a certiorari is issued, the work order dated 13/2/2023, issued in favor of the 4th respondent is quashed. The petitioner to continue operation of the pay-for-use toilet without interference from respondent number 1 to 3. Liberty is however reserved to respondent number 1 to 3 to initiate such proceedings as may be advised by invoking the arbitration clause under the agreement between the parties.
And this, got motion, till number 15, day is out there.
Bill number
20, yes.
20 into model.
Day.
Yes.
With your lordships, kindly submission, my lords, that I want to place, which is that the distinction that my lords that was drawn was that in the earlier round of writ, only the landowner was there, and thereafter the subsequent flat purchasers weren't there, therefore they weren't present at the inspection, and so another opportunity must be given. I've just received, my lord, copies of the Mahazars drawn. This is prior to the earlier petition, where these flat purchasers, who are the other petitioners before your lordships, were also present and they have signed, my lords. I'll of course place them with objections, but for now, my lords, I can place this before your lordships.
Place it before.
Yes, my lord.
You file properly after serving a note.
I'll serve.
My submission, your lordship, the court respondent having no locus standi, your lordship. It is this honorable court coordinate bench of the honorable court, your lordship, at page number 191. When he was filed his application for implement.
Whether we hear them or not, you have made them a party. Now you cannot say they have no locus after making
Not
them
a party before the BBMP.
You have made them a party in your petition, Mr. Counsel.
I want to clarify on that issue, your lordship. Kindly, once page number 191, 190.
Mr. Amandrapa, if we had filed something, you could as a respondent take up the contention that our locus illa anta. ನೀವೇ ಅವ್ರನ್ನ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 ಪಾರ್ಟಿ ಮಾಡ್ಬಿಟ್ಟು ಲೋಕಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ ಆಗತ್ತ ಅದು ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ತೀನಿ ಅವ್ರನ್ನ ಏನು ಕೇಳಬೇಡಿ ಅಂತೀರಾ ನೀವು ನಾಟ್ ಪಾಸಿಬಲ್. ಶ್ರೀ ರಘುರಾಮ್ ಕದಂಬಿ, ಶ್ರೀ ಪವನ್ ಕುಮಾರ್ accepts notice for respond number 1 to 3. Shri Raghuram Kadambi accepts notice for respond number 4. Shri Kadambi seeks for and is granted a week's time to place certain documents on record, relist on 6th.
You can stay, your lordship.
On 3rd. In the meanwhile, the respondent number 1 to 3 are restricted from taking any action for demolition of the property.
Would it be on the concern? Your lordship said 3rd, my lord. 3rd. I'm great.
Kindly have done
6th, I have some difficulty.
6th.
No, I have some difficulty on 6th. 7th.
7th, ನೀವು ಒಬ್ಬರೇ ಬನ್ನಿ. ನಾವು ಯಾರು ಬರಲ್ಲ.
3rd, my lord.
4th is holiday. 5th is CS day. Then we'll have it on 10th.
10th. 6th and 10th are the 2 dates, my lord. There's some.
7th.
Very well. I'm grateful.
48.
Yes, counsel had to appear in this matter. Very important 11.
48 at the request of the counsel for the petition released on 3rd. It's made clear that no further adjournment will be granted if arguments are not advanced.
Third, there is some inconvenience.
In long weekend antana. Long weekend antana.
No, there are the number of matters which were listed on that day. We thought it would be a holiday, but now we'll have to attend.
10th. 10th. Argument is not advanced, dismissed.
Serial number 50.
Yes, madam.
About 6 acres of land belonging to the grandfather of the petitioner to acquire it as land. But in lieu of this land, my lords, the petitioner made representation seeking for allotment of an industrial, which was allotted, my lords, with authority for a price, and thereafter it was reduced by 50%. He paid the entire price. There was an agreement, my lords, between the authority and the petitioner's grandfather that a construction of the industrial plot must be made within 2 years from the date of agreement. It was not done. In the year 1987, my lords, there was certain change in the measurement. The new agreement also was entered. Even thereafter, there was no construction made, my lord. In the meantime, the petitioner entered into, my lords, an agreement of sale with a third party and sought for permission, my lords, that was refused. Long litigation, OS was allowed, then RFA was dismissed. Thereafter, my lords, in 2014, a cancellation was made by the authority, which is challenged before this honorable court. My lords, this matter, Mr. Raghupati was appearing in this matter. He tells me, my lords, on the day when he appeared, this honorable court, hearing the matter on that day, requested, stated, my lord, that remembering that in another matter, the authority had conceded for issuing title deed, my lords, after receiving 25% of SR value. My lords, even in this case, a direction was made to this effect, and we have
not for this.
we have filed a memo. There is no record to that effect.
No record in the order.
No, my lord. But
Let us see what Mr. Vivekananda says.
Mr. Raghupati says this is the matter.
The
I have-
memo has been served to me, but
He says this is the matter in which
Irrespective of that submission, he can still make.
25%. We have filed a memo stating that we are ready to pay 25% of SR value. I'm not.
In another matter, it was.
In another matter where my
No, this
friend appeared.
matter, my lord, I have appeared, but in that matter, my lord, there was a board resolution by which, my lord, the representation submitted by the allottee has been placed before the board, and board took a decision to grant him the absolute sale deed, subject to deposit of 25% of the guidance value prevailing as on the date of resolution. But, on this,
Ultimately, here it is not a new allottee. It's a person who has lost his land. Now, firstly, the question would be, can you impose such a condition that they'll construct within 2 years when you are giving them the land in lieu as compensation?
no, that is where the distinction. This plot was not allotted as an incentive site to the land loser. An application was filed seeking allotment of industrial plot that was granted in usual course. Thereafterwards, the party pleaded that I have lost some of the lands for acquisition, therefore give me a concession. That concession was granted, that it is not a site which was allotted as a land loser site. It is a concession given. Therefore, all the conditions which were made applicable to the other allottees, similarly situated allottees, were made applicable to this allotment also. There, my lord, there was a condition that they should commence the construction within 6 months and utilize the plot within 2 years. This was done in 1980s, my lord. We are in 2020. And that is the state of
Amount has
affairs.
been paid, my lord. If similar,
Not as
My lord,
compensation, it is.
it is, my lord. It is. Kindly see annexure D, my lord.
It is
This
in
was
compensation and coercion.
compensation ತಗೊಂಡಿಲ್ಲ ಅಂತಾನು representation ಇದೆ. Even that has been.
Where is it that this is?
Kindly see annexure D, page 39, my lord.
39.
This is pursuant to a representation made at annexure C, my lord, where he states about he is not receiving the compensation.
Apply to CITV Mysore for site after formation. This is.
I'm directed to state that you may apply to the CITV Mysore for a site after formation of the layout. My lords, pursuant to this, he made an application. Then, my lords, he was allotted. Kindly see annexure F also, my lord. Where we asked for 50% of concession. Even there he says, my lord, second para, page 43, annexure F. In this connection, I have to state that my land bearing so and so, measuring 6 acres 12 guntas has been acquired for formation of so and so. The award is still under deposit and the same has not been drawn. We have not drawn the amount.
And this is subsequent to the loss of land.
Yes, my lord.
In lieu of acquisition.
That the concession was granted, taking note of the
The allotment itself was made on the basis of losing land.
For a land loser, no provision for allotment of industrial plot. It was an application was filed. The application is available in the file. An application was filed seeking allotment of industrial plot. Considering that application, industrial plot was allotted, but concession was granted subsequently on the representation made by the petitioner, petitioner's father, saying that I have lost lands for acquisition.
Have you paid him the compensation for the land acquired?
It is not in lieu of compensation, the land is.
Have you paid him the compensation?
Yes, it was deposited before the.
It's not drawn. My instructions are it's not drawn.
But if it is deposited, if it is not drawn, it is not our responsibility.
My lords, I'm not on that at all. I'm not on whether we have drawn it or not. My lords, as a concession, this land was allotted.
Deployed tomorrow also is what he said.
My lords, I'm not on that at all. I'm on the question that the authority passes a resolution in other matters where they're not even land losers. They say 25% of SR value is paid. They'll reallot the entire plot to them. Similar concession may be granted to me, and that's why I have filed a memo, my lord. Even we are ready to deposit 25% of the SR value. That's all we are saying.
It's something that you'll have to consider.
I would not look into.
In light of this, let the petitioner also make such a request. The same could be considered by the.
To obtain instruction and make your submission. Now that the memo has been served.
Yes.
Otherwise, it will be one more round of litigation. The memo has been filed by the counsel for the petitioner. In closing, past WP number 2051 of 2014, dated 12/7/2022, which is stated to be in which a similar list is stated to have been considered. TTP Vivekananda, counsel for respondent number 1 and 3.
Kindly add, sir. In that case, there was a resolution of the board.
We are not saying anything. We are not saying anything.
No, even to seek further instructions from the board, Lordships could add that there was a resolution in that case, and pursuant to that resolution, order is passed. It would be helpful for me, to.
And in the resolution, they say,
The said order indicates that in the allotment, the property by respondent number 2 was cancelled by respondent number 2. A resolution was passed by the board deciding to reallot the site in question to the allottee, son of the allottee, on payment of 25% of the guidance value of the site, as on the date of the resolution. Faced with the above situation, TTP Vivekananda seeks for and is granted 2 weeks' time to obtain instruction, make the submission. Released on 13th April.
The Bangalore Development Authority has executed a sale deal to Annexure A with respect to a non-existent.
Is appearing for Mr. Charity? You are appearing, sir. Yes. BDAS?
The BDA has executed a sale deal at Annexure A with respect to a non-existent land. But I have to say so because the Bangalore Development Authority itself has given me an endorsement
saying that the 337 square yards for which a CLD is executed at Annexure A does not exist. What had happened here was Annexure J, my lord, the Bangalore, the then CITB had executed the sale deed with respect to 1060 square yards. After executing a sale deed with respect to 1060 square yards, my lord, the father of the respondents, my lord, they started making a representation to the Bangalore Development Authority.
Father of which respondent?
My lord, the father of the
3 and
respondent,
4.
The contestant respondents, my lord, 3 and 4. Look, he gave a representation to the Bangalore Development Authority because this is a marginal land. So the only marginal land that was available was 1060 square yards, for which a sale deed has already been executed in the year 1979 by accepting this well consideration.
In whose favor?
In favor of one B.S. Pandit, because the dispute is between the brothers of the first wife and the sons of the first wife and the sons of the second wife of B.S. Pandit.
B.S. Pandit is the father of respondent number 3 and 4.
B.S. Pandit is the father of respondents 3 and 4.
Yes.
Yes.
So it was allotted 1089 square yards. Has been allotted to V.S. Pandit.
Not B.S. Pandit, to the other brother. That is B.S. Pandit and M.S. Pandit. B.S. MS and B.S.
V and B so
it's also confusion. Before I take my lord, I should also bring it to the notice of this honorable court. An order that is passed while vacating the interim order that was granted. Because I am sure my learned friend will say that I would be wasting the time of this court if I don't bring that order to the notice of this honorable court. Lord, kindly have a look at the order dated 4th July 2017. 4th July 2017. An ex parte interim order was granted in favor of the petitioner. May I request my lord to kindly come to paragraph 25, my lord, because this court says that it is a complicated question of fact which cannot be gone into by this court. Paragraph 25, my lord. Paragraph 25. Because of the complex disputed questions of fact, the petitioner does not have a prima facie case in its favor. Further, as there is a judicial finding given by a learned civil court with regard to the existence of two different parcels of lands, a finding which has reached finality, even the balance of convenience is not in favor of the petitioner. Furthermore, in case the stay order were vacated, it would not cause irreparable change. Or if the petitioner were to succeed, it can be compensated in terms of. Lastly, even after a full-fledged hearing of the case, this court would not be in a position to decide the dispute one way or the other. Hence, the main relief sought by the petitioner cannot be granted. Once the main relief cannot be granted, question of granting an interim relief in continuation. This is the order that is passed by this
petition itself ought to have gone.
It should have gone, but fortunately it survived.
You escaped that at that time.
Fortunately, it escaped probably for this reason. The Bangalore Development Authority is responsible for creating all the differences between the parties. On one hand, my lord, they say that there is no extent of land apart from 1069 square yards, for which a sale has already been executed. In this case, my lord, unfortunately, the BDA has not filed its statement of objections. If only the Bangalore Development Authority were to place on record, my lord, as to whether the 337 square yards is in existence for which a separate sale deed has been executed, my lord, then the entire controversy can be settled.
Where is this land? Is it part of a layout? Sadashinagar. Akdal.
Just may I request my lord to kindly have a look at
Lordship.
Note from Munbur and
Your Lordship,
that can almost be done over a cup of.
Your Lordship, I appear for Mr. Chirati, Your Lordship. We will, like he said, we will file our objections, Your Lordship.
And will you?
Your Lordship, you all might have it in a week or so, Your Lordship. We'll.
Week or two?
Because senior was supposed to be here, Your Lordship. He couldn't be here at this moment. That is right.
Otherwise, he is going to take us for a tour of Bangalore. That is why. Yes, Mr.
This entirely is an abuse of the process of law. There was a suit filed in which an issue was specifically framed as to the existence of these two plots of land. Evidence was led, and that resulted in a judgment holding that two plots of land exist. It became final. It was a judgment which came in 2015. Thereafter, this writ was filed in 2016 to overcome that judgment of a civil court to reach finality.
That is attained finality.
That is attained finality.
No appeal.
No appeal.
Petitioner and respondent number 3 to 5 are parties.
Privy to that. And therefore, complete abuse of the process of law. So you would, normally you take off with the writ and land up in a civil suit.
Where's the judgment?
My lord, it was produced before this court and it has been extensively referred to in the interim order of vacating.
Let's see the judgment.
Kindly see the application for vacating.
Where is number?
1566 of 2007. Page number 8 of my application for vacating the interim order. It was filed on 23rd July 2016.
Yes.
Kindly see page
1566.
1566 of 2007. In this judgment,
This is funded, Shamala recovery, patent funded. This was your family dispute.
yes, and specifically a document, a release deed in which both plots of land were shown was challenged.
There is a finding that both the properties are.
Yes.
Lord will get the issues at after paragraph 6 issues.
Number.
That's 2.1.
Yes, we got it. No, page number
After paragraph 6. These are the issues. There is no issue as to whether they are different properties or the same property. The suit was filed for cancellation of a release deed. And the only question that could have arose in that suit was as to whether the release deed is valid or not.
The release was for what property?
Kindly see page number 49, page 23, internal page 23.
23.
Yeah.
Of the judgment.
Yeah.
Yes. What do you want us to see?
Kindly see paragraph. I'm sorry, kindly see paragraph 33 at page 31. 33, page 31.
Yes.
Kindly see page 33, para 36, I'm sorry. Para 36 specifically.
Decide which para, Mr.
Paragraph 36 at page 35.
Para 36.
It is further argued there is no Schedule B property as shown on the release deed, and it is a fictitious one. In this context, he also drew my attention to the cross-examination of DW1. Regarding this aspect, I do find that there is some amount of cross-examination of DW1 on this point, and the replies are not convincing. But at the same time, it should be borne in mind that the existence of B schedule property is admitted by PW1 himself, and the inconsistent suggestions of plaintiffs during the cross-examination of DW1 prove the existence of the said property. It may be noted that in his further cross-examination recorded on 12th February 2015, the PW1 admitted the entire sketch annexed to the release deed and also the boundaries mentioned therein. He also admitted the existence of B schedule property to the north of the C schedule property released under the said
PW1.
B and C.
Who is PW?
PW1 is
Pandit.
his vendor.
This is Pandit.
SS Pandit is his vendor. He claims under SS Pandit.
He is your brother, your uncle.
He's my uncle. He admits to the existence of both plots.
You have case Pandit's children. You have different number 2 children. Different number 2A and B. Number 36 will go against you.
Just please also have a look at the internal page 39, my lord. That's the same. It was Shamla Pandit, my lord, who is the other sister. She was not a party to the release deed. Please have a paragraph 39, last sentence, last paragraph sentence, my lord. As conceded by the contesting defendants themselves, the plaintiff's number 2 is not a party to the release deed, and her right in the C schedule property will not be affected in any manner. However, she cannot contend that the said release deed is not binding on her, and even she cannot seek for cancellation of it when she is not a party to it. So one thing is clear, that her right in the C schedule property remains unaffected in spite of the release that she is seeking along with PW1 cannot be granted for the reasons aforesaid mentioned. But what was in dispute in the suit was the execution of a release deed, of which the Shamala Venkatadri was never a party. She is also one of my vendors, because what happened was the marginal land that was allotted to T.S. Pandit and S.S. Pandit, ultimately a partnership firm came to be formed, and this property was contributed as to the partnership firm. Now the only question is this, please have a look at my writ petition, what the BDA has given an endorsement, because ultimately, please have a look at annexure L, M, and N. That is why, my lord, I submitted that if only the BDA were to file its response, then, my lord, the entire controversy between the parties can almost be set to rest.
Mr. You are asking for quashing of the sale deed.
Yes.
Kata and plan.
Plan.
Can we quash a sales deed?
My lord,
virtually it's a declaratory relief that we are seeking for and cancellation of the document.
My lord, but there has been instances where this honorable court has set aside that and quashed.
That would be in the event of where the exercise of power by a statutory authority is improperly done, or where writ remedies are available.
Here, my lord, after giving a categorical finding that there is no such property that is in existence, my lord, what property has been allotted to me, the same property has been allotted in favor of them. Now, my lord, the problem is multiple. They are also claiming right with respect to the very same property. I am also claiming right with respect to the same property. May I request, my lord, to kindly direct the BDA to file its response, my lord. Once that response is placed on record, my lord,
this will have to go through a suit.
He is already filed a suit.
In the suit as regard release, if you say it is only releasing, now you file a declaratory suit. You haven't filed it, so you file
suit for declaration is pending, which I have also.
You have filed it.
He's filed it. He is not said that so far.
No, it is part of the record.
Where is
It is part of the record.
We don't know what is part of the record until you tell us.
No, my letter says
So
that I
please
have
tell
not
us, what is the suit that you filed?
It is a suit for declaration, my lord.
And what happened to that?
It is still pending. Page 398, my lord. Page 398, OS 691 of 2012. Page 408, my lord, will get the prayer, my lord.
Three 369 yards is what you said.
Yeah,
How many yards is that? Can you leave?
Lord, what has happened is, my lord, during the sale deed is dated 28/12/2012, annexure A.
You ask for cancellation of sale deed debt. When you ask for declaration, whether it includes cancellation or not, is subject to interpretation.
And that suit is.
Give this pair in this matter.
Honestly, my lord, the same order can be passed on once the EDA.
No, we can't decide these facts.
I am not asking my lord to decide these facts, my lord. That is why, my lord, I read the order where the interim
Even
order
if
was.
BDA were to say something, all of you are entitled to cross-examine, all those things are.
All that I'm saying is the same order. If the same order be passed after the BDA were to file its response, my lord. The only reason is this, that the parties, my lord, will at least know where they stand.
The petitioner is. The petitioner is for this court following. This court by reasoned order dated.
The order is dated 4th July 2017.
4 July 2017. Was of the opinion that the interim order cannot be granted when the final relief itself cannot be granted even after a full-fledged hearing of the case. When we all said reasoning at that point of time, the writ petition itself could have been dismissed. The relief which have been sought for in the present petition by the petitioner are more in the nature of cancellation of sale deed on account of private dispute between the petitioner and respondent number 3 on one hand and respondent number 3 and 4 on the other hand. Merely because of the statutory authority who is a party to that transaction would not make available the writ remedies to the petitioner. The petitioner has also filed a suit in OS number 691 of 2012 against respondent number
3 to 5.
Seeking for relief of declaration of title. Needless to say that such declaration would probably encompass the relief of cancellation of the sale deed set to have been executed by the BDA in favor of respondent number 2 and 3. If it does not, the petitioner could always seek for amendment of the said claim, seeking for cancellation
Law permits.
of the said document, which shall be considered by the said court in accordance with law.
Having due regard to the petition. that is
Having due
pending.
regard to the pendency of the present writ petition. Correct. And also providing the benefit of section 14 of the limitation. It may be in the wrong forum, but they have been prosecuting
No,
this.
no, the sale deed is in 2012.
To the extent,
The writ petition is in 2016. After suffering, they could
so
have.
7 years will go. Let the court decide the balance.
No, no, may I make a submission, my lord? There is a stay on ground of res judicata of the second suit by an order of the coordinate bench of this court. His suit has been stayed because of the judgment in the first suit. On the ground of constructive res judicata, his second suit has been stayed. So, that should not be prejudiced. Anything which my lord says here, kindly ensure that my remedies there are not affected.
The rights of both the parties are.
This court has not expressed any opinion on the merits of the matter. And the trial court will be free to decide the matter on merits.
Seek for short accommodation. Sinner is held up in another court. Preparing for respondent number 5, my lord.
The request of counsel for the petitioner reached on 17th April.
Yes, Ramamurthy.
Petitioner in this procedure.
Pavan,
This is an appeal filed before the
yes.
the respondent. Respondent to has issued the notice 321(1) and 2 of the Claims Act on the
under the delegations of the section 7 of the KMC Act by the Commissioner, respondent to one, my lord. Where the annexed C may kindly be seen, my lord. Next C, Commissioner Circular. ಮಹಾನಗರ ಪಾಲಿಕೆಯ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಮಂಜೂರಾದ ನಕ್ಷೆಗೆ ವ್ಯತಿರಿಕ್ತವಾಗಿ ಹಾಗೂ ಅನಧಿಕೃತವಾಗಿ ನಿರ್ಮಿಸುತ್ತಿರುವ ಕಟ್ಟಡವನ್ನು ತಡೆಗಟ್ಟುವ ಬಗ್ಗೆ ಸಂಖ್ಯೆ ಅಕ್ರಮ ಸಕ್ರಮ ಯೋಜನೆಯಲ್ಲಿ ದಿನಾಂಕ 3/12/2009 ಅವರಿಗೆ ಬಂದಂತಹ ಕಟ್ಟಡಗಳನ್ನು ಮಾತ್ರ ಪರಿಗಣಿಸಬೇಕಾಗಿರುವುದರಿಂದ ಮೇಲನಿಗದಿಪಡಿಸಿದ ದಿನಾಂಕದ ನಂತರ ನಕ್ಷೆಗೆ ವ್ಯತಿರಿಕ್ತವಾದ ಹಾಗೂ ಅನಧಿಕೃತವಾಗಿ ನಿರ್ಮಿಸಲಾಗುವ ಕಟ್ಟಡಗಳಲ್ಲಿ ಕೂಡಲೇ ನಿಲ್ಲಿಸುವುದು ಮತ್ತು ಅಂತಹ ನಿರ್ಮಾಣವನ್ನು ಕೆಡವಿ ಹಾಕುವುದು. That is the circular mela. Where I have constructed building 2004 made. 2004 comes under the Akrama Sakrama scheme. This circular will apply.
What has happened to Akrama Sakrama scheme?
That is for regularization of the unauthorized building.
What happened to that?
That is pending it is Supreme. It is pending still.
Been quashed and now pending. It is no longer.
And I am the benefiting under that scheme.
What is this one on the Akrama Sakrama now?
Stay, no stay, but it is pending before Supreme Court. So immediately the plan was for ground floor and first floor. They have constructed second floor and third floor also. The 2 floors they have constructed illegally. If the scheme, even if it comes.
Now even comes now is ground plus 3 is entitled for us for the 2015 plan.
Doesn't even.
Will regularize.
What is the status of Akrama Sakrama?
Pending malfunction before Supreme Court.
So, e matters in the end, madam.
Normally are getting adjourned to wait till the decision of
Supreme Court.
This is one more bunch that we'll have to do.
Few matters which are like that.
Counsel for the petition submits that the applicability or the virus of the Akrama and Sakrama scheme, and when challenged, the same is now pending before the Honorable Apex Court. Hence, awaiting other said matter. We list on 19th June. Interim order idea? Interim order earlier granted, extend to next day. Connect the above matter with so and so. And this put it.
I appear for petitioner, my lords.
Yes.
Annexure C is the impugned order, my lords.
You are referring to respond number 3, madam. About R1 and R2.
R1 and R2 executive officer of Taluk Panchayat and PDO of the Panchayat, my lords, sir.
Number 3, 10th interest. Number 3 or 1 and 2.
Who is the standing counsel for?
AK Vasant is been listed as AK Vasant. List it's AK Vasant.
AK Vasant. AK Vasant is now saying it doesn't appear in a lot of matters.
The list that has been provided to us says that AK Vasant.
And our Baradu is lively. He's not come to this court at all. Unless we do something else, we can't get.
Not seen him. That's the reason.
They don't want to appear. Really?
Sharanjit Shetty appears, my lords.
Sharanjit Shetty.
Sharanjit Shetty appears in all the matters, my lords. In my previous matters, he appeared.
ಅಲ್ಲಿಂದ ಕೇಳಿದ ಪುತ್ತೂರು ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೆ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಪುತ್ತೂರು
ದಕ್ಷಿಣ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್
and you are also standing counsel for Uppinangadi.
Taluk Panchayat Puttur.
2 I'll take
1 and 2.
2 I'll take instruction. 1 I'll take for you. So this village panchayat.
Whereas you are DK now. All DK will come to you. ಇನ್ನೂ ಒಂದಿದೆ ಮುಂಚೆ ಅದನ್ನು ನಿಮ್ದು. Sharanjit Shetty accepts notice for respondent number 1 and 2. Counsel for the petitioner serve a copy of the petition along with annexes on the said counsel. Relist on 17th April.
Please.
ಅದು ಅಪ್ಡೇಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. Sunil Kumar.
My lord, I am appearing for the petitioner. Lord, I request for a week's time, my lord.
There is already a preemptive order in this matter. You have not been appearing.
My lord, I have shifted my practice to Dharwad bench, my lord, for that. Yes, reason, my lord.
So you will continue to appear in this matter or what?
Please, I will continue to appear this matter.
The Bangalore list to note.
Please, my lord, please.
Counsel for the petitioner submit that he has shifted his practice to Dharwad bench and seeks for 10 days time to get ready and address arguments in the matter. Relist on 11th April.
Much obliged.
Lord, 59, I am appearing for the petitioner, my lord.
Yes.
I am for the petitioner. Lord, in this case, my lord, annexure A is the impugned order.
Ready, ma?
This
I am
statement of objections are ready, my lords. It needs to file the application. Weeks time will be granted, so I'll file last time.
AGA submit that the statement of objections are ready. Given 3 days time, it will be filed. Nimdu?
ಆಗಿಲ್ಲ ಪಾಯಿಂಟ್.
ನೀವು ಯಾರಿಗೆ?
R1 and R4.
Panchayat.
Submission made by counsel for respondent number 1 and 4. Objections, if any, by 6th April is made clear that if objection is not filed by that date, it will be taken as not filed. Relist on 17th April.
I am for the response number 3, my lords.
Your password adre reach agallama. 60. At the request of counsel for the petitioner, relist on 13th. 13ನೇ ತಾರೀಕು.
BBMP may be directed to file their objections, my lord.
I will file.
Co-respondent is asking for direction.
OS suit was pending, that was disposed of.
Yes, will you file your objections?
I will.
Pawan Kumar seeks for
2 weeks.
2 weeks time to file his objection. Objection will be by 6th.
Much obliged.
Baregoda. On the place for the petitioner, relist on. You will not file your wakalatos.
Copies not, sir, my lord. Last time notice was issued to me, I was not present in the court.
In the place for the petitioner, counsel for respond 1 and 2 submit that copies have not been served. If none were to appear for the petitioner on next day, dismissal will list on 10th.
So, this is a matter concerning the PDO and the Lord's MESCOM. Issue is Lord's that I am now Lord's retired Air Force officer, and I am now making this land available if they want. My age is pretty advanced. Therefore, I'm making this land available if they want for acquisition under the Land Acquisition Act. Therefore, my lords, this issue could be resolved because during my life,
already used your land.
No. There are some disputes. There are suits between us.
Between the local. Between whom are the suits?
Now, I filed suits against the MESCOM and the PDO. And therefore, some issues are here also. The PDO appears to have approached this court, my lord, and by WP number 7134.
The MESCOM is not even a party in this. We have State of Karnataka, Zilla Panchayat, Puttur, CEO, Panchayat Development.
That's another case. But concerning the same bit of land.
63783.
That's right. 63783, that relates to the PDO and.
Correct.
So, but what I'm saying is not that there are various governmental agencies who are not keen on, getting a piece of the pie. Therefore, the only point is that being of advanced stage, I'm now ready to give this land for acquisition.
Mr. Shetty, Charanjit Shetty. Now that we have your name, DK is going to be represented. Mr. Charanjit Shetty is directed to accept notice for respond number 2, 4, 5, 2, 4 and 5. Registry is direct delete the name of Sri Abhinav R and AK Vasant respectively. And AG 1, 3 and 6. They heard the proposal of Mr. Kadapa that he is ready to give you the land for acquisition.
You're ready to give the land for acquisition. You can take
This
it.
is for the petitioner to furnish a copy of the petition along with the annexes on Mr. Shetty, who seeks for and is granted 2 weeks time to obtain instructions, make a submission, relist on 11th April. Sundagarappa.
The petitioner sought for direction to direct the respondent to allot remaining site, my lord. Measuring 13 to 35, my lord. The draft is this, my lord. The petitioner is the absolute owner of the land measuring 100 into 100. Situated in survey number 21 of
Council petitioner is present and ready to address his arguments. None appears for the contesting respond number 4. None appears for respond number 4. If none were to appear for respond number 4 on the next date of hearing, the matter would be taken up for consideration on the basis of submissions made by the council for the petitioner. Relist on 11/4. IA1 of 20 hearing is allowed.
Pertains to ground rent prior to amendment. Has to be disposed in terms of these problems.
Only ground rent.
Ground rent.
Only ground rent.
Only ground.
Petitioner is before this court seeking for the following reliefs. The coordinate bench of this court has considered similar matter and disposed the same in terms of
460, petition number 4601 by 2020.
In terms of decision reported in ILR 2021 Karnataka 3968. We thereby pass the following order. Petition is allowed. 4094 to 4096. Same.
But sir, I've got the prayer of refund of the ground rent which I had paid at the time of seeking sanction plan and factual occupancy certificate as prayer number C of page.
That been covered in that?
This honorable court has said separate representation is to be made. Liberty may be granted to me to.
Yes. Para H of that judgment is clear.
And not to agree.
Same, identical. We are not changing anything.
Case of respond number 5, madam. Respond number 4, madam.
Ashok Patil.
May I please, Lordships?
Yes, Mr. Patil.
Lords, may I request for a short accommodation, Lord, because it's a long matter. I was slightly unwell, Lords, I couldn't come over. Because
Same thing. Modification.
You asked for modification.
Lords, that's a modification of the order.
It will have to go back before the same bench, Mr. Patil.
I understand.
IA 4 of 2022 has been filed. This is a modification of the order dated 9/6/2022 passed by bench. Registry is directed to place the above matter before the said bench
Please.
So obtaining necessary orders from the Honorable Chief Justice.
Great.
Number 67.
I'm appealing for the petitioner, Your Honor.
Yes. Prashant Chandra.
Appeal for the respondent, my lord. Respondent 2 and 3, my lord. On behalf of Prashant Chandra, my lord.
Is ready?
For the petitioner.
Ready, na?
Yes, my lord.
It's ready.
The petitioner has purchased the site and he has applied for khata. But the PPMP has not issued the khata. Thereafter, the land has been acquired and they have constructed the road. The petitioner has does not get the compensation from the respondents here.
Acquired under law, or they've just formed the road.
They acquired the
Acquisition notification was issued.
no, yeah. For us, they have not issued anything. I have the EC in my name, everything is
Acquired and thing in it. Without acquiring, they formed the road.
acquire ಮಾಡಿದ್ದಾರೆ ಇದು ಮಾಡ್ಕೊಂಡು ರೋಡ್ ಮಾಡಿದ್ದಾರೆ.
Acquire ಮಾಡಬೇಕು ಅಂದ್ರೆ ನೋಟಿಫಿಕೇಶನ್ ಕೊಡಬೇಕು. ನೋಟಿಫಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದೆ. ಸೊ ನಿಮ್ಗೆಲ್ಲ ಅಲ್ಲಿ ಕಾಂಪನ್ಸೇಷನ್ ಅದ್ರಲ್ಲಿ ಆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂತ ಕ್ಲೇಮ್ ಮಾಡ್ಬೇಕು, ಇಲ್ಲಿ ಬರಲ್ಲ. Proceedings.
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ the petitioner after obtaining getting the sale deed in his name, he has applied for khata. The khata was not issued. When they go, the petitioner when he went for the BBMP and as per khata, ಅವರು ರಿಪ್ಲೈ ಏನಂದ್ರೆ ಅವ್ರ ಹತ್ರ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ. The BBMP office which was situated near FC Gordon, it was burnt. All the documents were burnt ಅಂತ ಹೇಳ್ತಾರೆ. ಇವ್ರಿಗೆ ಏನು ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು ಖಾತಾ ಮಾಡ್ಕೊಡೋದಕ್ಕೆ.
ನೀವೇ ಹೇಳ್ತಾ ಇರೋದು ಆ ಲ್ಯಾಂಡ್ ಮೇಲೆ ರೋಡ್ ಫಾರ್ಮ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ
ಆಲ್ರೆಡಿ ರೋಡ್
ಆಗಿದೆ. ನೀವೇ ಅಕ್ವಿಸಿಷನ್ ಆಗಿದೆ ಅಂತಾನು ಹೇಳ್ತೀರಾ. ಕಾಂಪನ್ಸೇಷನ್ ಇದ್ರಲ್ಲಿ ಬರಲ್ಲ, ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. LAC ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗ್ತದೆ.
ಅಕ್ವಿಸಿಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇಲ್ಲಿ ಏನು ಹಾಕಿಲ್ಲ ಸರ್, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನು ಹಾಕಿಲ್ಲ ಇದರಲ್ಲಿ.
We'll reserve the right to them. Let them file those proceedings.
Yes, yes.
Before the for the following rules. The grievance of the petition is that that the khata of the property.
But there is no representation given for transfer of khata also. Proper representation they have not given. Only one acknowledgement is given, my lord. Annexure A.
Sir, he has given requisition for ಈ ತರ ನೀವು ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡು ನಮ್ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಮನೆಯ ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನಾಧಿಕಾರಿಗಳಿಗೂ ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. Annexure E.
Annexure E is different and Annexure A
ಕಮಿಷನರ್ಗೂ ಕೊಟ್ಟಿದ್ದಾರೆ. Annexure F ಅಲ್ಲಿ
an application had been submitted for transfer of khata in the name of the petitioner. The same has been rejected while Annexure E contending that the said land has been acquired. Counsel for the petitioner confirms that the said land has indeed been acquired and road has been formed. If that be so, the petitioner cannot seek for transfer of khata or issuance of a khata certificate in the name of the petitioner post the purchase of the property by the petitioner. The reserving liberty to the petitioner to seek for compensation by instituting appropriate legal proceedings available under law. The petition stands disposed.
Much obliged.
I appear for the petitioner in these three cases, my lord. The matter is, according to me, fully covered by several judgments of this honorable court.
But we'll have to issue notice to respond number 1. Pavan Kumar. Where is Mr. Pavan Kumar? Pavan Kumar is directed to accept notice for respond number 1. Registry R1. Muda. Mr. TP Vivekananda. TP Vivekananda is directed to accept notice for respond number 1. Registry is directed to print his name as such and delete the name of Shri V. Srinidhi as that appearing for respond number 1. Counsel for the petitioner serve one more set of petition along with annexures on Mr. TP Vivekananda.
Please, one submission, man. One submission. ಈ ಎರಡು ಮ್ಯಾಟರ್ ದಲ್ಲಿ ಉಳಿದೆರಡು ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ. ಇನ್ಫ್ಯಾಕ್ಟ್ ದ ಅಪ್ರಿಹೆನ್ಷನ್ ಇಸ್ ಇನ್ ದ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡಬಹುದು ಅಂತ ಹೇಳಿ ದೇರ್ ವಾಸ್ ನೋ ಎಂಟ್ರಿ ಮಾಡೋ ಗ್ರಾಂಟೆಡ್ ಬೈ ದ
ಎಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀವಿ. ಒಂದ್ ಕಾಪಿ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ. You will get his instructions. We are having it in 10 days time from now. We'll dispose it.
Please, much obliged.
Released on 13th, interim order earlier granted is extended.
Please, much obliged.
Mamta Kulkarni.
It's on a very narrow complex.
Morning they had asked for adjournment. They had not informed you, we did not give it. At the request of counsel for the petitioner, released on 10th. The Santosh. MK Santosh. The contesting respondent. So counsel for the petitioner and respondent number 1 and 2 are present and ready to address arguments. None appears for respondent number 3. None were to appear for respondent number 3 on next date of hearing. Taken up consequence. Released on 17th.
Bit earlier in the
Released on 3rd. Third.
Okay. The matter where private dispute as regards a road in a village, not the Panchayat Development Officer has acted in excess of jurisdiction. And therefore, my lord, on 17/12/2021, my lord, this honorable court passed an order directing the learned AGA to seek instructions from the government, my lord, for respondent number 1. So how a Panchayat Development Officer could exercise a jurisdiction over a private dispute. My lord, in response to that, my lord, the learned AGA, my lord, on the last date of hearing has filed a memo.
Yes.
My lord, he has filed a memo, my lord, along with a letter written by the concerned Panchayat Development Officer to learned Advocate General, my lord, justifying his action. That may not be compliance of the order dated 17/12/2020.
I appear for Panchayat.
Under what powers do you?
We have not exercised the jurisdiction of my lord's municipal court. That is taken by us. Let them counter my lords by filing the rejoinder at least to our statement of objection. We have pointed out what circumstances we have acted upon, and my lords, this is a Panchayat road. And my lords, I have produced the sketch also to show that this is a Panchayat road. And he has obstructed the Panchayat road, which was formed, my lords, way back in the year. But 2015 or 16. Produced annexure R1 and R2, my lords, to show that even sketch and also the Google map showing the existence of this as public road. Panchayat road. Police complaint was given by the private respondent to the my lords, jurisdictional police. And jurisdictional police have instructed us to my lords, see to it and my lords take suitable action.
Could you repeat that?
Please.
Police complaint was given.
They have filed a police complaint alleging my lord's obstruction to the.
Who has given the police complaint?
By the private respondent.
Yes.
Police in turn, my lords, directed us to look into the matter.
Yes.
And since it is a Panchayat road, they asked us to, my lords, to take suitable action.
So you did not take action on your own.
Lords, subsequently, pursuant to that, my lords, they made one more representation to us. On that basis, we have taken.
What is the document to show that it's a Panchayat road?
Lords, kindly turn to page 23, my lords. 23.
Yes.
May I read? Not the petition, my statement.
Objection. Statement over.
Yes. R11.
Yes.
For that, my lords, may I request my lords to turn to
Show us first that this is a panchayat road. It will come to all your resolutions.
Please. Page 10, annexure R1, sketch. ಕೂರ್ನಾಡು ನ್ಯಾಯ ಸಮಿತಿ ತೀರ್ಮಾನದಂತೆ ಸಾರ್ವಜನಿಕ ರಸ್ತೆಗೆ ರಸ್ತೆ ಬಿಟ್ಟುಕೊಟ್ಟವರ ಕಣ್ಣಂದಾಜು ಕಡತ ಸಂಖ್ಯೆ ಸೊ ಲೆಫ್ಟ್ ಸೈಡ್ ಶರಮನ್ ಕಣ್ಣು ನೋಟ ನಕ್ಷೆ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಪಜೀರು ಮತ್ತು ಕೂರ್ನಾಡು ಪತ್ರದಲ್ಲಿ ಕೋರಿಕೆಯಂತೆ ಈ ದಾರಿಯನ್ನು ತಯಾರಿಸಿದೆ.
ಯಾವಾಗ ತಯಾರಿಸಿದ್ದು?
This was my lord's date
2021-22 is what is Karata Sankhe. 21-20
days number.
So it is a recently relinquished land.
Yes, they have
relinquishment document.
Relinquishment document I have not placed for this court.
You have to place that.
But I'll ascertain my lords whether
it's not a public road. This is something that you are now forming or kind of formed. Road antu illa alli.
Illa road antile.
Photographs don't depict any road. It depicts a compound wall with a gate.
Compound wall, that is what may request my lords to turn to the photographs.
Claiming that it has been released.
We have produced one photographs, my lords, sir. Kindly see my lords, page 20. In page 20. This gate was installed. We have asked them to remove this.
Asked them to they've removed is my allegation in the writ petition.
Now kindly see my lords.
High-handed manner. Action was challenged in this writ. That is the action which is challenged.
This gate is there, but where is the relinquishment?
I will my lords ascertain and make this.
First you establish that it's a road.
Yes, yes.
And you have the right. If it's a road, then you are out.
That is under section 58 and 63, I have powers anta justify ಮಾಡ್ಕೊತಾರೆ. Video. 58 and 63 is the power granted to Gram Panchayat. And my lord, my limited research, my lord, the Panchayat Development Officer is only a liaison officer between the government and the concerned Panchayat. And ultimately, he can implement the decisions taken by the Gram Panchayat. That is the.
But is this, have you relinquished this land?
I have not relinquished.
Shri S. Rajshekar, Learned Counsel, appearing for respond number 2, submit that the land in question is a public road.
Disputed properties.
The disputed ಹೆಂಗೆ our dispute to
ಅಲ್ಲ ಅವರವರ ಡಿಸ್ಪ್ಯೂಟ್ ಅಲ್ಲಿ ನಾವು
we are not concerned about them, we are concerned about.
ಇಲ್ಲ ನಾವೇನದು ಇದು ಮಾಡ್ಲಿ.
We can always tell them go to civil suit. If you are going to interfere, you have to establish. The land in question is a public road vested with the panchayat. And in this regard, he relies upon a sketch produced at annexure R1, which is stated to have been prepared in the year 2021-22. A period of the said sketch indicates that the roads have been formed subsequent to the landowners having relinquished, gifted or given up their respective lands for the purpose of formation of the road. An inquiry, Shri Rajshekar seeks for and is granted a week's time to produce a relinquishment deed, if any, executed in respect of the land in question by the petitioner or otherwise.
Relinquishment deed ante.
Relinquishment, gift deed, or any other document.
Any other document. Or they should not take up a content. Yes, last week,
the 71 date, when will you produce it? 71?
4th or 5th.
6th.
6th. Yes, last week, my lord, asked to ascertain whether he will appear for respondent number 3 to 8 or
4 to 8.
You should respond number 6, I'll take notice. Keep for 2 more weeks time for 4, 5, 7, 8. Because the reason is that the administrator in charge been put in by the government. I don't have proper instructions on 4, 5, 7 and 8. On
So you will appear for 3 and
6.
6. Ranju Shetty submits that you will be appearing for respondent number 6. Insofar respondent number 4, 5, 7 and 8. He seeks for 2 weeks time to ascertain if he could appear since they said
So the president
administrator who has been appointed.
Administrator appointed on behalf of the government. Elections have not happened yet.
Relist on 11th.
Milad, serial number 73, Milad, I am per petitioner, Milad.
Yes, Mr. Chokareddy.
Yes, Milad. Milad, Anakshariya, page number 8, Milad. The respondent number 2, Milad, has issued the notice.
Number 3, my lord.
Ready?
What short accommodation, my lord. I pay for short accommodation.
Anakshariya, Milad, page number 8. Further action not taken, Milad. Anakshariya, page number 8, Milad, issued the notice under BBMP Act 313. Thereafter, no action was taken, Milad.
Have you replied to the 313 notice? ಗೊತ್ತಿಲ್ವಾ ನಿಮ್ಗೆ? At the request of counsel for respondent number 3 to get ready and address arguments, relist on 3rd. It's made clear that no further adjournment to be granted. Entire.
We have applied for the Khata law.
Applied for?
J. Khata. So far, they have not appreciated our application or they have not granted the Khata status person.
You are appearing.
J is the application.
You are not there. Municipal Commissioner Unsur, who is the council?
Geeta Devi.
Geeta Devi. MP Geeta Devi is directed to accept notice for respondent counsel for the petitioner. Serve copy of the petition along with annexures thereof. Relist on 11th. In Mesrak Torside, you are not even a party.
Earlier on, only CMCS party, city municipality.
Now it's become city municipality.
CMC, you are appearing. Registry is directed to delete the name of the
short date motion. 11.
11th.
Paying to the petitioner.
But
Tenchana MR has entered appearance for respondent number 2. Delete the name of VS Satyanand as that appearing for respondent number 2. Ready?
that a fine publication, they've asked for compensation. If there's a EWSSP has done there's some drain works for that. Which has been opened, there she has suffered from mutation of the leg to file an objections for seeking for the compensation.
We start awarding compensation. All the necessary amount. Idral estidio ashte award ಮಾಡಿ. Since seeks for and is granted
2 weeks.
2 weeks time for file. Then relist on 13th.
Pertains to issuance of transfer of development rights certificate. I think not respond.
Who is appearing for R2 and R2? You appeared, madam, for R4.
I think for R4 BDL.
R1
Who is to transfer?
But certificate has to be issued by the BDM, not.
Yes.
The BBMP notes has not given the form 2 notes to the BDM. Not has been not to KB Monish. His name is shown there.
Shri KB Monish has entered up. Monish Kumar Antilva and Vandilva.
KB Monish.
Has entered appearance for 2 and 3. Delete Pawan Kumar as that appearing for respondent 2 and 3. You have not given certificate for them to issue. The grievance of the petitioner is that necessary form 2 has not been issued by the BBMP to the BDA to enable them to issue the TADR certificate.
As per the note sheets, even the form 2 is ready, kept ready. I don't know why it is not being used. I have obtained under ITA. Form 2 I have marked it as an annex.
Manish Kumar to make a submission on why form 2 has not been issued, or in the alternative to state when it will be issued. Relist on 3rd.
Been awarded with the contract of my lord.
List for number 2.
Display of my lord digital hoardings.
You will appear.
SH Prashant sir has filed apology.
SN Prashant Chandra is also not filed. You are also not filed.
Last time copy was to be served by.
This is advertisement, I know.
Originally, Sridhi sir was appearing in this case.
This is advertisement matter.
Please, advertisement.
All tomorrow.
It is, my lord, display of digital hoardings at various petrol pumps. This is, my lord, the project of central government.
Where appear at the advertisement are only appearing.
Earlier, Sridhi sir was appearing. After that, I took notice, but copy is also not served to me. In the meanwhile,
How was it put it? Last time, my lord.
Non poultry shopping. Coffee product. Coffee product.
That there is urgency out of 5 years.
Just tomorrow, we are having all these matters tomorrow.
Please.
Connect the above matter with so and so, relist tomorrow. Shri Pawan Kumar is directed to accept notice for respond number 2, delete the name of Shri SN Prashant Chandra. Is that appearing to respond number 2?
Of madam has needed time so has filed the OS number 25, E67. After that only this writ has been filed by the petitioner.
Of madam has.
I have all the document filed in the OS. I will get the certificate copy of those documents. To file my objection, kindly granted 2 weeks. They also given.
We won't consider. Original suit, there is no jurisdiction against BBMP. Everybody seems to be filing suits.
Those are at the time of running the job, they are
entertaining suits. We will issue necessary directions on that.
I have to file my objection 2 weeks time.
And counsel for respond number 461 is granted a week's time to file a statement of objection. Objections, if any, by 6, relist on 11.
11.
By 6, you have to file.
Okay.
11 will list.
Okay. Statement of objections are ready, my lord. I'll file it in the office.
None appears for the petitioner and counsel for respond 1 to 4. Submit a statement of objections be filed during the course of the day tomorrow. Relist on 11.
I am appeared for the petitioner. For the challenge the annexure
81.
He wants my property free without
Pallava has entered appeals for 2 and 3. Delete the name of Geeta Devi as that appeals for R2 and 3.
annexure A may kindly. Case of annexure issuing, they sought for issuance of license action plan. Okay, they have the corporation has sought to execute relinquishment deed free of cost. Property seek instruction. Formal.
What have you asked for relinquishment? How much have you asked?
Page 10.
Page 10.
ಪ್ರಸ್ತಾವನೆ ಅಗಲೀಕರಣಕ್ಕೆ 30 ಮೀಟರ್ಗಳಿಗೆ ವಿಸ್ತರಿಸುವ ಪ್ರಸ್ತಾವನೆ ಇರುವುದರಿಂದ ರಸ್ತೆ ಅಗಲೀಕರಣಕ್ಕೆ ಕಾಯ್ದಿರಿಸಬೇಕಾಗಿರುವ ಸೋ ಚದರ ಮೀಟರ್ಗಳ ವಿಸ್ತೀರ್ಣದ ಜಾಗವನ್ನು 107.11 ಸ್ಕ್ವೇರ್ ಮೀಟರ್ಸ್ ಜಾಗವನ್ನು ಮೈಸೂರು
ಇದೇನಿದು ಒಳ್ಳೆ ಲಾಟರಿ ಟಿಕೆಟ್ ಯಾರು ಅಪೋಸ್ ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಫ್ರೀ ಸಿಕ್ಬಿಡತ್ತೆ. Oppose ಮಾಡಿದ್ರೆ ದುಡ್ಡು ಕೊಡಬೇಕು ಅಂತಾನ? We'll see. How many orders have been passed? You still keep on asking for relinquishment fee. In some matters, you say take contempt proceedings.
Advise, kindly have this matter next week, my lord.
Pallava seeks bond is granted 1 week's time to obtain instruction, make his submission, released on 3rd. Mr. Prashant. Arjun Reddy. ಹಾಕಿದ್ದಾರೆ ಇವರು ಯಾವಾಗ It's not a public interest litigation, Mr. Prashant.
Lordship, I belong to this particular road and I understand, I respect a view of this code. But your Lordship, BBMP office, ನಮ್ಮ ವಾರ್ಡ್ ಆಫೀಸ್ ಅಂದ್ರೆ ನನ್ನ ಪ್ಯಾರಲಲ್ ರೋಡ್ ಅಲ್ಲಿ ಅದನ್ನ ಚೌಕಟ್ಟು ಇಟ್ಕೊಂಡಿದ್ದಾರೆ, ಅಲ್ಲಿಗೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ, ಫಸ್ಟ್ ಕ್ಲಾಸ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ ಸರ್. ಆಮೇಲೆ ಇಲ್ಲಿ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್, ಬಸವನಗುಡಿ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಹ್ಯಾಂಡ್ ರೈಲ್ಸ್ ಹಾಕಿದ್ದಾರೆ. ನಮ್ಮ ಅಮ್ಮ ಇಲ್ಲೇ ಬಿದ್ದಿದ್ರು ನಮ್ಮ ಅಮ್ಮ, ಅಲ್ಲಿ ಹ್ಯಾಂಡ್ ರೈಲ್ಸ್ ಇದ್ರೆ she wouldn't have fallen. Till date, now also your Lordship, now you can walk with her in this road now. Full encroach ಮಾಡಿದ್ದಾರೆ. ಇವಾಗ ರೋಡು ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ, ರೋಡು ಆಗೋಗಿದೆ, ರೋಡು ಇಂಟರ್ಸೆಕ್ಷನ್ ಎಲ್ಲ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. I every day stand at Enarpani bus stand and clear the traffic. From past 1 week, I'm doing that.
The old area with lot of traffic. What to do?
Yes, your Lordship, I understand. Now they've allowed everybody to build concrete structures to the maximum. Road width ಬಂದು fire department ಅವರೇ ಮಾಡಿದ್ದಾರೆ. It is just 4 meters. I can measure it in front of the code commissioner if he walks into my road. It is getting worse day by day, your Lordship. Yesterday also I made a complaint of traffic, BBMP, everybody get non ಕೊಟ್ಟಿದ್ದೀನಿ complaint.
Pawan, your colleague is not appearing. These are busy areas. It's better to have handrails. ಸ್ವಲ್ಪ ಏನಾದ್ರು ತಳ್ಳಿದ್ರೆ ರೋಡ್ ಮೇಲೆ ಬೀಳ್ತಾನೆ. Very dangerous situation.
Your Lordship, kindly move into Annexure B1, your Lordship. Electric poles. Our office ಮುಂದೆ ಎಲ್ಲ ಟ್ರಾನ್ಸ್ಫಾರ್ಮರ್ ತೆಗೆದಿದ್ದಾರೆ. I can show photos also.
That is another writ petition which is pending.
I understand, your Lordship, but our office ಮುಂದೆ ತೆಗೆದಿದ್ದಾರೆ. ನಮ್ಮ ರೋಡ್ ಅಲ್ಲಿ ಯಾಕೆ ಮಾಡಬಾರದು ಅಂತ ಕೇಳ್ತಾನೆ.
ಎಲ್ಲ ದೊಡ್ಡ ಪ್ರಶ್ನೆಗಳು ಕೇಳೋದು.
If for a short
Trails.
I will ask him to.
Pawan Kumar is directed to also obtain instruction taking submission as regards the providing of handrails in the roads in question, considering that there is a lot of movement on the footpath, which could result with where petitioner's mother had fallen down. There is also a danger of the person being pushed onto the road, having heavy traffic.
Even the cattle is left, your Lordship. Cattle is like.
Released on 3rd.
Appreciate your Lordship.
Yes, the
For petitioner, my lord.
They have not been served with the copies.
No, my lord, no will serve, and we have been filed in the counter.
Yes, and no will serve on that. Put it.
That's and also one thing will appear only for R1, my lords. You don't appear.
Who is R2?
Taluk Panchayat is R2.
Who is R?
We appear for city municipal council.
Who will appear for Taluk Panchayat? You will have to tell us that you want to escape.
Usually Mysore, Somaji will appear for the judge.
DJ Soumyaji, he appears for
Mysore.
Yaudu, what is the panchayat?
Nanjangud.
Nanjangud Taluk
Mr. Soumyaji. Soumyaji,
Yes.
Nanjangud Taluk Panchayat.
Yes, I can explain.
Shri Mahesh submit that he does not appear for respond number 2. Shri BJ Soumyaji is directed to accept notice for respond number 2. Registry is directed to print his name as such. Counsel for the petition serve a copy of the petition with annexures. Counsel. What about in 83.1? Same party, sir.
Office objection was there, my lord.
Who are the
They have
party?
been complied.
Shri Mahesh accept notice for respond number 1. Shri BJ Soumyaji accept notice for respond number 2. Counsel for the petition seeks for and is granted a week's time.
And interim order should be.
If you don't comply, you don't give process.
No, we have been complied, my lord, morning. Serious apologies to that, my lord.
Seeks for a week's time to comply with office objection. We list on 18th interim order is extended till next day. Sangamesh. None appears. List on 18th. Dismissal. 85.
But I run a flower shop, a very small shop, wherein Lord, my dwelling house is also.
Mallikarjun Reddy.
Only one issue, Lord, sir, as my lord. Only one issue, Lord, that I am not allowed to any function there. In fact, the interim order prevents me even to do, Lord, online taking orders or something. At least that may be. I am not causing any physical hardship to any of the residents.
You got the interim order for yourself.
That was passed, Lord, to hearing. At least, Lord, because lot of time has been taken. I have only 2 submissions to make. Lord. One is that there is no previous publication of the rules. These are only legal submissions. Annexure A.
When was the interim order granted?
Please, the interim order, Lord,
The property can be used for residential purpose only,
Hello.
no commercial activity.
Shiga, what I am saying is, Lord, if I have a residential property, I can at least have a computer, my lord, and book orders online. I'm not causing any physical obstruction. Their worry is, my lord, that I will be causing obstruction to the.
You are residing in this place.
Yes.
I can always have a computer. Computer
illa, if lordships may see, my lord, what is preventing
Commercial
me
activity in residential.
that is what lordships may see the last paragraph.
How is the time of work from home? Computer usage cannot be.
Petitioner shall not carry out any business or commercial activity.
Shall not get any products or anything, transportation, nothing should happen.
They should not also store the material in there.
No storage of material.
There is storage. I have not stored. All that I am asking is, Lord, at least I can take my laptop. You rain virtually, Lord.
Computer in the laptop.
ಇವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಬಂದು
So ಬರೀ ಒಂದು ಲ್ಯಾಪ್ಟಾಪ್ ಬಳಸ್ಕೊಂಡು ಹೋಗ್ಬೇಕು ಅಷ್ಟೇ ತಾನೇ ನೀವು ಬೇರೆ ಏನೂ ಮಾಡಲ್ಲ.
No, at least, Lord, I should be allowed to have system, the computer or laptop.
Laptop.
Where the billing, I am doing the business from elsewhere. Now, billing software is there in my access my software, whatever computer or laptop facilities.
You see, it will be as good as allowing commercial action.
If you want to have your computer, you want to basically run an office. What is the width of your road?
No, my house is, Lord, in second floor.
What is the width of your road?
Road, my lord, is 30. ASA, my lord, according to me, it is 40, little less than 40 feet. I have not measured it actually. According to them,
what is in the road map road pattern?
No, they have issued notice to me, my lord, saying that it is less than 40 feet, my lord. According to me, my lord, that is 40 feet. That is one issue. Secondly, my lord, the notification that against me.
If it is less than 40 feet, you can't do it.
Annexure
A is 40 feet, can have part of the property as your office.
Now, that is not measured, and that report is also not before your lordship. only one submission, one submission. Annexure A, page 26. My specific contention is not, this is my only contention. There are other contention, allied contentions may fall into oblivion. Annexure A, my lord, has not been subjected to previous publication, so it has no effect. Is what I am contending. That's all.
Will consider on merits.
That is all I am saying, Lord. For this, Lord, they are been dragging for January nalli. At least I will get clarity, Lord. If I am
Council for respondent seeks for and granted a week's time to make a submission as regards the width of the road in front of the property of the petitioner, as also to get ready and address his arguments. Relist on 3rd.
My livelihood is
Ella matters are there.
livelihood and wonder.
Ella matters are there.
And computers will at least clarify, but otherwise I'm
Not now, not now. First, let us see the rule.
Lord, 86, I appeal for the private respondents, Lord.
Yes.
for the petition respondent. The representations are not with respect to setback violation for neighboring site only. Even the constructed roads are not sanctioned as per the plan sanction. Lordship, the respondent number 3 and 4 are.
What have you done on all his representations?
Seek instructions not recently.
May I make submissions?
Yes.
Lordship, until then.
Pursuant to the Lord's representations, the municipal corporation has issued 321 notice to the respondents, Lords. We have furnished our reply as well. The matter, Lords, can be disposed of directing the corporation to take action in accordance with law by considering our representations, Lords. We have already.
321 or 248?
321 ಅಂತ ಹೇಳ್ತಾರೆ ನಾನು ಬೆಳಿಗ್ಗೆ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿದೆ ಅವರು ಕನ್ಸರ್ನ್
Mysore City Corporation. Mysore City Corporation 321. Bangalore 248.
Kindly see the photographs that we have annexed.
They've already issued 321 notice. They've replied to it. They'll consider and pass orders. That's how much they can do. Petitioner is before this court seeking for the following release. The grievance of the petitioner is that despite several representations submitted by the petitioners, more particular annexure H1, H2, H3, and H4, H1 to H6, the respondent number 1 and 2 have not taken any action. Respondent number 3 and 4, illegal constructions being carried out by them. Pallava Act Current Council appearing for respondent number 1 and 2 submit that notice has been issued under section 321. Shri Pavan Kumar, Vinayaka B appears for respondent number 3 and 4 submitted on receipt of the said notice. A reply has been issued, reply has been submitted. In view of the said submissions made, notice having been already issued, no further directions need to be issued by this court, except to approve that the respondent number 1 and 2 shall consider the reply submitted by respondent number 3 and 4 and pass necessary orders within a period of
8 weeks.
3 weeks.
8 weeks. Elections are on the economy, election duty other than that. Yes, Your Lordship, they've already finished the construction, Your Lordship.
They have issued the notice. This is not a civil suit. They have issued the notice. They have to consider it and pass orders.
Kindly fix a time period for disposal.
That's what we are doing. Within a period of 6 weeks from receipt of copy of this.
Please.
Much obliged, Your Lordship. Yes, we are in the order. Property is less than 50 square meters. No plan request to be secured from the respondent authority.
Because the common passage also in respect to that. Including the common passage, they have constructed the building system, ground plus 4 floors. Place it on record the document.
This is what you had asked for time. That Shri P. Chidananda has entered appearance for respondent number 1 and 2 delete the name of Pavan Kumar. Shri Chidananda seeks for and is granted a week's time.
Please.
To make his submissions. Relist on 3rd.
Already there.
More reading.
Yes. Each Mela. Third, I have the station. One more accommodation.
List on
11th.
11.
Complex.
Gole. So counsel for the petitioner is present.
Petitioner.
Petition. Counsel for the petitioner is present, ready to address his arguments. None appears for respondent number 2 to 4. If none were to appear, this matter will be taken up consideration on 13th April.
Challenge the contemplated action of the respondent to demolish the portion of the building of the petitioner exists on the scheduled property for extension of Mandya Hadagali Road without.
Where is Mr. Praveen Kumar? None appears. The petitioner is ready. None appears. Will be taken up consideration.
11th.
List on 11th. Interim order earlier granted is explained.
I appear for the petitioner in this case.
R4 yeah.
R4 malad is attached to the malad R3 on. Malad Vijay may be glad to accept notice.
Vijay accepts notice for respond number 4. Registry direct print is named as such. Yes, what is this? Ready, Vijay?
To release the amount malad which is due by the malad the third and fourth respond. That the
Main
petitioner.
prayer cannot be maintained, my lord, but the alternative prayer, my lord, a mandamus may be issued. Main prayer, my lord, is in the nature of a civil recovery. The alternative prayer for
is before this court seeking for the following relief. The grievance of the petitioner is that despite the respond number 3 and 4 having acknowledged the bills submitted by the petitioner and a legal notice having been issued by the petitioner to respond number 3 and 4 on 1/10/2022, the amounts due have not been released, nor any endorsement issued, nor a reply issued to a legal notice. In that view of the matter, I pass the following order. The mandamus is issued directing third respondent to consider the representation wide legal notice dated 1/10/2022 at Annex H within a period of 6 weeks from the date of receipt.
Please.
Tahir? And appears for the petitioner released on 17th.
Has challenged the document of civic community site rules. Because
We're having the rules.
why is the rules?
We'll have to file objection.
I only request my lords is page number 53, my lords, newspaper.
Number?
53, I put a newspaper clipping. There is the call for application for allotment of civic community site. Newspaper clipping, paper publication.
Merely because you challenge it, it will be subject.
I only.
It will be subject.
Allotment, consideration of interim prayer may be compared.
How can you challenge civic?
Prior to the rules, sites were relinquished. In 2005, the rules were brought in, they are retrospectively allotting sites were relinquished in 2005.
Whenever it has been relinquished, it's still with them. They'll allot it for a civic community is to be there. If not allotted to whom, what will you do? They'll retain it with themselves.
Intention was for public purpose, my lord. Health institution is concerned. Intention is, my lord, it's for the purpose of association to whom it was made for.
It is relinquished to them. They are in possession. Now, Mr. Yogesh Naik will come and put up office of which authority is this? Anekal Planning Authority's building will be there.
We request consideration.
Shri Yogesh Naik seeks for and is granted 2 weeks time. Learned AG and Shri Yogesh Naik seek for 2 weeks time. Objections, if any, by 13, relist on 20th. Shetty.
Lords, I beg to appear for the petitioner, my lords. The matter relates to, my lords, the demand for relinquishment for free. In fact, the matter is covered, my lords. My colleague is there in the court hall. Of course, I urged on grounds, my lord.
My learned friend has served the copy on me, my lords. I've informed the same to the concerned party, my lords. I pray for 10 days time, my lords, and secure instructions and call. I haven't, I'm yet to file my wakalat also.
May I make one request?
Yes.
Lords, the development of a petrol station has been put on hold. I have already made an undertaking, my lord, that I'll not develop the portion.
You're appearing for whom, madam? You're appearing for Mr. Devraj. Why haven't you filed your wakalat? Mr. Ajay, you also not filed wakalat.
First copy was served only just last week, my lords. I have sought for instructions within a week's time and 10 days. I'll file wakalat as well as the
served last week, Mr. Ajay.
I'll do the needful.
Ajay Kumar and Shri H.V. Devraj seek for and are granted 2 days time to file their respective wakalatnama and objections. 5 weeks time from today, relist on 10th.
Please. I'm grateful. But they're relying on some judgment. If they can just give me the citation.
The name of H.V. Devraj to H.V. Devraj. MS Devraj.
But I'll share the ruling with my learned friend.
Please share.
Please. Great.
Number 2. Number 1.
Outstanding is 3 crore 63 lakhs. 3 crore 63 lakhs from the bank.
Gole. Election. None appears for the petitioner. None were to appear for the petitioner will be dismissed. Relist on 6.
Number 2.
Pertains to unauthorized construction, they have approached KAT. KAT has dismissed the appeal as a floor violation. They have constructed extra floor. It's an apartment building.
So this is the violator. KAT has dismissed it.
KAT.
None appears for the petitioner. None were to appear. Dismissal released on 3rd.
Number 3. Yogesh
Shri Pawan Kumar is directed to accept notice for respond number 1, 2, 3. Delete the name of Shri R. Ramchandran as that appearing for 1, 2, 3. None appears for the petitioner. None were to appear. Released on 11.
Pertains to advertisement, tomorrow.
Connect the above matter with soon. Respond number 8. Retirement filed by Abhishek for 1 to 8. Who is 1 to 8? You have appeared. Shri H. Devendra has entered appearance for respond number 1 to 8. Hence, memo of retirement filed by Shri Gurudeva Gachinmat is accepted. He is discharged from the matter. Registry direct delete his name. Connect the above matter with so and so and release tomorrow.
Serial number 8. Vijay Kumar.
Vijay Kumar. None appears, none to appear, released on 2.
Respondent number 4 has issued the notice, demolishing notice to the respondent number 5.
There Anup Kumar has filed. Who is
Notice.
DVR?
Respondent number 5 is.
Respondent number 5.
ಅದ್ರ ಮೇಲೆ KT appeal file ಮಾಡಿದ್ದೀವಿ. Appeal number 920 of 2017.
ಒಂದ್ ನಿಮಿಷ. ಯಾರು ಅನೂಪ್ ಕುಮಾರ್ ಹಾಕಿದಾರ ಎನ್.ಆರ್. ಜಗದೀಶ್ವರನ್? ಎನ್.ಆರ್. Jagdishwara has entered appeals for 1 to 4, Dilip R. Ramchandran and Anup Kumar has that appeal for 1 to 5. In submission in the
Respondent number 4 has issued the demolition notice to the respondent number 5. Respondent number 5 has filed the appeal before the KT. Said order is stayed in KT.
counsel for the
Appeal number 9 of 2017.
submit that the order of confirmatory
Above
under 321 has been stayed by the Karnataka Appellate Tribunal and the matter is still pending for the KAT. Hence released on 19th June. Matter is released on 13th. 16. So Venkatesh Somareddy Act sign ಮಾಡಿದಾರಾ? ಗೌರವ್ ಜಿಕೆ ಇಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ಅದನ್ನು ಚೇಂಜ್ ಮಾಡಿ. The counsel for the petitioner is now designated senior counsel. Hence, issue court notice to the petitioner returnable by 30th May. None appears. List on 19th April.
My lord, I am appearing for respondent number 4, my lord.
Respondent number 3, Commissioner CMC Chikmagalur. Also accept notice for respondent number 3.
I am for respondent 4.
None appears for the petitioner. List on 20th.
Oblige, my lord.
The prayer minutes that is sought in the petition minutes is for consideration of application minutes at annexure B. But what has happened is minutes, the petitioner minutes the unauthorized application of small piece of land measuring 10 by 11 feet minutes in survey number 72 minutes of Proceedings village. Minutes, if you lordship have to see annexure F minutes.
Where is your application for regularization?
Annexure B minutes. Page 80. I was in possession, not still, till as a state, not still till the filing of the petition, not I was in possession of the property. Minutes, your lordship can kindly see the photograph. Minutes, without due process of law, minutes have been created. The building which was there, minutes, the building constructed by me, minutes, is demolished. Page 54 minutes. Demolition could have. Now, without this, minutes, this demolition, minutes, is without any process of law. Minutes.
Now your reliefs are only as regards regularization. Consider the application. Now you are not even in possession.
The fact remains that minutes I was in possession of the land. Even assuming that, even according to minutes, I am an unauthorized occupation of the said site minutes. Minutes, if I were to be evicted minutes, the respondents minutes had to take recourse to law.
You are already evicted now.
So irrespective of that fact, minutes, the fact
you have to get back possession, you have to go to the civil court.
Minutes, apart from consideration of the representation minutes that I have made, seeking regularization, minutes, the fact that minutes have been dispossessed and the building minutes having been demolished, would not take away, my lords, my right for consideration of this particular application, my lords, which was prior to that particular date.
Consider it, but you know what order they'll pass.
No, that apart, my lords, some officer, my lords, who has done this, who has acted high-handedly, my lords, will not to be responsible, my lords.
Not
So that text,
not ask for any of those relief.
my lords, I'll make that amendment application, my lords, I'll seek for it.
Counsel for the petitioner seeks for and is granted 2 weeks' time to file amendment application. We list on 13th. What you have sought for can only be considered, not more.
Yes, yes, I understand. The-
23.
Appearing on behalf of petitioner, my lord.
Yes, madam.
My lord, kindly we are seeking for short accommodation, my lord.
Yeah, the request of counsel for the petition we list on 20th April.
Much obliged.
The TP Vekananda has entered appearance for R1, delete HC Shivramu, none appears for the petitioner. We list on 20th.
25.
None appears. Learned AGI accepts notice for respond number 1 and 2. Shri Robert T. accepts notice for respond number 3. Counsel for the petition serve a copy of the petition along with annexures on the said counsels. We list on 22nd May. Counsel for the petitioner has now been designated senior counsel. Issue notice to the petitioner returnable by 29/5.
Respond 4-5.
Udupi Panchayat. ನೀವು ಅಪೇರ್ ಆಗ್ತೀರಾ?
4-5.
ಅಶೋಕ್ ನಾಯಕ್ ಇಲ್ಲ ಇದೆ ಅಂತಾರೆ.
Four and five, Ashok Naik.
ಅವ್ರು ಬರ್ತಾನೆ ಇಲ್ವಲ್ಲ ನಿತ್ಯದಿಂದ?
ಇಲ್ಲ, ಅಶೋಕ್ ನಾಯ್ಕ್ ಅವ್ರ ಕೊಲೀಗ್ ಬರ್ತಾರೆ. She'll come.
ಒಂದ್ ಸ್ವಲ್ಪ ಕೇಳ್ಕೊಳ್ಳಿ ಏನು ಅಂತ.
ಇಲ್ಲ, she'll come. She'll appear.
Whoever we have directed to notice.
Except AK Vasanthi, everybody has appeared.
Ashok Naik, sir. AK Vasanthi. Ashok Naik is directed to accept notice for respond number 2 and 3. None appears for the petitioner. Released on 29th May.
30. David Ramon.
None appears. Released 29th May.
End of this.
What is the amount you
3 crore 63 lakhs.
just put there?
Officer, 4 weeks ಅಲ್ಲಿ 10%. 4 weeks ಅಲ್ಲಿ 10%. Already ನಾವೊಂದು check ಕೊಟ್ಟಿದ್ದೇವೆ ಸ್ವಾಮಿ. That was actually actual amount what is required for regularization of the loan.
10% ಎಲ್ಲ ಮಾತಾಡಬೇಡಿ. There's already an award which has been passed.
Please.
We told you reasonable amount. Reasonable amount can only be above 25%. In the first installment, second installment of 25%.
ನಮ್ದು ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಆಗಬೇಕು ಇಲ್ಲ ಅದು ಸ್ವಲ್ಪ ಹೆಚ್ಚಿನ the moment it gets cleared so ಅದಕ್ಕೋಸ್ಕರ 10%.
We can't do that. When AG accepts notice for respond number 2, issue notice to respond number 1 returnable by 22nd May.
Interim order. Any condition this court ready.
ಕೇಳ್ತಾ ಇದೀವಿ ಇಲ್ಲ ಅಂತ ಇದ್ದೀರಾ ನೀವು?
Any condition.
Any condition ಅಂದ್ರೆ ಪೇಮೆಂಟ್ ಮಾಡಬೇಕು. We can't impose a condition like that. If you don't pay, then
Please, I know the concept.
counsel for the petitioner submits that the total due amount is a sum of rupees 3
crore 63 lakhs 19,000.
3,000. She submits that given 4 weeks time, an amount equivalent to 25% thereof would be paid. And within 4 weeks thereafter, another 25% would be paid. 25% of the due amount will be paid. Taking note of the said submission. the first payment to be made by 3 weeks now, by 17th, and the second payment to be made by 29th May. If any of the above payments are not made, the interim order will stand automatically. The operation of the award, is there a sale notice issued?
Award,
Is there a sale auction notice issued?
not auction.
ಮತ್ತೆ ಇದನ್ನೆಲ್ಲ ಹೆಂಗ್ stay ಮಾಡ್ತಾರೆ? Only if auction notice is issued, then come.
Physical position ತಗೊಳ್ತೇನೆ ಅಂತ ನಾಳೆ ಬರ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ರು ಮನೆ.
Operation of the award dated 39/2023. As per second respondent is stayed. Consequently, the notice dated 7/2/23 at annexure B is also stayed. Process fee and copies to be furnished by end of day tomorrow. Failing with the interim order will stand automatically. Relist on 18th April. 17th or payment madilla, 18th bandre will vacate it. Office objection to be complied with by.
Sandhya. 1,54,82,000.
Same order.
Handling.
The respondent shall act on printout of the uploaded copy.
Please.
Respond number 4 ಇದೆ ಏಕೆ ವಸಂತ್ ಅವರು ಅಪೀರ್ ಆಗ್ತಾ ಇಲ್ಲ. Directed to
Shetty. Ranjit Shetty is directed to accept notice. Respond number 4.
Silent report, my lord.
Registry direct print his name as such and delete the name of Shri A.K. Vasant as that appearing to the funding. Without file much.
Next week.
And AGS seeks one is granted 10 days time to file the survey report, relist on 11th.
Kind permission. Some of the orders are not applicable because survey in this upload ಆಗ್ತಾ ಇದೆ. I could not communicate to the ADL. Yesterday, 25th was the matter. It will uploaded on after 6 o'clock. So, 2-3 matter lang ಆಗ್ತಾ ಇದೆ.
Every 2 days a lot pending it. Generally, they are getting uploaded in 2 days time.
Yesterday, 25th was the survey date. It was uploaded on 25th only. Saturday. Usually I check daily. Daily orders check because without that daily orders could not complete.
Get it check.
I'll just move this 2 matters tomorrow.
Aye.
The only dates coming we
Will 200 amount. Wow. You are touch. Which matter was today, madam? ಇದು ಅನ್ಕೊಂಡು all training matters ಅನ್ಕೊಂಡು ನಾಳೆ one with the paucity of time, the matter could not be taken up today. We list on 29th at 4 p.m. 29th on 4 p.m. Tomorrow we have got that other pattern. Which we must take it up. I thought the training matters was there today because that was one of the parted matters. So that was a big list. Everything is that. That's what we thought. Not serious.
Just have a little more of the history and then thereafter.
ನೀವು ರೆಡಿ ಆಗ್ಬೇಕು ಇನ್ನೇನು ಮುಗೀತಾ ಬಂತು. You have to fix the date for your argument.
Court officer, madam. Court officer, madam. Madam.
ಹೇಳಿ ಮೇಡಮ್.
Madam, second list serial number 14 ಏನಾಯ್ತು madam?
14 10th April next date.
Okay, madam. Thank you.